generally along the lines for the reasons they state in here. Anything you think needs to be heard on that, Mr. Beal?
No, Your Honor.
Okay.
But John, you need to keep your eyes out because we think it's out of there on.
It's out, Your Honor.
What's up?
Okay.
It's been removed.
What's the subject matter?
And then
And we have-
Those are the reasons that Sandmann, that McMurtry believed that Mr. Sandmann relieved you of representation in the case.
It's just testimony.
Also to describe as
It was
fired
just
me.
testimony.
I was being gentler. The next objection lodged was starting on page 105, just generally a kind of an extended discussion about what it took to get these emails from Mr. McMurtry. And I just wanted to inquire, is this in essence preserving an argument that you're almost impeaching Mr. McMurtry or kind of showing his involvement in this and that sort of thing?
And he sat on that stuff and shouldn't have.
All right.
Excuse me, Your Honor.
Yes, sir.
Are you going through plaintiff's objections and then our objections? Is that how it's going?
No, I'm really just doing yours because you haven't tried to play yours yet. So I'm trying to be as I don't think I need to worry about their objections because you're not publishing or
Oh, okay.
showing his deposition, the portions that you're trying to introduce yet. Right.
Right.
Okay. So, but as to the remainder of the objections, they're noted. I've looked at the lines. I don't believe it rises to the level of exclusion. Most of these are lodged on relevance or speculation grounds, and I think he's providing a basis for an opinion. It's a fact issue that goes to this general larger issue of fraud and or alleged fraud rather. And there's only one I wanted to hone in a little bit closer here. This is the very last objection on page 143. The opinion of whether McMurtry thought that the plaintiffs needed Mr. Sandmann's approval. What would you say to the relevance objection there on the part of the plaintiffs? This is
You said
on page 143 is the final objection lodged by the defense, where he kind of offers an opinion that he had thought the plaintiffs knew Mr. Sandmann's approval was needed for this fee split, and then later says that apparently he later learned he was mistaken. Defense has lodged a relevance objection.
Your Honor, I don't see I don't see the objection on 143. Am I missing something? Is it maybe 142 or something?
Page 5, I'm just looking at their defendant's objections. It's a separate filing.
Right.
And they object to 143 line 20 through 144.12, where Mr. McMurtry is testifying generally to his opinion of whether the plaintiffs knew Mr. Sandmann's approval was needed, I guess, the whole time and on relevance grounds.
It's not at that location, Your Honor, and we'll throw up on the screen what 143 has. So I don't want to unnecessarily complicate this, but here's what's going on 143.
just take it up there if they want.
Here, let me just let you look on our computer. I'm sorry. This is 143.
Well, I've got it here. That's fine. I've got
Okay.
it pulled up. I think I just looked at it a few minutes ago.
It says, no, the conservatorship hearing was postponed until after I spoke with the.
Go to the bottom of that page. I'm not seeing.
Yeah, it's more so the top of 144, I think, is the core of the objection. I thought at the time that since I thought it was understood that Nick Sandmann was going to have to approve this, I didn't realize that WGW had no idea that Alston Bird was going to ask that section. And then it keeps going a little bit more.
Oh, so
Yeah.
this is.
And claiming that you committed malpractice, that aspect of it.
Yeah.
So there's a relevance objection lodged to that.
But
Withdraw
that
it,
goes
Your
to the whole reason why you make them at the time, so that I can move it around. Since I don't have Mr. McMurtry, now
True.
kind of.
Your Honor, we'll withdraw
We'll
that.
That was
withdraw
not
that.
your
that
question.
objection.
Okay, they've withdrawn it. We'll move on.
We say that was Reyes's question.
They've withdrawn.
They've withdrawn it.
Yeah.
So,
That should have been our.
with that, just as a matter of housekeeping, look, I'm trying to make decisions in real time. I can tell if people are just finding it awkward, this whole last name thing. If the parties agree, we can just move on from that. And I'll just direct the parties, let's avoid nicknames or casual things like that. I think it just seems unnatural. So if you want to disregard the prior instruction that we should be more formal here, just that seems like it might be more trouble than it's worth, and people really are fine with that. Mr. Beal, any position there?
No, I think that's a good idea.
Okay, Mr. Wood, anything on behalf of the defense there? It seemed like it was more trouble than it's worth.
Silly.
All right, well,
Might call
I
the
can
judge.
I can see that now. All right, so disregard that. Other than that, is there any reason we can't bring in and resume playing the McMurtry deposition?
None for the plaintiff, Your Honor.
Okay.
So to clarify, everything's overruled except for the one we withdrew. Is that right?
No, not everything. I did have them remove the portion that I indicated on 403 grounds around page 83 to 84.
Yeah.
But the rest of them are preserved, noted, but I did overrule the remaining.
Your Honor, do you mind? if I
Objections.
pull Exhibit 159 out, because that's the one that has the Mike Pence stuff that you didn't want them to talk about. It's in their binder.
To 83.
I mean, if we don't talk about 159, they'll probably never
I don't care
skim
about
to it.
Let them talk about Mike Pence.
Okay, if you want to withdraw, well, they've already taken that
I
part
think I'm right
out.
About Mike Pence.
It's up to you. I mean, it was your objection, so I don't want to.
Let 'em hear
14.
it.
Okay.
Could we get
hold on.
some?
There's some confusion. I thought it was page 83, line 4 that got taken out of the deposition. And that's where the exhibit is introduced. I was mistaken. It's 83, line 14.
That's right.
So the exhibit does come in. I apologize for the confusion.
So we're good on the exhibit?
I believe so, Your Honor, yes.
Okay.
Because was not taken out based on what Your Honor struck.
Okay, so there's no issues with the exhibit.
I apologize for the confusion.
All right, at this point, though, you've already cut that portion out.
Correct.
And even though they're withdrawing the objection, I still think we can just keep it out and
It's
move
out
forward.
and we came early. The deposition is ready to go and it's downloaded on a thumb drive today,
Yeah.
so we will not have the internet problems we had yesterday.
That is wonderful to hear. Okay, from there, I think then that we should bring in the jury and get going. Yes, sir.
We get some, excuse me, I don't, could we get some idea of where we're heading today in terms of who's going to testify and when we expect?
As I understand, so we finished in with the McMurtry deposition. I think they had Mr. Sandmann's deposition and Mr. Grunberg's testimony. And then they said they had, were you still wanting to call Mr. Wood for
I don't think we're gonna need you now.
okay.
We've got it worked where we get all the evidence in that we don't need them. And then we may have 10 questions of the IT guy.
The IT guy, that's right.
That's it.
Okay, so there we are.
Yes.
So it's hard to really gauge where we are until we get through across of Mr. Grunberg and the kind of the time that's needed for that. And I think we take that up when we do kind of our mid-morning break after.
Motion in limine with respect to Mr. Grunberg. And obviously we have motions related to a directed verdict.
Of course, and that takes time too. So I think we've got a full day ahead, most likely. We could bring in the jury.
Be optimistic, Judge. I want to get on the road.
I hear you, Mr. Wood.
Hasn't filed it.
Is, in relation, Mr. Exum, to the issue you raised on 408 this August, I think you said it was an email or a letter. Is this an exhibit, either in defendant's binder or plaintiff's that we can look at?
Yes, it is an exhibit. I'll let you know. I think,
All right, for the jury.
oh,
You can just tell me which defense exhibit it is.
I know which one it is. I don't remember the exhibit. But
Judge, I kind of.
Thank you. Please be seated, everybody. Members of the jury, thank you for your patience. We've been working on some things while you were ready to streamline it. I think we've achieved some progress on that front, and so I'll ask the plaintiffs to resume their presentation of evidence at this time.
Over at Exhibit 48. Tell me if you need to take a break.
I'm fine.
Proceed. Okay, good. Does Exhibit 48 appear to be another late night email? Sorry, you got to turn in 2872. Date's number. So it's about 5 pages in. Does Exhibit 48, dates number 2872, appear to be another late night email? This one dated March 4th, 2020 at 1:16 a.m. From Lynn to you regarding the same subject.
Of the division of our quantum merit only,
Yes.
it does appear to be that, yes.
Okay, and he's talking about other cases here, Carboni and Lindsay, but those aren't your cases, are they?
They are not.
Okay. It states that he's only prepared to offer WGW fees on a quantum merit basis. Is that correct?
It does say that, yes.
And it states some random numbers of what he's willing to pay them, but that he is not willing to pay them pursuant to any agreement. Is that right?
Said I am now inclined only to offer them between 100,000 and 200,000. Any monies offered them shall be in excess of the monies they are fairly entitled to under the law, and the statement of our clients zero. Yes.
Thank you. All right, let's look over at Exhibit 55. Sorry. All right, in Exhibit 55, at the bottom of the page, does that appear to be an 8:57 a.m. email on February 29th from Lynn to you?
Yes.
You probably can't answer this, but any idea why Lynn was so mad in there? Objection form.
Yeah, I object to the form, but if he understands what you're asking, he of course can answer.
What are you saying where he's so mad? That's
All right, well, let's just break down what he says. He says the subject of the email is order from the general. Did he oftentimes refer to himself as the general?
around this time period he did.
And it says, if you care about your campaign, take 10 minutes and call your best supporter, your best financial supporter, your best strategic supporter. 10 minutes, Todd. If you don't want to sue all 5 of them, I bet you can see, and I assume he means sue, the New York Times. I see around the corners, Todd. How about show me enough respect to give me a call? I'll pull out of the case. That'll hurt the same as I pull out of your campaign. That'll hurt you. I'm not going to do either one of those things, but damn it, you owe me enough respect to call me this morning for 5 or 10 minutes. Thank you.
Do I know why he was so mad?
Yeah.
He was calling me a lot around this time and I was busy and I didn't return his calls.
Okay.
This is the way he would react.
So somewhat common, not common, but
Yeah, I mean, he was abusive. He would try to abuse people. It didn't work on me, but he would use these tactics and yeah, he called me and I didn't return his call.
all right. Thank you. He says, as to the campaign, he was your best financial supporter. Do you believe that to be in general terms correct?
I think he, as I recall, he offered to help with some fundraising by maybe holding a fundraiser in Atlanta or something like that. But at this point in time, I didn't really take too much of what he said seriously.
All right. And then at the top of the page of Exhibit 55 is your email saying, hey, I've been busy. I'll call you.
Correct. That's whatever that says. That's what I said.
And then the very next Exhibit 56 is the same day, a couple hours later, you write this email, Exhibit 56, to me and to Lynn. Is that correct?
Yes.
All right. And in that, you suggest again that the Sandmanns control the fee, quantum Merowit is appropriate, and you'll hold the money in escrow. Basically.
Where do I say I'll hold the money in escrow? Oh, that is, I propose my firm hold on to that some pending resolution of the claim. I wrote that.
Yes.
And did I talk about quantum Merowit in there? Let me see.
Yeah.
That was my position. Yes.
Mr. McMurtry, we're back on. Thank you. We're looking at Exhibit 56. We're looking at the third paragraph. And in the second sentence, you said, so I approach this matter as an objective and disinterested stakeholder. What did you mean by the word stakeholder? That somebody who has an interest in the outcome?
I was one of the attorneys, I guess, who was working on the file, one of the principal actors in the entire situation.
And you said disinterested and objective. But is it fair to say that you still wanted to assist Lynn because he was your friend?
In part, I wanted to assist Lynn because Lynn was, in my view, at that time, and in my view, was the person who would be able to be most successful with the cases as they progressed. So I wanted his involvement to continue.
Because of his name or his presence or his...
Exactly. Those reasons, all of the above. He's the one who made the phone calls, and he's the one who issued the demands. I mean, I was on the phone, but he was the person who got the job done.
And he is the one who could bring you in on other cases.
At that time, there was no discussion of that. I think once later in the process, he asked me to assist on one other case, and nothing ended up happening.
But you understood he was kind of a magnet for some high-profile cases.
Correct. I'm sure that in the future, as I saw it, there may very well have been an opportunity once the WGW folks left to maybe help out on some of those cases.
Thank you. Also, he had been a substantial contributor to your firm and to your campaign. Did that cause you to want to, if possible, assist him in this matter?
Well, I think you and I spoke on the phone, as I recall, and I did want to assist all of you in going to mediation and resolving the dispute.
Did Lynn ever say if you didn't help him with this, he would withdraw his support from you either in the campaign or in these cases the way he did in that one email?
That one email is the only instance that I can remember. I certainly didn't have concerns about other things. These were merely, I think, possibilities at the time that in the future some other case might arise. That was my thinking.
Let's turn over to Exhibit 63. Talking about this whole issue now of the delay of the settlement in the conservatorship hearing. Can you describe for the jury what a conservatorship hearing is and why it was necessary in the Sandmann cases?
Yes, so a conservatorship is required when the person receiving the settlement monies, the litigant, is underneath or below the age of 18. So in this case, we had a settlement. Nick Sandmann was not yet 18. For him to receive the settlement, it had to be under a certain amount of court supervision. And that is and we engaged in that procedure in Kentucky to accomplish that.
So let me see if I can summarize this for the jury and tell me if I'm wrong. When somebody's under the age of 18 or they have some mental issue, even though you settled the case, you still need court approval for that settlement and a conservator to assist the underage person or the disadvantaged person in managing the funds.
I think managing the funds can be part of it, but in general, that is correct. There would be a check so that I think the check is primarily so that parents don't run off with the money. But yes, what you said is generally accurate.
All right. And when was Nick going to turn 18?
July 20th or 24th of 2020. Forget the exact date.
So he was 17 3/4 when this dispute was going on in February of 2020.
You know, 3 months before he would be 18. Yes.
Thank you. And when he turned 18, he could execute the settlement himself. Is that right?
Correct. Without supervision by the court or otherwise.
And so when he turned 18, he would become the putative or named plaintiff, not his parents as guardians for him.
Correct.
And so let's look at Exhibit 63. I think we're on there. Does this appear to be an email from your associate and or partner, Will Huber, to you on Sunday, March 15th, 2020 at 1 p.m, describing or detailing that the probate court hearing would be postponed due to COVID-19 interruptions with the courts?
Yes, I recall that it was postponed he says here it was canceled. There was no hearing.
And you wrote to Lynn at almost 6 p.m. that day saying, please read below. So you were telling Lynn about the issues with the delay. Is that right?
Yeah, I said the virus was causing us trouble.
Okay. And you included Will Huber's email summary. Is that right?
That is correct.
All right. And so then Exhibit 64. Does this appear to be Lynn's email right back to you 30 minutes later?
Yes.
Okay. And he says, I am excited too. The hearing will work out. I have resolved dispute with former business partners. Today is a day for prayer for our nation. I love you. Did Lynn oftentimes say, I love you in his emails?
Yes, he did.
All right.
He's familiar in that way.
And And did you then contact him to ask him what he meant by resolving his dispute with his former business partners?
I don't believe that I did. I don't recall reaching out to him. I just recall being relieved that this was resolved and we could move on.
Okay. And you believe that if there was an agreement among the parties, they could divide up the fees however they wanted, so long as it didn't affect the Sandmann's fees or your fees, and you could be done with this.
Absolutely.
And so you assume that they had reached one of those agreements that you talked about in your letter to me, where you said, I will hold the money in escrow absent an agreement.
Correct.
Thank you. Let's turn over to Exhibit 69. And 3146 Bates number, so it's the second page. In the middle of the page, does that appear to be your email to Lynn on Tuesday, March 17th at 9 p.m., 9:06 p.m.?
Yes.
All right. And you say, Lynn, I write to bring you up to date on the status of the CNN settlement. We were set for a hearing on Monday in Kenton District Court to appoint Julie Sandmann as the conservator for Nick and the CNN settlement. Unfortunately, the court canceled all hearings until late April. We called Monday to ask for a phone hearing, but the clerk denied that request. So we're forced to reschedule. The earliest date we could get before our preferred judge, Ann Ruckle, could I say that correctly?
Yes.
Was May 4th. This is an unfortunate delay, but I assure you, we have no other option. I will keep you updated should anything to change. Did I read that correctly?
Yes.
All right. So you wrote this to Lynn on Tuesday, March 17th at 9 p.m. Is that correct?
Yes, 9 p.m. Yes.
And you had written Sunday night or Sunday afternoon at 1 p.m. to tell them that it was likely continued.
I don't recall the date on the prior email, but yes, around this time I said that it was, I think I said they had canceled the hearing, and then I followed up with this additional information.
Okay, let's look back real quickly at 63. Does that appear to be Sunday at 1 p.m. that you wrote them?
Yes.
So you didn't forward your earlier email to Lynn saying, yep, we're postponed. You wrote an entirely new email.
I did, yes.
And did Lynn ask you to do that because he was planning on forwarding it on to the plaintiffs?
I don't know that he did. I can understand why you look at that and think, why not just say, hey, it's canceled? I don't know if it was that or if I wanted to then forward this to the clients. I don't recall one way or the other. I don't think that I have no recollection of Lynn saying, write it and then send it to me so that I can then forward it to my attorneys. I don't recall that.
But it could be for forwarding on to other people.
It could be, yes.
Yes. And you believed at that time that the Sandmanns would control the allocation of fees between Lynn and WGW, and that quantum merit was required. Is that correct?
Well, I believe there's an objection. I did not necessarily believe. I believe that Nick could have said, yes, I approve. So I didn't think that he had to engage in a quantum merit discussion over the fee. So what Alston and Bird told me is that Nick needed to make some decision about approval or not of the settlement.
So we saw Exhibit 46 and 56, your first letter to me in February of 2020, and your second email correspondence with me in March of 2020, in which you said, we can escrow the fees. the Sandman's control and quantum merit is required. Do you remember those two
I do.
letters that you just?
Yes.
Thank you. So are you saying that between February of 2020 and July of 2020, your position changed?
No, I don't think that my position changed. I think that I kind of stuck. Well, I see what you're saying. So whether it was settled, that would eliminate any conversation about the case. My position changed after Alston and Bird said Nick needs to approve this settlement. And so then I felt that we were, kind of walking a tightrope as to what do we do here. I didn't want to have that imposed upon Nick and was not happy that we were being put in this position to have to deal with the situation.
Did you ever tell Nick that he didn't have to consent to anything? He could just receive his money and not sign any kind of consent form and not get involved in the issue of his consent?
Objection. That question calls for communication subject to the attorney-client privilege and the work product doctrine, and I'll instruct Todd not to answer.
Let's look over at Exhibit 107. Does this appear to be your transmittal letter to Nick regarding his settlement with CNN and the money and a statement showing the money received in the Washington Post case as well?
That is my email to Nick Sandmann. And then an exchange with Lynn.
And it states, it also shows my firm's disbursement to Lynn. Is that correct?
Correct.
Please review the settlement statement. Once you approve, I can transfer money to Lynn. We will hold your money until such time that you direct us as to where to deposit it. Do you remember saying that to it?
Yes.
And this is dated July 31st, 2020. Is that right?
Yes.
And so he had been 18 for 9 days.
Thereabouts, yes.
All right. So his parents were not in this process at all. Is that correct?
I mean, I don't recall whether I sent the settlement statement to them to review. They were certainly the clients at the time that the settlement was accomplished. I can't say exactly to whom I sent this.
And if we look over at Exhibit 111, is this your email to Lynn showing that you have made the transfer to Lynn of all of his fees?
Yes.
And then we look at the third page of Exhibit 111, which is Bates number 3160. And it shows a line for Lynn Wood. And I would assume that that is the complete disbursement of all funds of Lynn's half, more or less, of the settlement proceeds. Is that correct?
Well, there were some litigation expenses. I don't know how those were paid, but yes, in total, that would have been all of the settlement monies.
And there was no money held back for any dispute with WGW in your escrow account there.
That's correct.
And if we were to see the blacked out section, we would see that Hemmer DeFrank Wessels received an additional $75,000 from Lynn regarding some kind of dispute or expense you had in your firm internally. Is that correct?
That is correct.
So so the earlier email that we looked at, 107 to Todd, excuse me, to Nick, refers to all the settlement monies being sent to him. And would it be fair to say that that was all delivered to him at or about the same time you requested his consent for Lynn to share fees with WGW.
I'm gonna object to the form of the question to the extent it purports to characterize what are privileged communications between Todd and his clients. Subject to that, if you can answer.
So I think we would have met with Nick on June 24th, and this would be a week later after the money had cleared our escrow account, you know, pursuant to our kind of internal controls about how long money has to be in escrow before we disperse it. And I would have only dispersed the money with the client having signed the document shown on the third page of Exhibit 107, which is WGW Bates 3090.
Let's look over at Exhibit 159. Did there come a time when it was necessary for you, as counsel for Nicholas Sandmann, to terminate Lynn Wood in his representation?
Did it become necessary for me to terminate Lynn Wood?
I didn't ask that very well, did I? Let me start over. Did there come a time when Nicholas decided to terminate Lynn Wood and asked you to communicate his wishes to Lynn?
Objection, subject to attorney-client privilege. Work product doctrine, I'm instructed not to answer.
All right, I'll phrase it a different way. Did there come a time when, well, let's just look at Exhibit 159. Is that your email to Lynn terminating his services?
Yes, there was also a phone call.
And was it based on some things that Lynn had said in the media regarding various public figures?
Yes. All of these things added up to a completely unmanageable, untenable situation. And in particular, for me, it was a strong reputational risk to even be associated with anybody saying these things. So all of that cascaded to a mandatory termination of Lynn Wood.
If we look at Exhibit 159 at the bottom of the page, does that appear to be Lynn's email to you acknowledging that he had been terminated and talking to you about various issues with regard to Nick?
That's his email to me, yes. And whatever it says is what he's told me.
So in the second paragraph, it says, I had agreed to withdraw voluntarily at his request. I just wanted to wrap up the fee issue and the return of the $75,000 from your firm. And so is that the $75,000 that we talked about from the Sandmann settlement?
Yes.
And the fee issue is what he would be entitled to receive on cases in which he was terminated.
Correct.
And Sandmann, at this time in January of 21, had settled a year before.
Correct.
And Sandmann versus CNN, Sandmann versus Washington Post were all resolved at that point.
Correct.
All right. The next paragraph says, I hope that you and Nicholas will maintain the truth of your position on the WGW case, that Nicholas must see the timesheets before he can reach a decision on the reasonableness of the amount of their fee. I believe you testified earlier that Nicholas had not specifically requested or that you had told Taylor Wilson and Jonathan Grunberg that that there was not a request to see the timesheets.
I'm going to object to the form of the question to the extent that it purports to characterize his communications with Nick. You switch gears midway through. I don't know if you want to ask it more focused.
Yeah, I don't want to ask about his communications with Nick.
So to answer your question, as I understand it, you asked me about our position with regard to providing timesheets, correct? That's what you wanted to know?
Yes, and by that, is his statement there correct? That Nicholas,
That is not correct. That was never anyone's position that actual timesheets had to be produced.
thank you. You told me last week that you would do so since it is the truth and truth does not change. Did you just strike that up to another Lynn Wood-ism? Or did you believe that you had made some kind of a promise about what Nick's testimony or your position might be?
I never made that promise to Lynn.
That's what I'm saying. Okay, thank you. He then again goes on in the next paragraph to say, do you plan to return the $75,000 as indicated? And I believe in other places you had told him that it was not your obligation to refund the money, but you would endeavor to do so anyway. Is that fair?
Correct. I told him if we recovered any other fees on the case, I would pay him out of that recovery.
Thank you. All right, going on to another subject. What is a litigation hold letter or a preservation demand?
In something that one lawyer sends to somebody to preserve
Yes.
your documents?
Yes.
It's that, preserve your documents.
When a party receives that, can you tell me what the effect of it is?
I think you need to make an effort to preserve documents so that they're available for future review.
If you're aware that there's a potential claim that might involve those documents.
Yes, in general,
And do we call that a preservation demand or litigation hold letter?
something like that, yes.
Thank you. Now let's look at Exhibit 114. Does this appear to be my a litigation hold letter that I sent to you on August 6, 2020?
It's of that form, yes.
And does it reference an earlier letter of February 25th, 2020?
Yes.
And do you remember receiving the earlier one on February 25th, 2020?
I can't tell you exactly what it was, but I remember that you sent me something like this at that time.
Okay. And if you look over at Exhibit 192, I don't expect you to just peek in there. Does that appear to be the February 25th litigation hold letter on 192?
Yes.
Thank you. All right. Now let's look at Exhibit 148. And is this your email to Joey Burby of Alston and Burr regarding my demand for preservation of documents?
I'm sorry, what number?
148.
That's an email for me to Joey Burby.
Yeah.
Yes.
And do you appear to be, and in that email, are you asking Joey for his opinion regarding my litigation whole letter that I had sent to you.
I think yes, my entire family were trying to turn in their cell phones and I wanted to get the $750 rebate.
And so that was in December of 2020. And my first letter to you was in February of 2020, and the second was in August of 2020. Is that correct?
That's right.
All right, let's look over at Exhibit 155. Does this appear to be my email to you in January of 2021, asking you if you held any of the Sandmann settlement fees for the Sandmann settlement in escrow?
I go by what the letter says. Yes, I see what you're asking here.
And then your email back indicates that you were not at liberty to tell me. Is that correct?
I'm trying to look. I think it was around this time that Len was no longer associated with the case. I was trying to move on with things and I didn't want to get involved. And so, yes, I wanted you guys to agree to instruct me on what to do.
And then Exhibit 156, the next page, does that appear to be my letter to you of January 11, 2021, in which I detailed the types of services performed by WGW in the Sandmann versus CNN litigation?
You do talk about some of the services provided.
And are those, if you look at the long paragraph at the bottom of the page, do those appear to be the same things that we've talked about here today?
Yes.
And did you have any reason to believe that, or did you agree with that summary of services that I put there in that letter back in January of 21?
No. I think that you were being argumentative here and you seemed upset. At least that's the tone I took from it. And you were saying, almost attributing the success of the case to them. That's what I disagree with. I'm sure that they wrote retraction demands and that they did word searches on the internet and got on the Wayback Machine and tried to identify websites and drafted all these pleadings and wrote all this stuff. I agree that they did all that, but I don't agree with exactly what you said here. The actual acts, the facts of the work are correct. They did do these things.
That's all I was asking.
Yes.
That's good. Thank you. All right, let's look over at Exhibit 162. Is this a record of a Zoom meeting between yourself and Alston and Bird lawyers in January 26th of 2021?
Yes.
And were you guys meeting to talk about Nicholas Sandmann's affidavit?
Yes.
And then if we turn over, is this Exhibit 163 the same Zoom meeting or is it another one?
Looks like it's the same one.
All right, and then let's look over at Exhibit 164, where Joey Burby says, thanks for hopping on the phone just now with me and Chris to discuss the affidavit. So you had multiple conversations with Alston and Bird regarding Nicholas Sandmann's affidavit. Is that correct?
I believe that we had more than one conversation.
And you believed at that time that the WGW folks were all partners of Linwood in L. Linwood PC or their other firm, Wood, Wilson, Grunberg, and Wade.
That's what Jonathan told me back in that time period. So I accepted his representation that was their status.
And do you know how being members of a firm would impact the interpretation of Rule 1.5E?
I know that the rule discusses winding up affairs and so forth. You know, I think that, as I said before, the case law in Kentucky is a little different. I was looking at it from a Kentucky standpoint.
And if we look back at Exhibit 92 in the first binder,
I see it.
thank you. And we look at page 6. Excuse me, page 7. Note 8 states that paragraph E, meaning rule 1.5E, does not prohibit or regulate the division of fees to be received in the future for work done when lawyers were previously associated in a law firm. Did you have an opportunity to review note 8 to rule 1.0? Rule 1.58, sorry.
Not in the July 2024 timeframe. I don't believe that the version of the rules that I reviewed in February of 2020 yet contained that provision. I think the rules did. I think my book, you know, the book that I refer to for those things didn't have that rule, did not have that number 8 comment. With regard to heading into July 24th, 2020, no, I did not review that. I did not see this memo. I did not review that. I relied upon what Alston and Bird told me was required under Georgia law.
And you discussed rule 1.5 with Lynn in February of 2020. Is that right?
I believe that I did, yes.
And then if we look over to page 6 of that exhibit,
Which one?
the 92, sorry. And I'll just read it to you. Georgia Rule of Professional Conduct 1.5E provides a division of a fee between lawyers who are not in the same firm may be made only if not in the same firm. And I believe you testified that you believe that the WGW folks were partners with Lynn Wood in his firm or in the firm of WWGW.
When they left the firm, yes, I would have said that they were partners.
Thank you. And did you get a chance to review Georgia Rule of Professional Conduct 1.0?
I didn't review any Georgia rules of professional conduct.
What steps did you undertake, if any, to determine what constitutes a law firm, associated with a law firm or being members of a law firm?
I didn't do anything with regard to Georgia law. I'm not licensed or affiliated with any firm down here, so I didn't make any review of Georgia law. I relied upon what Alston and Bird told me. And prior in the February timeframe, I thought Kentucky law applied. And as I said, I cited to you the case involving Bonar and Chesley, which I think would support my legal position at that time.
Looking back at the, I think you're on the right one, the affidavit. Did you ever ask to see Lynn Wood's records of his time spent in the Sandmann versus CNN case?
No.
When providing legal advice, did you discuss the issue of proportionality?
Object to that question. It calls for communications subject to the attorney-client privilege and work product doctrine.
What steps, if any, did you undertake to determine the proportionality of any fee to WGW as opposed to Lynn Wood?
The only steps that I would have taken, or that I did take, were to consider the relative value of what each group, Linwood and WGW, brought to the settlement. And in my view, Linwood's my view at the time, it's evolved, but at the time, I would have said that Lynn procured the settlements based upon his alleged national reputation and standing in the area of defamation law, and that WGW were his able supporters in that effort, but that none of that group, WGW, would have had any success obtaining those same settlements as Lynn was able to, based upon, in part, his, he personally knew the lawyers for CNN, he personally knew the lawyers for the Washington Post, had dealt with them before, and they seemed to have a good rapport. So I saw Lynn as being the, kind of using a realtor term, the procuring cause of the settlements.
Would you agree that there would have been no settlement had there not been a complaint, and a complaint or amended complaint that ultimately survived a motion to dismiss?
Yeah, sure. And I think that in an alternate reality, Lynn had the capacity to have drafted the complaint or directed me to draft that complaint, just as he helped train the WGW people in this field of law.
Did you ever have a discussion with Lynn about how often he ever typed any pleading or any non-email correspondence?
I'm sure that he did practically nothing other than talk to me on the phone from time to time.
Thank you. When WGW withdrew from these cases, your firm undertook a lot of the written product thereafter in representation of Nick Sandmann. Is that correct?
Yes.
Would you say that your law firm then, after their departure, effectively did all the written work product on the Sandmann cases?
Yes, I even had to hire another attorney to help.
All consuming, absorbing kind of work?
Yes.
And you were aware at the time of the execution of this affidavit, and you were aware in July of 2020 that Lynn did not keep a record of his time either.
I certainly would not have, I didn't know that as an independent fact. My assumption was that he did not.
Okay, and he had told you in multiple emails that the WGW folks did not, to his knowledge, either.
That's what he told me.
But you had a belief based on your communications directly with Lynn.
I did.
And was that he did not want to share fees on that case with WGW except on a quantum merit basis?
Objection form. I don't know that he was as specific as saying quantum merit, but in that July 2020 timeframe, based upon my conversations with Lynn, I took that he did not want Nick to approve that settlement, and he didn't want to share fees with WGW.
Thank you. You had no discussions with Lynn between the March 17th time period and these July 2020 conversations about the WGW fee split. Is that fair?
The first I would have learned of this new WGW fee split issue would have been when Lynn called me and said, my lawyers from Alston and Bird are going to call you. And then they called me and they raised this issue of needing Nick to approve the settlement between Linwood and WGW. So that would have occurred in July 2020, I believe, based upon my review of the emails and documents. So between that March email where Lynn said, we're settled, and that July call where Lynn said, Alston and Bird will be calling you, I didn't even think about this. I thought it was over.
Thank you. So nothing changed in your perception of what Lynn wanted between your February, March conversations with Lynn and your July conversations with Lynn. Is that right?
The only thing that would have indicated a change is that email in March where he said, we're settled. But other than that, he never spoke to me and said, my feelings on settlement have changed, you know, up until the July timeframe.
And he never said disregard prior communications or anything.
No.
I believe you testified about a trip that you guys took down to Reynolds Plantation to meet with him.
I could never forget that trip, but go ahead.
Did Lynn send a private jet for you guys?
He did.
All right. And in that trip, he also expressed his views about fee splits and a variety of other issues.
I don't recall exactly. It was a very strange event. He expressed a lot of views in the day that we were there. And I'm sure that there would have been, based upon everything that is happening, that there would have been some complaints about WGW.
Okay. Now there was another trip down to his plantation in South Carolina, the Tomotley plantation in July 2020 that involved your clients and Lynn. Is that correct?
Yeah, I think that the Sandmanns were on vacation and in the vicinity.
And he flew them down and met with them. Is that right?
Not to my knowledge, no. I thought they were driving, isn't that in South Carolina? I thought they were driving to South Carolina for vacation and detoured over there. But I don't know. I've never seen any plane records, or I've never been told that Lynn flew them down there.
You weren't at that meeting in July 2020, were you?
I was not.
All right, let's look at Exhibit 185. Do you remember executing this affidavit, and I'll call it your discovery affidavit?
Yes.
And did you execute that to represent the efforts that you had made to produce documents which were called upon by a subpoena issued to you by my office?
Yes.
And in that, looking at paragraph 9, you said you conducted a diligent search of your electronic and paper files for responsive documents and have complied with the subject subpoena. How did you do that search?
I met with my assistant. I asked her to get on everybody's computer and to search. I said, search for to from BC CC. That was the term I used. And she literally got on everybody's computer and searched. There were, Linwood, L. Linwood, some search terms that she employed, and she generated the documents that I produced to you. And then,
And I did review that with her. I went through and reviewed all those documents and made the redactions.
Thank you. And then look at paragraphs 10 and 11. Is that where you swear or affirm that you have produced all responsive documents with regard to Linwood Communications?
I swore to what is written there.
Okay. And you remember that there were some notable exceptions as to what was produced and not produced in this case pursuant to that subpoena. Is that correct?
Well, you characterized them as notable. You'd have to show me those emails. My recollection is that they're more kind of Linwood off the reservation rants.
Okay. Let's look over, sorry to do this to you, but you got to go back to the first one, Exhibit 48. All of these late night February 22nd emails were not produced. Is that correct?
All the ones at Exhibit 48,
Yes.
are these the ones that Nikki Baker produced?
Yes.
I don't know. I can't, if you tell me that these are the ones, I know that some emails were not produced.
All right. Rather than do that, I'm sorry, I shouldn't have gotten you back on the old binder. Let's look at Exhibit 195. Does this appear to be my email of September 14th, 2021 to Chris Finney, in which I say, Chris, sorry for the delay. Here are the two emails which Todd did not produce. As you can see, they go to the heart of this matter and they show what Lynn's plan was and how Todd could help him execute it. Let's talk tomorrow. And if you turn over to the third page of that, you see the 2:42 a.m. email. And then the fifth page, you see the 2:58 email.
I see 3 emails in Exhibit 195.
Right. And so does that refresh your recollection that these emails that we were referring to late night on February 22nd, referenced here in Exhibit 48, were the ones that were not produced pursuant to the subpoena?
I believe that when you tell me, I know that some were not produced. I think these are the ones. I haven't gone through and checked side by side, but I'll accept your word that these are the ones that were not produced.
All right, let's turn over to Exhibit 196. Does this appear to be Chris Finney saying that what steps you were taking to more thoroughly comply with the subpoena?
Can I read it? I need to read it.
Yeah.
Yes, that's a letter from Chris Finney to you.
And Chris was your lawyer on the subpoena issue, is that right?
Correct.
And so then if we turn over to Exhibit 197, this is Chris producing a volume of additional communications that were not produced originally.
I recall that we did have supplemental production.
And if we look back at 195, the two emails, they're from Lynn to you. Is that correct?
Two of the emails are from Lynn to me.
And the first email, the one at 2:42 a.m., it's hard to say earlier when you're talking about 2:42 a.m., but it is the earlier email. The subject line is Taylor, Jonathan, and Nicole. Is that right?
Yes.
So, do you believe that if a search was done with any of those names, Lynn Wood, Taylor Jonathan, and Nicole, that your Outlook process would pull those up?
My belief as to why these were not originally produced is that my assistant took my request literally, and that is, the inbox, the sent box, and did not search the deleted box, and that these were in the deleted box, and that's why they did not show up. So it was a faulty search. When referencing the email to Chris Finney, when I saw that this happened, A, I was ticked off, and B, I met with NKOL, our email provider, and had them do the subsequent search. So that's where I believe the problem arose.
So you think that might have been moved to your deleted box?
Yeah, I mean, I routinely, if I don't forward or reply to an email in my inbox, it goes to deleted. I will say that back in when you sent me the first letter to preserve documents, I was doubly irritated with the situation, not because you did that, but because the mere existence of the thing and having to be involved in something that I didn't consider my problem. And
Getting dragged into it?
yeah, I was not happy about that. So I remember speaking with NKOL, and I was of the belief, and I think it's true, that they generally keep everything. We have no document destruction policy. Our documents don't go away after a year or 2 years or 5 years. They're all there. And so I believe that we would have everything. And then when we did the search, it was just done inexpertly. And that is ultimately my fault. I should have just called NKOL. I should have had you provide me search terms, and then we should have had an agreement, but I didn't do that.
Did Lynn ever tell you he didn't want you to produce those documents?
No,
Did Lynn ever tell you he wasn't going to produce those documents?
no.
Did Lynn ever tell you he hadn't produced those documents in response to a request to produce documents served on him months before?
I think I only learned about Lynn's failure to produce anything. Well, I take that, strike that, in the process of this litigation. He never told me anything. I just learned through the litigation that he didn't produce anything.
Got it. Thank you. And you were keenly aware of the amount of written product they did because you were working with them on every phase of this case.
In my opinion, as an attorney, separated from my role as a lawyer, I thought that their fee would have been fine. I mean, you could make an argument one way or the other and say 800,000 is too much or it's not enough. I think the point of the July 24th thing is that this was thrust upon me without anybody asking me, and I didn't want to be, I really didn't want to be a part of it. I didn't want to say yes. I didn't want to say no. I really wanted to thread the needle and get out of the whole situation. That's what I was trying to do.
Did you ever tell Lynn that you felt like he had brought you into this situation unfairly or improperly?
I probably said, I'm really pissed off that I'm involved in this situation. Yes. I was not happy about it. And I didn't want to be involved in it. That's why when you called me shortly after the settlement and said, we don't need your approval, I was like, great. I don't want to be involved.
Paragraph 32, the disputed client has not consented to pay fees to plaintiffs in the absence of records to substantiate the fees. And I believe you said in the phone conversation that was not entirely accurate.
No, I don't think I said that. 32?
Yes.
I think I said he wasn't going to, well, I'm sorry, I can't. I guess that's delving into privilege.
Yeah, he can testify to what he said on the phone conversation.
Yeah, that's all I'm asking.
Okay, but I'll object to form of the question to the extent it mischaracterizes what was said on the phone conversation. So you're getting pretty specific about something we all listen to is recorded. And if you're gonna ask him about that, we ought to let's focus on the language that's actually on that recorded call.
So in response, do you want to ask a different question or do you want me to?
No, go ahead and answer that.
Okay, so as I understand your question, did I tell Alston and Bird that did I tell Alston and Bird that I wanted to see something for WGW to prove its work? And that's just the gist of what I would have said. Show us your work. Then yes, I did tell that to Alston and Bird.
Right, that's paragraph 31. Paragraph 32, where you're referencing Nick and his demand for documents. I believe what you meant is it's your demand for documents. Is that right?
I'll object to the form to the extent it mischaracterizes what he meant.
What I communicated to Alston and Bird was that we would like WGW to show its work.
Okay. But I believe you said on the recorded call that the disputed client did not demand time records to substantiate fees.
Correct. I think something akin to your letter that you sent before, if you had sent that on, August 3rd or something, had you chosen to do that, then I would have been able to proceed. And I didn't want to be approving or not approving the fee, but that would have been the next step in getting your people paid.
But not getting into your attorney-client communications, you were capable of telling Nick all the facts regarding proportionality of the fee because you lived it, you worked it, and you worked with the WGW folks every day throughout 2019 and the beginning of 2020, correct?
I'm going to object and instruct him not to answer to the extent that it calls for what he said and communicated
Nope.
about with the Sandmann.
Doesn't ask that at all.
Yeah, proceed. So if you had called me as an expert witness to review the work done on the case, I would have found that their fee request was reasonable.
Can you turn over to Exhibit 199, Mr. McMurtry? We received this. We received this extraction report from Celebrite from your team. Can you describe for us who Celebrite is?
Is this my phone?
Yeah, I think.
Yeah, somebody copied my phone and I assume Celebrite's the software used to do this.
And what cell phone provider did you have in early 2020?
AT&T.
And did that ever change?
I've always had AT&T. I've had AT&T throughout the period that I've been involved in this case.
Thank you. And let's look over at Exhibit 200. Does that appear to be the results of the Celebrite search for emails, text messages?
Yes.
And was that necessary because your phone was traded in and you lost certain text messages at a particular time?
No, the phone was never traded in. It just wasn't traded in. And I later learned that we still had the phone. And so when they extracted everything off of the phone, I think this is what they got.
But you got a new phone and used that and had text messages on that new phone, is that right?
Right. If I recall correctly, on the new phone, I screen captured and sent you text messages from that phone.
So this was very recently produced to us. Is that correct?
Yes.
All right. Let's look over at Bates number 860 and 861.
Okay.
Does this appear to be texts on March 4th, 2020, between you and Lynn?
Yes.
And are you referring to, if we look at 861 at the top of the page, it says, sorry. Let's look at 860 at the bottom of the page. Received your voicemail. You are a great chess player. Let me know if you need me. Looking forward to visit. And that was on March 4th. Is that correct?
Yes.
And then the next page, you stated, I have some immediate thoughts, but wanted to sleep on it. And I assume that is immediate thoughts in response to his voicemail to you.
I don't recall exactly. That appears to be correct.
And then Lynn writes back and says, perfect response tonight. Perfect response will be scribes tomorrow. I shall follow to the penny what you recommend. I trust you and believe in you. Always have, always shall. You must feel comfortable with the amount I offer. I shall, all caps, be comfortable with the amount you recommend. I love you. Lynn, Dad, Pops. And were those communications regarding the any settlement amount with WGW?
I don't recall exactly. You know, we were also talking about the CNN settlement. I think it's, since I don't have a clear recollection of that, I really would be speculating, but it could be that. It could also be CNN.
And CNN settled about 6 weeks before that. Is that correct?
Yeah, it may have been around the time. I don't know exactly. It may have, I'm not clear. It may have been around the time that we were trying to get into court. There were some negotiations with CNN related to the whether we would go through the process of the probate or whether we'd wait till Nick turned 18 and what that meant. So there were some additional negotiations, but I can't say exactly when. I think around this time.
And so I believe you testified earlier that the settlement in the CNN Sandmann case was in January of 2020.
Yes.
Right. And these emails are in March of 2020. Is that correct?
Yes.
All right. What did Lynn say to you in July of 2020 that made you think he still did not want Nick to consent to a fee division with WGW?
So from the time of the call with Alston and Bird up until July 24th, I probably had 3 or 4 phone calls from Lynn where he was basically unhinged and screaming, I'm being screwed, WGW screwing me. You know, and he was really, as Mr. Wilson knows, you know, off the reservation, you know, crazy. And so we had to deal with that, and that's what he told me. So I knew that he was looking for a different solution. He was trying to blow things up. So that's what he told me.
Thank you. Did you ever receive any interest on the CNN settlement?
Yes, there was interest paid on the CNN settlement.
And do you know approximately how much that was?
I'm going to object based on confidentiality grounds. We don't unfortunately have a protective order in this case in place, and I think the amount of that would be confidential.
Okay, and however much it was, did you and Lynn share some portion of that, interest by your contingency fee?
Yes, we did. It was just, some simple type interest on the gross amount that was tacked on to the settlement by July 20.
Thank you very much.
I'll direct your attention now to Exhibit 4. And this is an email from you to Chris Markworth on August 10, 2020 at 10:25 a.m. in which you say, Chris, I think Drew Beal committed malpractice. And by not including the Sandmans, what do you mean by that?
Well, I realize now that I was probably wrong in that assessment. I thought at the time that since I thought that it was understood that Nick Sandmann was going to have to approve this, I didn't realize that WGW had no idea that Alston and Bird was going to ask Nick Sandmann to approve the settlement agreement. So I thought they knew about it. And I said, well, if they knew about it, why didn't they take care of this in the settlement process? But I later understood that they did not know about it. And I was operating under a misapprehension at that time.
All right. Anything further on behalf of this particular deposition from the plaintiffs?
Your Honor, at this time, we would move the exhibits into evidence.
All right. So to the, we might have to name those for the record unless you've got them written down somewhere, just so we have the numbers.
It's exhibit 16, 17, 18,
Hold on.
21.
Just everything in this binder.
That's correct.
So,
He's just listing all the numbers in this binder for the record.
I've got to look through them. As he goes through them one by one, I can look over and say objection, no objection.
All right. Well, I'm going to let him name all the numbers and then we'll follow up with you, Mr. Wood, and we'll address that. So, Mr. Beal, why don't you just name all the numbers for the record and then we'll follow up. Okay.
Thank you, Your Honor. It's exhibit 16. Exhibit 17 to the deposition is exhibit 286 to the trial, and that is the engagement letter. The next is exhibit 18, and it is the motion of Nicholas Sandmann to admit Jonathan Grunberg pro hoc vice. And then there's exhibit 21. And this is the email from Lynn to Todd saying, call me. I'm your best supporter. Exhibit 38 is trial exhibit 287. And it is the letter from Taylor Wilson on the letterhead. Oh, excuse me. The very next one is exhibit 288. Trial exhibit 288, which is the demand for retraction on the Wood, Wilson, Grunberg, and Wade letterhead. And it's about 7 pages.
Gunner, he can save time by just telling us the number. He doesn't have to give his summary of what he thinks it is.
I think that's fair, Mr. Beal. If you just want to go ahead and tender them all, they've actually, every one of them's already been discussed in this deposition. So I don't really know if we need to, there's really much more to address here.
Let them all in. I don't have any objection.
Well, I think we've pretty much already discussed that yesterday. So if you could just name the numbers for the record, Mr. Beal, that's all I'm trying to achieve here.
There are a few that have trial.
I understand. And if you want to clean that up, you can do that.
And all right, so that is exhibit 46 is also trial exhibit 289. It didn't change.
Oh, yeah, but you didn't say it on the record.
He only wants the ones that change. That's what he just said.
We
So-
know.
But we want everything in so we can stay on the record. We know what's in.
All
If they
right.
have different numbers,
right.
you can note that just
So-
so the record's clear.
Okay, Exhibit 16, Exhibit 17 is Trial Exhibit 286. Exhibit 18, Exhibit 21, Exhibit 38 is Trial Exhibit 287. Exhibit 39 is Trial Exhibit 288. Exhibit 45, Exhibit 46 is Trial Exhibit 289. Exhibit 48, 52, which is Trial Exhibit 290. Exhibit 55. Exhibit 56 is Trial Exhibit 291. Exhibit 63. Exhibit 64 is Trial Exhibit 292. Exhibit 69, Exhibit 91 is Trial Exhibit 293. Exhibit 92, 98, 99, 107, 111. Then Exhibit 114 is Trial Exhibit 294. Exhibit 118 is Trial Exhibit 295. Exhibit 119 is Trial Exhibit 296. Exhibit 148 is Trial Exhibit 297. Exhibit 155 is Trial Exhibit 298. Exhibit 156. Exhibit 159 is Trial Exhibit 299. Exhibit 162. 163 is Trial Exhibit 300. 164. 185 is Trial Exhibit 301. 192 is Trial Exhibit 302. 193 is Trial Exhibit 303. 194 is Trial Exhibit 68. 195 is Trial Exhibit 304. 196 is Trial Exhibit 305. 197 is Trial Exhibit 306. 198 is Trial Exhibit 307. 199 is Trial Exhibit 308. And 200 is Trial Exhibit 309.
All right. And based on discussions with counsel yesterday and statement of parties now, those exhibits as described by the plaintiffs are admitted without objection.
Well, to the extent there were objections, you overruled them.
That's right. To the extent there are any objections that already raised that have been preserved and ruled upon.
So we preserved our objection to any of those terms, the ones we identified, and you may have ruled against us and let them in, so that the record's clear.
Understood.
Thank you.
All right. So with that, I believe we need to collect the binders back from the jury and we can move on to the next part of the plaintiff's case.
Yes, Your Honor. Plaintiffs call Jonathan Grunberg to the stand and we can get him up there and get ready while we're collecting the binders.
All right. And let me have the parties approach.
There you go. I just saw that. I think all of I'll find it. It doesn't matter. I'll figure it out.
Right, members of the jury, there's been a request for a brief break, so if anyone wants to step out, they can. And we'll be ready to resume when you are, okay?
All right for the jury?
Your Honor.
Sir,
So,
hold just a second. Yes, sir.
so there were some, I know there was some overlap, but there were some portions. Are we gonna do, what are we gonna do, I guess, the plaintiff's objections to our designations?
When you would want to present them.
Okay,
So that would be during your case.
all right.
And once you tell, or if we've got downtime and you tell me, well, we're definitely going to be presenting this part during our case in chief, we can go ahead and get into them. But otherwise, y'all seem logistically a little easier since you're planning to read and not having to do IT stuff with
I'll
them.
read out.
Yeah, so we bring that up when you're about to present it. Or we can do it before that if you need a ruling before then.
Before the jury comes back on Mr. Grunberg, I have a motion to make. Remember,
All right. Oh, that was, you had a motion in limine. Okay, if you want to address that now, we can. And probably should.
Fair judge, I told you I had to go to.
Oh, well, then we can do that. Look, you tell me, we'll be back when
I'm
you're
just
back.
kidding you.
Let's handle it. All right.
I'm gonna go to the restroom one more time.
Okay.
Just.
One of the jurors is saying it's hot. I don't think it goes down much more than this. They don't really give us much margin. Yeah. Ma'am?
The jury names from, I don't have a list of the jurors, the names of the jurors. Just I don't need it.
In case they talk.
Or just, yeah,
In case
my
you-
notes for later.
Okay.
In case you need it, I do have it.
Yeah, we
If that
have it.
comes up.
They shouldn't be, I'm usually gonna refer to them by their numbers anyway.
Okay, thank you.
Okay.
I just need to make sure I got 'em. Thank you. Is it possible to try to document that? Yeah. No, but.
Yeah. Shoot. I have to grab these.
Oh, perfect. Yeah, all right.
All right, let's go back on the record. All the parties and counsel are present. And before we begin the testimony, Mr. Grunberg, defendants indicated they have a motion in limine they want to make. Mr. Wood,
See, John.
you may.
Let me get my notes.
I don't mind taking.
You're good.
I'm in a good mood today, Judge. I'm
Glad to hear it.
going to see my puppies. At this time, Your Honor, on behalf of the defendants, we will move in limine with respect to what we anticipate will be offered testimony by Mr. Grunberg on the subject matter of an incident which occurred in September of 2019 in a hotel in Los Angeles. Mr. Grunberg is going to contend that I assaulted him.
Can I pause you right there and ask, are y'all actually trying to get this in? Maybe I'll save you some argument here, Mr. Wood. And then just yes or no, and then I'll let him resume.
Well, Your Honor, a couple things. We do think it's admissible. We do think he opened the door and talked about it and said, you're going to hear about it. But no, we were not planning on getting into it.
I didn't say anything about it.
Well, there was a reference to it. I don't know I think the door was cracked there, but I don't think it was really
I
fully
don't think we're
explored.
planning on getting into it,
I mean,
right?
So
I know we did, but we're not really going to talk about it.
My recollection of the testimony was that there was a reference to an incident.
I hadn't
No
testified.
details were provided, and it was just kind of vaguely referred to.
I
and It was
didn't- I
buried
didn't-
amongst a lot of
I
other
had mentioned it.
information.
in most general snippet, but I did not discuss any of the details or even.
And there was certainly no reference as to whose fault it was or what started it or that sort of thing.
I believe the actual sentence was, and you will hear testimony about Mr. Grunberg's false allegations of assault.
Then
He did certainly open the door.
Okay.
We're
Well-
not planning to run through it right now. Now,
I-
if something happens in here where the door gets opened again, yeah, we might have to go through it.
Well, the bottom line is it sounds like in the direct, you're not planning to touch it.
That's right.
Mr. Wood, does that temper your arguments or?
if they're not going to discuss that at all,
That's right.
that's fine with me. That would solve my motion.
There you have it. All right.
Thank you.
We've got the light. So with that, unless there's anything else, Mr. Exum?
Yes, it was D14, the exhibit you were looking for earlier.
Yeah, which I've looked at. I found that. And we can take that up whenever you tell me we need a ruling on that.
Yeah.
All right. Okay, let's bring in the jury. And yes, Mr. Grunberg, whenever you're ready, if you could just go ahead and come on up.
All right, jury.
Thank you. Please be seated, everyone. Plaintiff may call the next witness.
Thank you, Your Honor. Plaintiff's called Jonathan Grunberg to the stage. May you please swear in the witness for me?
Stage.
You swear upon the testimony you're going to quote is true, the whole truth, so help you.
Yes,
It's in
been
my
a long
statement,
week.
spell your name for the court.
my name is Jonathan Grunberg. Did he say spell?
Yes.
Oh, JONATHANGRUNBERG.
Good morning, Jonathan.
Good morning.
Can you tell us where you grew up?
Yeah, I grew up in Los Angeles, California.
And did you go to college in California?
I did. I went to University of California, Santa Cruz.
And where ultimately did you go to law school?
I ended up heading out east for law school to Duke University.
And after law school, where'd you start your legal career?
So I started my legal career in North Carolina, clerking for a federal district court judge. So that's a job where you basically get to go work for a federal court judge and help them manage all their cases, write the opinions, and you get a ton of exposure to the law in a way that you wouldn't get.
Question was where to go work, not all the things he claims he did. So if we could confine him to answering the question, it
No.
would certainly save a lot of time.
Well, all right, potentially. So if you'll listen to the question and answer the question
Sure.
asked.
And how long were you in, how long did you serve in the capacity as a clerk?
So I did that job once in North Carolina for 1 year, and then I came up to work in Georgia.
And how long were you in the clerkship in Georgia for?
So then I worked in a clerkship in Georgia again for a federal district court judge here in Atlanta. And I did that for 1.5 years. You may have heard before that I was a clerk for a judge for 10 years in opening. I was only a clerk for 2.5 years for a judge at the beginning of my career.
And when did you start working with Defendant Wood?
So I started working with Defendant Wood right out of that clerkship at the district court here.
And
That would have been 2012 when he was with Wood, Hernacki, and Evans.
and in what capacity did you come on to work with Defendant Wood?
I was an associate, so, a young attorney.
And why did you choose to work with Defendant Wood?
He had a reputation for being one of the best defamation lawyers in the country. There were also two other named partners who were really wonderful in and of themselves. There was Stacey Evans, who was a young up-and-coming Democratic politician in the state. And then there was Catherine Hernacki, who had worked with Lynn for a long time. I thought they were great. And I wanted to be a plaintiff's lawyer. So most of the people I went to law school with went and worked in big corporate law for these big firms making a ton of money. I wanted to represent human beings against the companies, and that's the kind of stuff that Lynn and Stacy and Catherine were doing at their firm. So I wanted to be a plaintiff's lawyer with them.
And I think we heard testimony that the firm name eventually changed, and Miss Evans and Miss Hernacki left, and that neither of them wanted to hire you after that time. What did Miss Evans and Miss Hernacki do after they left Lynn?
I haven't given any testimony to this yet, Your Honor.
I'm sorry, I didn't hear that.
She's talking about what she claims I've given testimony to.
All right.
I misunderstood the question.
Okay.
Yeah.
Okay, I
He's
didn't
made-
quite hear that part of it.
He's
Maybe
made
she-
repeated comments
maybe she-
about
Well,
this.
well, those are the comments that are not evidence. So why don't we rephrase the question?
We've heard Defendant Wood say in this trial thus far that when Miss Evans and Miss Hernacki left his firm, that neither of them wanted to hire you. What did the two of them
Excuse
do
me,
once
Your
they
Honor.
left Defendant
Mr.
Wood?
Wood?
She's referring to argument. Argument is not evidence. So that's
Okay.
improper, and I object to it.
All right, so let's rephrase the question.
Have you heard Defendant Wood make comments about
Without referring to his comments, just ask the question of the subject matter, perhaps, of the comments.
when at some point Miss Evans and Miss Hernacki left the law firm? Is that correct?
They did, yes.
And what did they do when they left Defendant Wood's firm?
So Catherine Hernacki made a bunch of money on these these False Claims Act actions that were going through the law firm. And
Just
she,
objection in the grounds.
Whatever Catherine Hernacki made, number one, he doesn't know. But what relevance does that have to do with anything in this case?
All right, if it's to explain the context of his professional career, I think he worked with them. It's got the foundation.
Came to work.
All right, Mr. Wood, we're gonna we don't need to get all the details. I think on these grounds,
But he came to work there in 2012. That case resolved.
then that's something you can take up on, if you disagree with them, you can take it up on cross.
Well, I don't think you should be characterizing what kind of money Catherine Hernacki
All right,
made or didn't make. That's improper. Let him bring her and put her on the stand if she wants to talk about that.
objections noted. It's overruled. You can continue.
so she made a bunch of money on these False Claims Act cases as a partner there. And then she basically retired from the law after that. And then Stacey Evans, before those claims even settled, she split off from Lynn and formed her own firm, SG Evans Law, as a solo practitioner. So it was just her alone. And she didn't hire another attorney. Catherine never hired another attorney. And she went on then to become a candidate for running for governor. And then Stacey Evans joined a firm with other people, but neither of them, from my understanding, were looking to be anything other than either retired or a solo practitioner at that time.
And when they left the firm and working with the two of you guys, did Defendant Wood need you to help, work on the cases that they had left at the firm?
Certainly. At that point, then he had, I think, 3 lawyers, including himself. One lawyer an associate had gotten fired maybe in the year before or something like that. He wasn't, I guess, in their estimation, up to snuff. There was one associate, David Ehrlich, who was like first year out of law school. And then there was me, who had, all this experience, particularly a lot of experience from my clerkships and doing all the kind of legal writing that you need for the complex litigation practice that Lynn had when it became L. Lynn Wood PC. So I was from what I understood, a pretty important part of his team to do all that work that he wasn't doing himself, like writing all these briefs and writing the discovery and things like that.
And so at some point after that, after Miss Evans and Miss Hernacki left, what did the firm name become at that point?
So when they left in 2014, the firm name became L. Linwood PC, which he had that firm for a long time, and he just kind of restarted it. It actually had even been a partner of Wood, Hernacki, and Evans. Ellen Wood PC was a partner of Wood, Hernacki, and Evans, and then he restarted it as Ellen Wood PC, a firm that was actually practicing law and facing out to the public.
And can you just briefly describe some of the notable cases that you worked on at Ellen Wood PC?
Yeah, there were a bunch. I mean, Lynn was a big deal. He was a great attorney. And he gave me really great opportunities. When I came in, I got to work on the DeVita case with him, that False Claims Act case. I got to work on the Coons False Claims Act case with him. I got to work on the CBS v. Ramsey case, the CNN v. Ramsey v. CVS, Carboni v. CNN. I'm really proud of the work I did for even some of our, maybe not as high profile stuff, but for Miss Sharon Lindsay, who lost her husband in a trucking accident. We had a lot of really great cases that he gave me the chance to work on.
And we've heard reference that you injured yourself at some point. Can you briefly just describe to us what happened?
Yeah, so in September of 2015, I was rock climbing. My rope broke. I fell 45 feet. I ended up in the hospital for 6 weeks, and I ended up on one of those Grady, I wouldn't be here except for Grady billboards, in fact. It was hard. I had to learn to walk again, and Lynn was really good to me at that time.
And did that accident cause you to stop working?
It did cause me to vastly decrease my work while I was in the hospital, but I still worked in the hospital. And then getting out of the hospital continued ramping up my work and working from home because, like I said, I had to learn to walk again, so I had some serious mobility issues. But I was working. I even went and argued a case in another great high-profile case was Zamudio v. Rick Ross. I went and argued in that court in walking boots several months after I got out of the hospital. So I was working.
And we've also heard reference to a fee that you guys received in the Ramsey case. Do you remember that testimony?
I do.
And how long did you guys work on the Ramsey litigation that resulted from that fee?
I think we worked about 2 years, a little over 2 years. It started in like October of 2016 when the two-part docuseries aired, filed the complaint, I think by December of 2016, and then it settled, I think like November of 2018. So like 2 years later.
So during that time period before it settled, just in general terms, what kind of work did you guys do on that case?
So we, the team, Ellen Wood PC, which was, myself, Taylor, Nicole, and of course, Lynn. But primarily myself, Taylor, and Nicole did pretty much all of the underlying work for that case, writing all the briefs, going through all the discovery. I, took the first crack at the draft of the brief and analyzing the two-part docuseries. I'm sorry, the draft of the complaint. It was like a book. It was like 100-page complaint. Taylor argued the motion to dismiss. I wrote the response to the first motion to dismiss.
There's an objection, so let's pause the testimony.
I hate to interrupt. It's not relevant what work they did on the Ramsey case. They received $750,000. There's no issue about what they did.
Objection, all right, he's
what they did.
doing
No,
a speaking
he's
objection.
explaining the legal basis. I don't think it's crossed that line.
I just don't think it's relevant, but if they want to spend their time.
All right.
It's
Understood, Mr.
entirely
Wood.
relevant, Your Honor.
Okay.
Defendant Wood has repeatedly tried to insinuate that they received money, the $750,000, and they didn't do anything, and he was being generous, and he just gave it to them. So this testimony goes to show that my clients
right.
did work really hard.
And I don't need any more argument. I've heard it from both sides, Mr. Wood. I don't need any more argument, and then I'll deny the objection. So you can continue, Mr. Grunberg. We're good. Let's keep moving.
Yeah, so continuing on in what we did. So we basically did all of the work for that case. Lynn managed us as the partner for the firm as he did. He's, a great strategist, a great thinker, a great lawyer, and had a lot of experience with the Ramseys. But we really dug into that case. And then, Lynn took one deposition, like you said, the deposition of Werner Spitz. Nicole took two depositions in that case. I took one deposition. And then think about 6 months after Lynn took his deposition, and then, I took mine, Nicole took hers, and we did a bunch of discovery work, then the case settled. It wasn't, as I heard Lynn say in opening or in a question here, that
Same problem.
Just, if you don't have to refer to other testimony, you can
Sure.
just say generally how it's characterized.
yeah, it's not how it's been characterized, that Lynn took a deposition, then all of a sudden they're handing us a settlement check. That's not how it happened. And
Excuse me, Your Honor. Character, opening statement is.
I know,
not
and
evidence.
we're going to say,
You instruct him to stop talking about things that
All
are
right.
not in evidence.
so
Please.
we'll just refer, generally you can refer to the ideas or theories put forth, but without reference or tying it to a specific statement.
sure,
Continue.
sure.
I think you've answered that question. Let's answer the next one.
Yes, Your Honor. And Jonathan, at some point, you and Taylor got the promotion to the title of partner at Ellenwood PC.
Yeah, so actually in the middle of that Ramsey case, before it settled, Lynn and I were promoted to partners of Ellenwood PC.
Did you mean Taylor and you?
Taylor and I were promoted to partners of Ellenwood PC.
And I believe that we saw in the Happy Camper email memo that was at some point in 2018. Is that right?
Yeah, so that was May 1st of 2018 that we were promoted to partners.
And so at that point, when you guys got the promotion to the title of partner, did anything change at the firm?
So some things changed, some things remained the same. We stayed in our same, at that point, May 18, we stayed in our same office, same chairs, same firm, Ellenwood PC, doing all the same work. All of that was essentially the same, except now we were called partners. And now the financial arrangement changed quite a bit, but in a way that actually was designed in many respects to benefit Mr. Wood. So what happened is he took us off his overhead and his payroll.
Got to draw a line. He's a fact witness. He's not here to characterize and make arguments.
Okay.
I'm not upset with what he says, except it's just got to be stopped.
All right, but I believe all right, I understand the witness is allowed to have opinions, which he has a basis, if he has a basis to base them on.
But
And so,
opinions that have to be relevant. What he,
okay, I think this is relevant, Mr. Wood. So
How did-
I'll overrule the objection.
Thank you, Your Honor. How did your compensation change when you went from associate to getting the title of partner at Ellenwood PC?
Sure. So now I had to start paying Lynn's overhead. And so us collectively as WGW, we were paying 75% of Lynn's overhead now. Whereas before he was responsible for that 75% of his overhead. And that was, at least usually like $6,000 a month. So now I'm paying him. And that overhead included the lease and included, all the kind of things to keep the firm going. And then in terms of payment, now instead of him having to be committed and locked into paying a salary to me, I would then just get compensated if I worked. If we brought work in, then I would work on that work and I'd get compensated. If work didn't come in, I took the risk that I wouldn't get compensated. So for hourly cases, I would usually get first like 70% of the work I did on an hourly case, and contingency fee cases, like the Sandmann case here or the Ramsey case, I'd usually get something like 15% of the case that I worked on.
And did you have a website bio on the Ellenwood PC website like we saw Nicole and Taylor have?
I did. I had, just like Nicole and Taylor were, and I think there's, the picture in the front of the website for Ellenwood PC. It had all four of us, I'm included. It had the about and who the lawyers were of the firm, and it had me on there, just like it did before I was a partner, after I was a partner, but now it said partner, and I was on the firm website.
And I'll point you to take a quick look at Plaintiff's Exhibit 19. And can you tell us what this is?
I'm sorry, I think this is defendants, pardon me.
What's on?
19.
Okay, I'm there.
And what is this?
So,
Just brief terms.
this is the page on the website for Ellenwood PC that talks about me as being a partner of Ellenwood PC as of May 13, 2018. And then it continues on in the next page, showing me with that same profile, nothing's changed. About 2 years later, February 16, 2020, I'm a partner of Ellenwood PC.
And are these true and accurate screenshots from that Wayback Archive we've heard about?
They are.
Okay, Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 19 entered into evidence.
Any objection to plaintiff's 19?
No objection.
Plaintiff's 19 is admitted.
Thank you, Your Honor. Jonathan, if we look here on your bio, there is a reference here about you helping to obtain some key TAM settlements for Stark law violations and Medicare fraud. Can you just briefly tell us what that's in reference to?
Sure, that's in reference to the DeVita case, the one in which I earned a $200,000 bonus from Mr. Wood generously, and a reference to the Coons case, in which I also helped Mr. Wood obtain a really great record-setting result. The one for DeVita was the large one. That was the $450 million result, plus some additional attorney's fees and such that makes up a lot of that $500 million number there on the profile that I had on Mr. Wood's website.
And did you perform work on both of those cases?
Oh, yeah, a lot.
And we've heard testimony from Nicole and Taylor about the business cards, the email signatures, and the letterhead all at Ellenwood PC. Was yours the same for all that? It had this information we see here on the website?
Yeah, I had the same stuff, the cards, the email addresses, the email block on my emails, my email, all of it's the same for all of us who were partners of Lynn at Ellenwood PC.
And did you ever perform any work outside of Ellenwood PC during the time that you worked there?
No, I didn't perform any legal work for any other firm. I worked for Ellenwood PC and I did it full-time and then some.
And did you also have access to the Ellenwood PC Dropbox online server that we've heard about?
Yes, so, Ellenwood PC had a Dropbox where it kept all of its files, all of its client files, and it's important in the law in terms of who gets access to your client files. Only people in the firm can get access to the client files. In fact, Lynn, at some point, he had an actual office sharing arrangement with Stacey Evans where they worked on 3 cases together. And she had a limited area in Dropbox, LLW PC shared, where she had access to the 3 cases that she worked on with him. Whereas the rest of us, the partners of Ellenwood PC, Taylor, myself, and Nicole, had access to the rest of to all of it, all the 200 different client files, because we were part of the firm, not a separate firm.
And were there any other differences between WGW and Stacey Evans during this time?
Sure, Stacey Evans practiced law as SG Evans law. And when she filed, so we've talked a lot about pleadings. It's kind of technical terms. The things that we file to courts, when we submit a document to a court, we call it a pleading. And you always have to sign your pleadings. You have to put your signature block down there explaining what firm you're from, your email address, and you sign it. Everything we ever signed while we were at Ellenwood PC, from the time I was there from 2014 when the name changed to 2020, was signed Jonathan Grunberg, Ellenwood PC. Stacey Evans, once she left and became had an office sharing arrangement with him, she would sign a separate signature block that said SG Evans Law. She was no longer a lawyer of L. Linwood PC, despite the fact that she actually rented an office from him in that same office space we were in.
And what about Miss Evans' clients' funds during that time? Did she have maintained different bank accounts than the Ellen Wood PC bank accounts?
Yes, my understanding is that she had a different, so lawyers have to be very careful with their money. I think there was testimony about money being kept in a trust account from a settlement. And what lawyers basically usually have two types of accounts. They have a trust account where the client's money is kept, and you don't touch that when you're the lawyer. You hold it in trust. And then you have your operating account, which is where you pay for things out of as a lawyer. And so that trust account, my understanding is that Lynn had his own trust account, Stacy had her own trust account. And when we were partners of Ellen Wood PC, and it's even in that agreement, that proposal in the Happy Camper email that Lynn sent to us, he said, you will be using the Ellen Wood PC trust account because we all shared clients and all the funds can be put there together because we were partners in the firm.
What about billing hourly clients? How did Miss Evans during this time bill her hourly clients? Did she have access to the Ellen Wood PC Clio system?
I did not see Miss Evans have access to the Ellen Wood PC Clio system once she became SG Evans. So the Clio system is like this software we use. You access it online and you put your hours in for the hourly cases we worked in. For some contingency fee cases that we expected to get an attorney's fee award. Once Miss Evans was out of the firm and had SG Evans Law, she was no longer putting her time in to the Clio account for Ellen Wood PC.
And what about on the website? Was she still listed on the Ellen Wood PC website after she activated SG Evans Law?
No, she was no longer listed on the website. She had her own thing, SG Evans Law, and the website is, what y'all have seen eventually when it got changed, when Nicole and Taylor came aboard, and no Stacey Evans.
And once you got promoted to partner, the title of partner, did you also form your own LLC like Mr. Wilson did?
Yeah, so like Lynn put in the Happy Camper email, he said you should form your LLCs.
I've lost track of they keep referring to the Happy Camper. I thought it was, could I get this identified by exhibit so we could look at what they're talking about?
Sure.
Sure.
5
Thank
All
you.
right, plaintiff's exhibit 5. Is the email in question. All right, to the extent you still had something left to say in the response, feel free to pick that back up, or if you got another question.
I don't know if I was done answering it, but in the Happy Camper email, exhibit 5.
If I'm looking at exhibit 5, it says I am not a happy camper. So they're mischaracterizing it and it's improper.
All right.
It's very precise. I am not a happy camper.
Okay. I think the reference has just been, this is the Happy Camper email, not getting into the substance of it. So
Well, if you're going to characterize it, they ought to characterize it accurately under the evidence. And it says, I am not a happy camper.
all right, understood.
It's not.
Overruled. You can continue.
So sure. In the Happy Camper email, Lynn stated, effective May 1, your LLCs will each be non-equity partners in LLWPC. So your LLCs will be non-equity partners in LLWPC. We started our LLCs because Lynn told us this is what y'all need to do. I'm changing the way things are done around here and you're going to need to get LLCs. So that's what I did.
And what was the purpose of you guys creating LLCs during this time?
It was for Lynn to be able to pay us. He didn't want to W-2 us anymore. He wanted to give us a 1099. And so we needed the LLCs to receive the 1099 from him when he paid us for working for him.
And what is your understanding of what a 1099 is?
It's just a way for like a tax form to communicate to someone that, hey, I've given you money for something.
And can you get paid through a 1099 and still be a part of a law firm?
Certainly. I think a lot of lawyers in this town get paid as 1099 from the law firm that they work with. That is nothing unusual.
And did you ever have any active law firm through these various LLCs we've heard mentioned during the time that you worked at Linwood PC?
Never. I had no, we started we had WGW LLC when Lynn thought he was just going to go out and be alone, open up another office and with Kimmy and go do his thing. Then he decided when the Steve Wynn case came in, actually, let's all get office space together and be back together. So at that point, Taylor and I started our own. I have JD Grunberg LLC. He has his, I think it's G Taylor Wilson LLC, and Taylor and I did Grunberg and Wilson LLC. None of those things have ever practiced law as a firm. None of those that I described have ever had a website, letterhead, an email address, appeared on a pleading, any of those filings at court. None of those names have ever appeared other than, now WGW, of course, is active after we left Lynn's. But before we left Lynn, they were just LLCs to get paid from Lynn.
And what about for WGW LLC before you left working with Defendant Wood? Did it have a website, any clients, sign any pleadings?
Never. It's the same thing. I mean, once Lynn changed his mind about we'd all be together, I think WGW, Wade Grunberg and Wilson LLC actually went on inactive status. And then we restarted it in February of 2020 after we had to leave Linwood PC. So it's never practiced law before that point.
And did you generally enjoy the work that you got to do at Linwood PC?
Yeah, I mean, it was great. It was really high caliber, complex civil litigation. Lynn had an incredible reputation. People called him up from all over the country and all over the world. And we worked on just amazing cases together with a pretty great team.
And did your experience in working with Defendant Wood change at some point?
Yeah. By the fall of 2019, Lynn, became very difficult to deal with. He was being really abusive. Became really hard to just have conversations with the man. It was a different Lynn than I had experienced. I think that's 19. I'd known him for 7 years at that point. He'd always been he's a passionate guy. He'd always had his fire. But he was a different guy in fall of 2019.
And at this point, I'm going to point you to take a quick look at Plaintiff's Exhibit 74 and 74A and ask you to tell us what this is.
So 74 is the transcript and 74A is, I think, going to be the recording of a call I had with Lynn on February 10th, 2020. So now we're in that week, that kind of critical week where things really came to a head with him and we had to leave. And he was, he was difficult to deal with.
And are these true and accurate copies on 74 and 74A?
Yeah, I had reviewed these before and they are.
Your Honor, at this point, I'd like to have Plaintiff's Exhibit 74 and 74A admitted into evidence.
Any objection?
subject to authentication in terms of who made the recording and when it was made. Other than that, I have no objection, but I think he's got to establish a foundation of who made the recording, when it was made, and who transcribed it.
All
Happy
right.
to do that, Your
Otherwise, I
Honor.
object to it.
I agree. Ms. Brown, next question.
Jonathan, did you record the conversation that is depicted in the transcript on plaintiff 74 and appears in the recording on 74A?
I did.
And was it made at the time that this call occurred on February 10th, 2020 at 3:15 PM?
It was.
Not at this point.
Retender?
Yes,
All
Your
right.
Honor.
Do you renew your objection, Mr. Wood?
No, Your Honor. Thank
All
you.
right. 74A are admitted.
Under the name of,
Oh, I said Laryngeus.
what is that? Remind me.
That's a trust and estate case from Nicole that we're dealing with discovery right now.
Great, you're working on a case where you're gonna make more money than me, and you and Nicole are gonna make more money because I gave you the right to do it in my office. What else you work on besides the case with Nicole where you're gonna benefit more than me? What else?
Today?
Jonathan, I know you're tired, and I saw you sleeping when I was trying to get you to listen to me. You were so uninterested and disinterested that you gave me lip service by coming over here and you fell asleep. I asked you today, what have you done today? You told me you read an email. You told me some undefined, just something in a little rant.
Feel free to start it back over. I'm just having trouble.
Michael, do you have this one loaded? We'll try. Thank you for letting me know. We'll try it on the screen.
Oh, I said Laryngeus.
What is that? Remind me.
That's a trust and estate case from Nicole that we're dealing with discovery right now.
Great, you're working on a case where you're gonna.
I said Laryngeus.
What is that? Remind me.
That's a trust and estate case from Nicole that we're dealing with discovery right now.
Great, you're working on a case where you're gonna make more money than me, and you and Nicole are gonna make more money because I gave you the right to do it in my office. What else you work on besides the case with Nicole? You're gonna benefit more than me. What else?
Today?
Jonathan, I know you're tired, and I saw you sleeping when I was trying to get you to listen to me. You were so uninterested and disinterested that you gave me lip service by coming over here and you fell asleep. I asked you today, what have you done today? You told me you read an email. You told me some undefined, just something in a little ranch, some trust case. You a trust and estate lawyer?
I'm not.
Yeah. Then you're in the wrong firm if you're a trust and estate lawyer, because that's not who I practice law with. Nicole gets there because she can make $1 or $2 on trust and estate that she can't make anywhere else. But nobody's gonna come to her for the kind of case I handle if you wanna handle. I thought you wanted to be a damn defamation lawyer where we got a reputation. What do you wanna be? Trust and estate, working for Nicole, or defamation lawyer with the firm that could be the best in the country? What do you wanna be? You write me down an email and send it to me so I'll know who I practice law with and what they want. I thought y'all had enough sense. I'm tired of this. I'm tired of practicing law. I'll tell you what else I'm tired of. I'm tired of the fucking president of the United States. He's treating Richard Jewell like a piece of shit.
Okay.
He put him down at the bottom of the calendar. You know what? Y'all, is Caleb every day or is he too busy doing something else?
He's here.
Is Nicole there?
No.
She'll say she didn't come in, but she stayed there and talked to me all night. She stood here and listened to me to check the box. Nobody talked to me. Jonathan checked the box by going to sleep. Here's what y'all all do. Did y'all do that?
Yes.
Y'all all gather in the damn conference room. I suggest a small conference room where nobody can hear what I'm gonna say. We're gonna put it on speaker and we're gonna straighten this mess out right damn now. You hear me?
Yes. Do you want me to send your email to Carboni or did you send it on Saturday, the one I wrote?
Are you fucking stupid? Did I just tell you to get in the damn conference room and call me and then you want to talk to me about something I didn't ask you about?
You asked me about Carboni to start the conversation.
That Carboni is the first part of the call. That's what the next stage you call. Now you want to tell me to change the subject matter. You're not going to tell me anything anymore, John Grunberg, because I know you're not going to be a leader. You better start being a follower. But you're either a leader, a follower, or get the hell out of the way. Damn sure don't get somebody to create obstacles. Get everybody in the substance of all the big concepts. I don't care. I don't have to go away this way. I don't want to know whether give a damn about this law firm as a group.
Volume problem again, Judge.
That's the question I want you to answer. And then I want you to list for me the reasons, the things about this law firm you care for as a group. Then on the phone call, we're going to listen to you, what you care about. So pick your words carefully. Because I'm going to ask you what you've been doing about your cares for the law firm, okay? Because I'm tired of y'all's lip service. And do everybody understand what I want you to do?
Yes.
Nobody wants to take orders. Everybody wants to be a leader. I'm going to give you a chance to be a leader if you don't ask the questions right. Do you hear that, Jonathan?
Yep.
Because Jonathan, I love you, but you're not a leader yet. You're not qualified. All you do is criticize the leader. You're not even a good follower. You want to damn tell the leader what to do. You know what the third choice is, Jonathan?
Yes.
Leave, follow, or get out of the way. I'm going to find out if y'all want to get out of the way. Because if you do, I'm going to let you get out of the way. I'm going to get out of the way for you. But you're creating obstacles for me. Because you're disagreeing with me and questioning me. I've had enough of it. I haven't talked to my kids, and I don't intend to talk to my kids in days. My daughter came to town this weekend. She didn't bother to come back to see me. That's the way my law partner treats. Call me back when you're ready to answer that question. If Taylor thinks he's important, got something else more important, I'd like to know what it is, because I don't know what the hell he's working on. If he's working on Sandmann, he's pissing around taking way too much time to close the damn case. I don't know what else he's working on. They must have cases I don't know about. I think you're working on your own shit. On my time, under my name. I'll talk to y'all when you're ready to call me back with an honest answer of whether you want this law firm to work together as a group. And then I want to know, okay, what is it that you want? What do you care about this law firm? What do you think it takes to keep this law firm working as a group? For me to get out of the way and not create too many problems? No, I haven't done that. I don't think it's me. Don't answer that question. No, let's do this. Let's do this. You still there, Tim?
Yes.
Let's take it from the positive side. Ready?
Okay.
Before Nicole comes in, here's what I want you to do. Give me each of y'all's top two. Jonathan, you think you can explain one of the things to me for Taylor, so I have to call him and tell him what I told you?
Yeah, what's that?
So change your tone of voice with me, number one, young man. You hear me? You're still a young man to me. I'm your elder. You people are going to start treating me like that. I'd suggest to Taylor that he put his damn ego like you need to put your ego in check. Because we're going to find out who's going to lead this law firm, who's going to follow in this law firm, or who's going to get the hell out of the way and stop being an obstacle, being part of it. We'll have the conversation with Nicole separately. Because I'm not sure why we all put her name on that. I'll find out when you write it back. I know why her name's on there. I want to find out if you know why it's on there. Make that your second question. Why is Nicole Wade on the end of this law firm? Why is she a part of this law firm? That's your second question. I want to know what you honestly think why she's here. Okay? And then why don't we do this? Why don't we also start on the front of the list? Why don't you put a quick list of why you think Lynn Wood's the first one on the list? Why is Lynn Wood in this law firm? Now, read the assignment back to me because I changed it. I'm sorry.
Okay. Top two things that will make the firm better.
Make that the last question.
Okay. Why is Nicole Wade in the law firm, and why is her name on the door?
Now, you didn't listen to me. Let's start again. Tell me when you write it down or type it so you get it right. Are you ready?
Yes.
Let's start with that one.
Why is Nicole Wade a part of this law firm in your opinion? Question mark. You got that? That's gonna be the subject of the discussion. You don't need to write me anything. I'm just gonna give you a heads up so you can think about it for 10 to 15 minutes. You ready for the second question?
Yes.
Make it the same question with Lynn Wood on instead of Nicole Wade. Those are the two questions I want you to ask. Forget about what can make it better. We're gonna find out what's gonna make it better when you answer those two questions. Jonathan, those tough questions? You understand where I'm coming from, John?
I do.
Make sure Taylor understands. Hey, I hear the smart ass in your voice. I do. You should say I do, Glenn. You should speak with me respect, young man. You ain't gonna be in my law firm. You hear me?
I do.
You told me that. Nicole told me last night to rip her name off the door if I didn't like the way she did business. I said, you really want to commit professional suicide?
Jonathan, did defendant Wood ever express any frustrations to you about any efforts to get Richard Jewell the Presidential Medal of Freedom?
Yeah, he did, and they were generally coupled with frustrations about getting himself the Presidential Medal of Freedom. He was at this time kind of intent on trying to get the Presidential Medal of Freedom for Richard because he thought that he could piggyback off of it and get to go meet the president.
In the world, he's coming up with that.
Mr. Wood, that's his opinion, and you're gonna get to cross him on it. I know it's an issue of fact.
How am I supposed to
We're
cross somebody on-
testifying again, Your Honor.
He's
It's not
testifying.
an issue of
He's
fact.
testifying
He's
again.
Okay, Mr. Wood,
It's improper.
could-
You have an opportunity.
you can approach if you need to, if you want to put something on the record, okay?
Just make sure you keep it loose. I understand you disagree with me personally. That's not where I'm going.
False. He doesn't have any basis. State that he knows my thoughts.
Okay.
If he's got some document or he's got some trend, then put that in and let him discuss it.
Okay.
But
I understand the best of your judgment.
Yeah, I think it's a good.
All right.
All right, I'll direct counsel on this particular issue. Why don't you first explain why he has the basis for this opinion, and then you can ask him for his opinion. You can proceed.
Jonathan, did defendant Wood ever tell you anything in regards to his efforts to get himself or Richard Jewell the Presidential Medal of Freedom?
Yes, it was, in that point in time, it was kind of his obsession, starting, I think, in around mid to late January of trying, and he would talk to us about it quite a bit, about wanting to get the Presidential Medal of Freedom for Richard Jewell, and that he thinks he is going to be able to then get it from himself. And my impression of it, in having those conversations with Lynn and knowing him at that time, was that he was using Richard's name basically to piggyback into getting it for himself and to be able to meet the president. He was talking about grand plans of flying a bunch of people up to Washington, D.C. and that he's probably going to get the Presidential Medal himself. So that was my understanding and how I got it, including it happened just that morning of February 10th. I just heard myself on that recording. I was tired because Lynn had just seen the Richard Jewell movie, called me over to his home at around 1:00 in the morning saying it was like a matter of life or death. Talked to me for like 3 or 4 hours, and Nicole as well, at his house that morning. Like, I tried to stay awake best I could. I had like 18-month-old twins at home, pretty exhausted. And he talked to me in that conversation too about getting the Presidential Medal of Freedom for Richard and for himself, and flying up to Washington, D.C. for all of it. So that's my basis.
And any efforts that defendant Wood may or may not have taken to get Presidential Medal of Freedom for himself or Richard Jewell, did it have anything to do with you?
Absolutely nothing. I was not involved in this forum. I didn't talk with people about this forum. That was kind of Lynn's own obsession.
So did you ever say or do anything that would have gone back to the president or impacted whether Richard Jewell received the Presidential Medal of Freedom?
Nothing. I had zero involvement with any of that.
Thank you. And I'll direct you to take a quick look at Plaintiff's Exhibit 90 and 90A and tell us what this is, please.
So Exhibit 90 is a voicemail that Lynn Wood left to me on my telephone at about 7:27 a.m. on February 17th of 2020. So again, that week where we left the firm.
And are these true and accurate copies at Plaintiff's 90 and 90A?
I also reviewed this before and helped make this transcript, and it is a true and accurate copy of the recording of that voicemail, which is 90A from my understanding.
And did you receive that voicemail on your cell phone at around the time that it was left at 7:27 a.m.?
I did.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 90 and 90A admitted into evidence.
Any objection?
No objection, Your Honor.
All right, it's 90 and 90A is admitted.
I'm gonna be a little calmer with you than I've been with Taylor and Kimmy on their voicemail messages. Jonathan Grunberg, you sorry, slimy piece of shit. How do you look at those babies? I've got it all. I know what y'all been doing. But here's your problem. You teamed up with Rick Miller. He's going to federal penitentiary. I'm afraid y'all need criminal defense. In fact, I know. I've been up all night dealing with this. I've locked it all down. I can prove everything you did. Every email you played with. Everyone's coming back at you. Every document deleted. I can get it in 120 days. I got people on it right now. They're on my way here to mirror image my hard drive. The FBI is going to be knocking on your door, Jonathan. You need to go get a criminal defense lawyer. Somebody in that damn former piece of shit firm I had better get on the phone and tell me the damn truth, or I can tell the FBI that at least somebody's going to be good to him and cooperate. You got in bed with Rick Miller and you manufactured shit from Jane Levinson, and you tried to hurt my kids. In the process, you look at those two little babies, you hurt them. You look at your wife, you hurt her. You're not going to get one thin dime from me about anything. You might even get sued by me. What the hell were you thinking? Man, oh man. You glad I'm not with me right now in an elevator, buddy? You're damn lucky. I'm that mad. If you come over here to tell me the truth, make sure you give me a heads up, because I'm going to make sure that the FBI or someone from the Atlanta Police Department is here so they can be between you and me. That's how serious it is, you little fucker. You look in the mirror and you're going to see a Chilean Jewish fucking crook. Goodbye, Jonathan. You better get somebody to come over here and tell me the truth, because it's coming out the hard way, buddy. It's coming out the hard way. What did you do to Chelsea and Kimmy? You sorry bastard.
Jonathan, did you have any idea about any of the allegations that Defendant Wood was talking about in this voicemail he left to you on February 17th?
He fabricated all of that. I had no idea what he was talking about other than things that he was making up to try and intimidate us, is my understanding, to try and hurt us. It's just a lie. Nothing ever happened with that.
And did you receive other threatening voicemails from Defendant Wood during this time period?
I did. He kept the pressure on.
And we've heard a lot of testimony about the Sandmann matters and that litigation. And I believe yesterday we heard testimony about an initial meeting with Todd McMurtry with you and Taylor and Defendant Wood. Do you remember that?
Yeah.
And how did Defendant Wood refer to the two of you guys, Taylor and you, when you first met Mr. McMurtry?
when we first met Mr. McMurtry, I think actually we crossed the river maybe, and we were in Cincinnati. And he introduced us to Mr. McMurtry and the Sandmann's family as his partners.
And can you briefly describe to us what kind of work you did on the Sandmann matters?
Sure. I did, pretty much everything on that case alongside Taylor, other than argue in court, drafting the complaints, drafting, retraction demands, analyzing all the complex media that was pumping out incessantly, helping actually edit a script for this video to try and get the truth out of what actually happened, going to the hearings, preparing Todd McMurtry to argue for the hearings, writing briefs. I mean, everything.
And approximately how many hours would you say you worked in that first month the Sandmann matters came in? Would you say it's equivalent to what Mr. Wilson testified to?
Yeah, I mean, hundreds. I think Taylor did a bit more than me. There was a point, because I had to travel a little bit. I had to go out to Washington State to get braces for my legs to try and walk better. And I remember, though, being out there in Washington trying to fix my legs and working alone in the hotel room on the Sandmann case. I mean, it was like a fire hose, drinking from a fire hose.
So all-encompassing type of work in the beginning.
Correct.
And what do you believe is the value of this type of initial legwork that goes into litigation cases like this?
The value, look, Lynn is a great attorney. You heard it from Todd. You heard it from us. He's the big name on the door, and he has a lot of value in not only having that name, but his strategy for these cases as well, and talking with us. And he's a smart guy. He's a good lawyer. But he also can't do a case like this without a team. It was a complicated case. It was, Nick was this high school kid who was on the steps of the Lincoln Memorial with other high school kids. They were on a high school trip. At some point, this group of Black Hebrew Israelite protesters started.
Bill is over here signaling his witness. That's inappropriate. But I'll help him because he's asking me to move on. This is irrelevant. A general description of the Sandmann case is sufficient. Going into the details of what happened that day in Washington, D.C. is a waste of our time. It is what it is. So I object.
All right.
On behalf of Mr. Bill, who is objecting.
Mr. Bill, if you want to respond, you can.
Do I need to? It's another fantasy.
All right, we'll leave it there. But I do believe the witness has testified. It was a complicated case. I don't think there's any denying that. I think we can move along.
Yes, Your Honor. Thank you.
So it took a lot of work to kind of unravel everything that happened here. And that was work that we did as a team, Taylor and I, and then Nicole coming in and really being phenomenal in writing the briefs for getting the case turned around. So yeah, there was a lot of value to Lynn in having this team to be able to do that kind of case. He couldn't have done it without us.
And in your opinion, what does it take to win one of these big type of defamation lawsuits?
In these kind of defamation lawsuits, you're going up against the best First Amendment law, like defense law firms that represent the media, the best law firms in the country. And so these cases aren't, it's a different vision. It's not like decided in the courtroom often enough, a lot of the things. It's a lot of paper going back and forth, hundreds and hundreds of pages of paper, thousands and thousands of pages of paper, complex brief writing, doing legal research. And to go up against those folks, you got to have a team that can do that kind of writing, that kind of research, move that kind of paper. And if you can't, they will steamroll you. And so there's a huge value.
And these big defense defamation law firms, how many people on average is on a team for one of these large defamation lawsuits, would you say,
On our side or on the defense side?
on the defense side?
You know, they'll usually be staffed with something like 3 lawyers who are heavy on it, and then bringing in a bunch of pinch hitters all the time. So they have like a bank of lawyers. They can bring in 5, 6, 7 lawyers, as many lawyers as you want to bear. And in the Sandmann case, what was interesting is that it's us 4, suing all these different companies with all their different lawyers, filing all these different briefs. It's a David and Goliath type of situation. Washington Post has its lawyers, NBC has its lawyers, CNN has its lawyers, and us 4 have to go up against all those folks and win.
And throughout your time working on the Sandmann matters, approximately how many hours would you say that you worked?
Hundreds. It was a contingency fee case, and so I didn't track my hours as we did, like we didn't do with all those contingency fee cases I had when I was a partner of Ellenwood PC and for years before, other than the few where we could recover attorney's fees. And so I don't know precisely, but it is hundreds and hundreds of hours.
And at that time, when you were at Ellenwood PC, what was your hourly rate for billable cases?
At that time, it fluctuated, I think, between like $450 an hour to $550 an hour, depending on the engagement.
And what percentage of the total hours worked on all of the Sandmann matters were performed by the one of you 3 compared to defendant Wood?
I think it has to be like 90% of the hours compared to Lynn that we did working on that case.
And what do you think WGW's fee would have been if you would have computed it on an hourly basis?
I think it would have been as much as what he promised to pay us in that case. On that, I think it would have been, you know, high 6 figures at least.
Your Honor, at this point, subject matter wise, it's a good
Okay.
pausing point. if we
All
want
right.
to keep on.
Then with that, members of the jury, we'll take our lunch break. I'll ask you to not to discuss the case with anyone, including amongst yourselves, not to do any research about this case. Let's reconvene and see if we can get going again at 1 o'clock. All right. We'll see you then.
Thank you, Your Honor.
Yeah.
All right. And so at 1 o'clock, you're saying you have another witness who's going to sub in here? at that
Yes, Your
point?
Honor.
Yes, we think we can interrupt him just for like 15 minutes and then finish him.
Okay. And as I took it, there was no objection from the defense earlier for that. And
Whatever works easiest, hoping I'm gonna get on the road a little bit earlier.
Thank you.
what's the name of this witness, just so I have that?
Tyler Jones.
Tyler Jones. All right. So we'll reconvene at 1. If there's nothing else that needs to be taken up right now, we'll see you at 1 o'clock with Mr. Jones.
Thank you.
I'll
Thank you,
instruct the jury.
Judge. I just like control. So you're moving on. Do a little trolling. Let's go there. We got an hour. This is like luxury.
So you know he
All right,
had
you ready yourself now?
you know he had a calendar for Wednesday.
Yeah. Listen,
It's
12:30. Well, I'm gonna step. I didn't mean to interrupt. I'm gonna go downstairs. Smoke my sin stick. So I can bring it in my side. I keep asking God to remove it. Then we're gonna come back into this room and go lunch. We'll be able to get in.
Yeah, I'm gonna leave that like that.
Don't you? You know, eat it.
She's on.
Share it with her.
Mhm.
All right.
Jones, thank you. Okay, thank you.
Let's do that.
Oh, King. So what about O'Neill?
Keep coming out.
Are you in that deal?
You go check, and then we'll make sure they change.
Okay.
Because I've got some things. You know what?
Yeah.
Okay, well, you guys.
I'm scared to get my mom.
Because
Yeah. They said I should be getting one in 3 weeks. I think my battery almost dead.
And they got the bags over there, they can swap. Yeah, I had mine swapped out, but it did not go for those late things. Go for my name, I think. Nice. So they want both your lights on you.
You know what? Oh, I'm going to call the way. I wonder which one too. I wonder which one. I gotta go help Scott. I'm gonna call you. I gotta go help Scott get an inmate. Yeah. Yeah. She don't pay for it or whatever, but you just find that. Wait, we don't take something like that? Okay, I'll wait. I just got 2 chicken dogs.
No, but 12:30. I mean, after Jeff come out, you know. Fine, time. See, O'Neill was supposed to be on that virtual thing, so he ain't gotta come out, just he come.
Okay.
With bad music, so every time he write a song or somebody sample a song, he get paid for it.
Okay.
That's why
That's
he
great.
didn't make it. We went, they went, his wife, they know you. And that lady.
No. Miss Washington and Mr. Pendleton, who's handling the plea?
Hey, Ms. Waters, I'm handling the plea for my case. My case is Michael King. I'm not sure if Mr. Pennington has anything.
You need to talk to him.
Yeah, I did the indictment, can you sign it?
You got the key, right?
Yes. I think it's 12:30 anyway. I'll try to rush it. Mr. Pendleton, are you just observing? Are we missing a case?
I could call him and ask him.
Yeah, I sent him a message, but I didn't get a response.
Um,
Are we ready to kick this thing off? You need me to come in?
Mr. Sandmann is signing the defendant up now. If you want to come on out,
Yeah, I'll be in a minute.
okay. Ms. Smith, are you with us?
yes.
Thank you. Mr. Kuzu?
I'm here.
Thank you. That was out, chipper.
Let's see. It is.
Washington is on,
Okay, great.
so just wait myself. Civil attorneys, they always have a lot.
Always got all their paper, all their stuff. And then Richard Marks rolls in with just a manila envelope.
We just.
Let's
we
try to
were
murder
told
him.
today, he came down.
He what?
He came down to our office. I think he
Oh,
or something.
nice.
And I looked in his folder, it was a manila folder, one piece of paper.
One piece of paper
The
in it.
whole case.
Yeah,
And everybody else, big folders.
yeah. He did fine though.
And his folder consisted of 2 paragraphs.
He'll get in there and
Yeah, get it done.
he'll get in there and, try a case though.
Yeah.
What is this? I gotta ask her what this thing does. I don't know what it is. Or maybe that's something they pass. It's supposed to be passing around. I don't know. I don't know what that is. I'll ask her. I hadn't seen that before. Our other court reporter is actually from Columbus. He works with a Superior Court judge in Columbus. And I guess they're off this week. Yeah, he's gonna be back with us. That's pretty interesting. It's like us loaning out Kamisha to go side hustle.
You hear that, Commissioner?
Not allowed.
I did.
Not allowed. We got too much to do. That's right. No way. No way. But I don't know if we just, if we get another 12 acquittals in a row or something, maybe she won't have to work on any transcripts anymore. What's he doing? We just signing the indictment?
Yeah.
Just tell him we're ready. He probably doesn't know we're ready.
No, he knows, because we're waiting on him.
And the judge ratings on the.
Is this case gonna wrap up today?
No, I don't think so. I'm hoping Wednesday.
Remember, we're live.
All right, are we ready to go on the record, Mr. Simonoff?
Yes, Your Honor.
Okay, then let's do that. We're on the record now with 23 SC 190787, State versus Michael King. Mr. King's present here in court along with his counsel, Mr. Simonoff. State's here through Ms. Washington. And Ms. Washington, if you swear, Mr. King, we'll proceed.
Yes, Your Honor. Can you please raise your right hand? Do you solemnly swear or affirm that the testimony that you will provide to the court is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can lower your hand. Can you please state your name, age, and date of birth?
Michael King, I'm 28 years old, 7/29/96.
Are you not under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
College.
Can you read, write, and understand the English language?
Yes, ma'am.
Have you had an opportunity to review the document that charges you in the case today?
Yes, ma'am.
And do you fully understand the nature of the charges or the charge pending against you?
Yes, ma'am.
Do you understand that by pleading guilty today that you are giving up the following rights? The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself.
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on this charge by jury?
Yes, ma'am.
Do you understand that you're pleading guilty to one count of aggravated assault with a range of punishment of 1 to 20 years?
Yes, ma'am.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything anywhere?
Yes, I'm on probation in Fulton County.
Do you understand by pleading guilty today that your probation will almost certainly be revoked?
Yes, ma'am.
And Judge, the incident date on this offense was before he was put on probation, so I don't think that he can be legally revoked.
All right, understood. Do we have Ms. Akuzu joining us?
Yes, Your Honor, I'm here.
All right, welcome. Is there anything from probation you think we need to take up?
What was the offense date, Your Honor?
8/19/21.
No, there's nothing we need to take up.
Understood. Ms. Washington, you can proceed.
Thank you, Your Honor. And this is a negotiated plea, and the state has made the following recommendation for count 1, aggravated assault, 5 years probation, with the special condition that upon your release, that you're to complete the Family Violence Intervention Program and have no contact with Javonda, Javonda Perry, Perry.
Ma'am.
Should the court sentence include a period of probation, you will be required to obey both the general and special conditions of probation. Do you understand these conditions?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything that we have talked about today?
Yes, ma'am.
Has anyone used any force, threats, or promises which have caused you to plead guilty against your will?
No, ma'am.
Do you have any questions for your attorney before you proceed?
No, ma'am.
Understanding all of your rights, how do you wish to enter a plea to the charge today?
Guilty.
And is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you'll have one of two ways to do so, and your attorney can further advise how each way works. The first way is through a direct appeal, and you'll have 30 days from the date the sentence is entered to file this appeal. The second way is through a habeas corpus petition, and you'll have 4 years from the date the sentence is entered to file this petition. Your Honor, had this case gone to trial, the evidence would show beyond a reasonable doubt that on August the 19th of 2021, officers responded to 100 Bell Street Southwest. Witnesses told officers that they saw the defendant assault Ms. Javonda Perry by choking her until she passed out. Officers observed multiple abrasions and lacerations to Ms. Perry's neck and face. Ms. Perry had been in a relationship with the defendant for about a month until she moved out. Ms. Perry was transported to Grady for treatment for a bite mark to the left side of her face, lacerations to her neck and her face area. Your Honor, the state made this recommendation after speaking with Ms. Javonda Perry. She was in agreement with the state's recommendation. That's all from the state.
Thank you, Ms. Washington. Ms. Simon, have anything to add here?
Yes, Your Honor, I would ask for credit for time served. He's been in several times in and out between the date of arrest and today. I think by my calculation, that's about 404 days of credit for time served. So I asked that be applied towards the sentence. And I asked that this sentence run concurrent with the sentences that Mr. King is on probation for. He got put on probation for those cases that occurred after this incident date. They were just resolved quicker than this one. I'm not sure why, but that's just kind of the order that things happened in.
All right, not for lack of trying in this docket.
Right.
All right, just making that clear for the record. So, Mr. King, you understand the nature of this charge?
Sir.
And you still wish to waive the rights that were explained to you and go forward with the change of plea? You're doing that because you committed this offense?
Sir.
Mr. Simon, are you satisfied your client is confident that this plea is knowing and voluntary and that there is a sufficient factual basis?
Yes, Your Honor.
I agree. I'll make those findings that there is a sufficient factual basis and that this plea of guilty is knowingly, voluntarily, and intelligently entered. And so I'll sentence you, Mr. King, as recommended by the parties on the sole count of aggravated assault. The sentence would be 5 years to serve 15 months with the balance on probation. You'd receive full credit for all the time you served since this incident date, which is over 469 days. The special conditions here would include that you're to complete the family violence intervention program. You're not to have any contact with this victim. And for any technical violations while you're on probation, like failure to report, those will be handled directly by your probation officer with a sanctions cap of PDC or RSAT under the sentencing options system. And Ms. Washington, do we have permission on your part to sign the indictment indicating the change of plea?
Yes, Your Honor.
All right. So, Mr. King, do you have any questions about anything at all we've covered here today?
No, Your Honor.
Ms. Akuzu, is there anything that you need to instruct Mr. King on?
Yes, I just need his current address.
What's your address?
1256
Okay.
Chambers Road, McDonough, Georgia, 30253.
All right, let's see. What county is that? I'm sorry. Henry?
Yes, ma'am.
Okay. All right, so you're going to report to the Henry County office we'll do next Friday on the 16th. You're going to report at 1335 Citizens Parkway, Suite B, Morrow, Georgia, 30260 at 8:30 a.m. I'll also text it to Mr. Simonoff as well.
All right. Thank you, Ms. Kuzu. Then with that, we'll be off the record. Good luck, sir.
Judge,
Oh.
just one, I'm sorry,
All
one
right.
final thing. There is a matter of a bench warrant that I'd ask that be dismissed pursuant to the sentence.
I'll be on the final decision. Take care, Mr. King. We're off the record. Take care, Ms. Smith.
Judge.
Thank you, Judge.
Bye, Judge.
Any different from what we put on the disposition? Okay.
No. As long as it says that it's dismissed on there, I think the jail has been working with those dispositions now, so
All
at
right.
least I haven't had trouble with it recently.
Glad that one worked out.
Yeah, me too.
You have any others?
Well, I've got one, I don't know if you noticed, but I had one this morning where I was like, I'm ready for trouble now.
I wasn't on, I forgot. I completely.
Bye, Cheryl. Bye, Attorney Simonoff.
Bye. Thank you.
You're welcome.
It's probably getting no prost. But I'm
Who is
following
it?
a speedy today, Michael Williams,
Oh,
it's that hate crime case.
okay.
But I'm following a speedy on it today, and I'm gonna see if I can get it off of that. for June.
Okay. You add it?
I need to cut the line on that. Doesn't get across.
Okay, it would definitely add it.
We don't have court till Tuesday, right?
Yes.
Okay.
No, you have Monday. You have.
Oh, right,
Turn the calendar.
did he ever get back to you?
He did not, but I'ma still,
Okay.
it's via Zoom, so don't come in.
Okay, that's fine.
We can put you in a breakout room.
Yeah, that'd be great. I just want to convey, because I wasn't here when he was last here, so I just want to convey the offer to him, see what he says.
Okay.
But yeah, I'll just zoom
It
in.
looks like he may have other counties.
Yeah.
Based on the booking screen for Turner County,
He's got holds out of,
something. I didn't show a hole for us.
well, I know that, he bonded out here in West Turner, so he shouldn't have a hold here.
Yeah.
But I think he picked up new charges, like they did charge him a riot or something.
Yeah.
Yeah. Okay,
Thank you.
thank you. Talk to you later.
All right, have a good weekend.
Have a good weekend.
You know, Mr. Marks is going on a cruise.
What's that?
Mr. Marks is going on a cruise Monday. He let us,
Yeah,
everybody let
that's
us know.
Is this going through next week? It is? Okay, all right. Have fun.
Yes. All right.
Hello, sir. Hello, Nicole. Hello there. How are you? Haven't seen you in a while. Have seen you in a while. Welcome back, John. Welcome back, man. Saying in crops, and I can't use one saying.
Y'all are right there, right between. No, other side.
Main seat, but now come order.
John.
Yeah.
That's fine. So it's the same.
All right. I guess Deputy Scott, if we could get a head count whenever you're able to. I'm wondering, what is this?
That is the microphone. The microphone.
So we should be passing this around during the bench conferences, maybe?
No. If you guys have a bench conference, I just make annotations stating the bench conference so the transcriptionist knows that's part of the record.
What happens when I
That's
do
just to
that?
indicate it's working. And this is my echo. Like,
Okay, all right,
if you
gotcha.
guys do, I always make a note, so when they, if something, they'll they won't
Okay.
consider it.
Well, I mean, I
But
just
yeah, and this is just like, yeah.
got it. Okay. Because there's some, I might have to look into this at some point. I've seen some where I press a button and it does a white noise.
Oh, yeah. You know, I love when the court, these are the kind of do it, so.
I'm going to have to look into that. Okay, just you can stay right there. Let me check in with the parties. All right, let's go back on the record. Is there any reason we can't bring in the jury on behalf of the plaintiffs? Anything on behalf of the defense?
Oh, bring him in, bring him in. Let's get the circus going.
Here we go. If we could bring in the jury.
We'll have to announce him in a bit.
Is he outside?
Yes.
Just gonna bring him in.
Oh, okay. Okay, thank you.
Yeah. Awesome.
All right, sir. Feel free to just go ahead and come on up here and have a seat. We may need to clear out the exhibit binders here.
True.
So he has some elbow room.
You grab the binders to have.
All right, for the jury.
Yeah, he doesn't need them.
Okay.
Thank you, Deputy Scott. Thank you, everyone. Please be seated. Welcome back, members of the jury. Thanks for being back and on time. There's a lot of logistical things that happen behind the scenes to make a trial happen. One of those is sometimes witnesses have scheduling conflicts. So we're going to pause the testimony of Mr. Grunberg right now. We'll pick it up later. In the meantime, I've been told we have some brief testimony on another witness on behalf of the plaintiff. So if you can, plaintiff can call this witness.
Thank you, Your Honor. Plaintiffs call Tyler Jones to the stand.
Raise your right hand. Do you swear affirm that the testimony you should give the court is the truth and nothing but the truth to help you God?
I do.
Would you please, while speaking to the mic, state and spell your first and last name?
Tyler, Tyler, Jones, Jones.
Mr. Jones, can you tell us how you're employed?
I work for Carmichael Consulting Solutions. We're an IT consulting firm.
And what is your title, if you will, at Carmichael Consulting?
President and CEO.
So you own the business?
Correct.
And how long have you had that business?
Just over 14 years now.
And I believe you said Carmichael provides IT consulting services. Can you explain to us briefly what that means?
Absolutely. So we provide computer and technology support to small and medium-sized businesses, everything from network security, computer security, cloud and service management, and so on.
And are you familiar with an entity called Linwood PC?
Yes.
And was that a customer of Carmichael Consulting?
Yes, they were.
Do you recall approximately how long that was a customer of yours?
From the time the organization was formed up until around late 2020, early 2021.
And during that time period where your business serviced Linwood PC, is it safe to say that either you or one of the folks that work for your business performed all the IT services for Linwood PC?
That's correct.
And are you familiar with Defendant Wood?
Yes.
And is your familiarity with him through your work for Linwood PC?
That is correct.
And for Linwood PC specifically, as a customer, did you provide these types of same normal IT services that you spoke about previously?
Yes, that is correct.
And are you familiar with Ms. Wade, Mr. Grunberg, and Mr. Wilson?
Yes, we serviced the entire firm.
And so during the time frame that they were there, you at Linwood PC, you provided IT services for them as well?
That's correct.
And did Carmichael Consulting set up Ms. Wade, Mr. Grunberg, and Mr. Wilson's email domains at linwood.com?
That's correct.
And are you familiar with how Linwood PC maintained its client files?
Yes, largely either paper or in a service called Dropbox for electronic documents.
And to the extent that you remember, do you recall who had access to the Linwood PC Dropbox server?
Originally, all of the attorneys as well as paralegals did.
Anybody outside of Linwood PC have access to that?
No.
And how was your company paid for its IT consulting services that it provided for Linwood PC?
There was a fixed monthly rate. We sent a invoice at the beginning of every month. For the previous month, we billed in arrears, and we're paid via check or ACH.
And was that payment, did that come to your office through Linwood PC?
Yes, to the best of my recollection.
And did it appear to you during that time that Mr. Wilson and Mr. Grunberg and Ms. Wade were part of the same law firm with Defendant Wood?
Yes.
And I'm going to turn your attention to the February 2020 time period. Did you go at some point to Mr. Wood's home?
Yes.
Why did you go to his home?
Mr. Wood had reached out to me directly. He was concerned and asked that I be there, to the best of my recollection, on a Monday morning. He was concerned that there had been an attempt to gain access to his home, as well as to his technology security. He was concerned that files had been moved or deleted.
And when you went to his home that day, how did Mr. Wood seem to you?
He was clearly agitated. He was very concerned. One of his neighbors was already there, as was an IT forensics specialist.
And what did you do specifically on that day at his home?
We basically checked his equipment. We made sure that there were no viruses or other tools on his machine that shouldn't be there. We ran both the native tool that we supply and a second one just to double check and confirm there was nothing there and there were no problems found. We looked at the logs for Dropbox for any electronic file storage to see if there were any large deletions or file movements. Didn't see anything there. There was unfortunately not that level of visibility into the email. Because of that, we had already started moving Mr. Wood to a more secure email platform, but that had not been completed yet. And we advised that if he was still concerned based on our findings, that he should probably leverage the IT forensics expert that was there to do a much deeper dive as kind of a specialist.
And did you or anyone at Carmichael Consulting that day see any evidence of Mr. Wood being hacked in any capacity?
Not in the checks that we ran.
Your Honor, that's all I have for this witness at this point.
Any cross-examination?
Thank you, Your Honor. May I call you Tyler, like I have all
Absolutely.
the time we work together? Well, how are you, Tyler?
Well, sir, how about you?
Well, you know, I'm hanging in there. Do you have a file with you on L. Linwood PC?
No, sir. Actually, we, as routine process for us, destroy all client information as soon as they're off-boarded.
And when was L. Linwood PC off-boarded?
It would have been sometime, I think, in 2020.
The last bill, if this refreshes you, that I have.
Objection, Your Honor. If you would like to refresh the witness's recollection, I believe the proper protocol is to show the witness a paper.
I think I'll allow a leading question if you want to get to the,
Yep, thank you.
just to move things along.
And I'm not suggesting I'm right, but the last bill that I could find from you was your invoice for August of 2020 for services rendered in July of 2020.
And that would align roughly with my recall, yes.
Consistent with your recall.
Yes, sir.
Thank you. Now, you had been to my house before February the 17th, hadn't you?
That's correct.
About how many times were you there? And at your church, you had a program where you provided clothing for people that needed clothing.
Objection, Your Honor. Relevance.
I'll tie it together.
All right, overruled.
You had that, did you not?
That's close. I was working with a nonprofit organization that was looking for donations of professional attire, trying to help people get employment.
How many armloads of suits and pants did I give you that you took from my house to take to your organization?
All right, if you want to establish the foundation, Mr. Wood, you can approach. I'm not seeing it, or the link, rather.
Just show.
In terms of what he's testified to on direct and what he's here to talk about today. But you can approach if you want to explain it to me. Otherwise, it seems like character evidence to me.
Sounds like what?
Character.
Thank my. Thank you, Your Honor. Tyler, without going into any specifics, but based on your relationship with me, did you find me to be a generous man?
Yes, sir.
Thank you. Were your bills always paid in full and timely?
Yes, sir.
If you had occasion to do work, let's say on Jonathan Grunberg's personal laptop, you would send that bill through L. Linwood PC.
I'm not aware of any instances where we serviced personal equipment. I could be mistaken in that. It would have been unusual, and because our agreement at that time was for, I believe, a fixed rate, a fixed bill rate, we would have included that gratis.
But if you had to do something specific to one of the laptops, and you did it at times for both Taylor and Jonathan and Nicole, right?
Correct.
And then you billed LN Wood PC,
That is correct.
but you do not know who owned the laptop that you were working on.
That is correct to the extent that it could have been swapped for one that we had purchased for the firm. We wouldn't have necessarily checked the serial number, for example.
Or it could have been one they purchased for themselves.
I can't rule that out.
And if you sent the bill to LN Wood PC, do you know whether LN Wood PC would charge one of the three, Nicole, Jonathan, and Taylor, for the cost of the work that you had done on their personal computers?
I do not know internal accounting procedures now.
All right, thank you. You have a recollection of I believe you said contacting you on the morning of, did you have the date, Monday, February the 17th?
I believe that's correct. It was, I believe, overnight. You had reached out very concerned. And we had established a relationship in which you could call me directly or text me versus going through our standard support line.
You believe I called you the night before, asked you to come?
I believe it was overnight that night before, but it's been some time.
So your bill shows, and I don't have this on hard copy. If you want to see it, I'd be happy, but I won't misrepresent it. Your bill for March shows a billing,
There you go.
a ticket number 25589, firm electronic lockdown, on-site review, and data gathering, Tyler Jones, 2/17/2020. Sound right?
Yes, sir.
That would have been Monday, the 17th of February, following Friday, the 14th, right?
I believe that's correct, sir.
Were you told that evening or morning that I had discovered that my email organization was in total disarray?
You had mentioned that when we met on the morning of the 17th.
And you saw it. You saw my emails, the organization that I normally would have had. It was everywhere. Remember that?
I don't, and unfortunately, having not seen immediately before, I couldn't tell you what had changed or how.
You have a recollection of me telling you that my organization of my emails
Yes.
it was in total disarray. Remember me telling you that?
I do.
And you found it in disarray. I know you don't know when, but when you saw it, you found it to be in total disarray, didn't you?
I found it to be not well maintained, but I couldn't tell you who did that or when.
Right. You had arranged for my email, LN Wood PC email, to be handled through a company called Sherwood.
Web, correct. Share web.
Sure
Yes,
Web,
sir.
right? And so by your own admission, you really didn't have the capability to look into what had happened, if anything, to my email system.
Correct. We had reached out to the vendor and confirmed that they did not maintain log files for the email, which is why we had started the migration to a different platform.
And locked down so that no one else could get access.
Correct. If somebody got your password, they could have theoretically gotten into your account.
So while you were satisfied that you couldn't find a problem on the Dropbox part of the files, you knew there was something going on in the emails, but you were not able yourself to be able to learn what had happened. Would that be fair?
I would say that you absolutely reported fervently that something had happened with your email, that it was not how you expected it. But again, we could not determine who or when or how that was changed.
And you knew when you came there that day, I think you said I was very irritated. I was not a happy camper that morning, was I?
No, sir.
You bet. I told you I thought my emails, if not other parts of my computer, had been hacked by someone, didn't I?
You did.
On Sunday night, the 16th, or Monday morning, the 17th.
That is correct to the best of my recollection.
Following Friday, the 14th, right?
Yes, sir.
And when you got there, do you recall there being another individual who was some type of an IT expert there?
Yeah, there was an IT forensics expert there from an investigative company, and at least one of your neighbors was there as well.
Do you remember whether when you were there was a lawyer there named Don Samuels?
I believe that is correct, but I couldn't say definitively.
Do you know who Don Samuels is?
I know the name.
It's a criminal defense lawyer.
Yeah.
Did you know, or did you learn that the person that he sent there, or the other person that was there, the IT person, was there on the recommendation of Don Samuels?
I was not aware of that.
So you spent 3.5 hours that day at my home.
That would have been a mixture in the night before locking out requested accounts and into that morning. So cumulatively, yes.
And then you also billed on the 17th, firm electronic lockdown returned from Linwood's home, Tyler Jones, 0.75 hours, right?
We logged travel time, yes, sir.
And then on the 18th of February, ticket number 25589, you write firm electronic lockdown. Re-enabled Dropbox users provided email passwords to Lynn, Tyler Jones, right?
Yes, sir.
And on the 18th, you have ticket number 25636, Linwood password reset, changing Lynn's password to lwood@linwoodlaw.com to 14 Valentine 20/20, right?
Yes,
That was
sir.
done by Jesse Homans of your office.
Yes, sir.
And on the 18th of February, you billed on ticket number 255, firm electronic lockdown, suspended Dropbox users, changed email passwords done by your employee, Dexter Brodus.
Yes, sir.
2/20/20, ticket number 25687. Chelsea password reset. Change Kimmy's email password per Lynn's request. 0.25. 2/21/20, ticket 25700. Re-enable Dropbox access for Kimmy. Re-enabled Dropbox access for Kimmy and set up Smart Sync on Lynn's 13-inch laptop, Tyler Jones. You believe that this is built, you would agree this sounds that way, that you kept your time and sent your bills?
Yes, sir.
You don't have any reason to dispute that this is at least demonstrative of what you were doing during this time period, do you?
No, that sounds accurate.
Scroll up.
Yeah. And that bill was a total of $3,000. $3,006.39.
I don't have my ledger in front of me, but I have no reason to doubt that.
But you came out there and you came in response to a client of long standing. How long had you been working with me?
Since the early days of Wood, Hernacki, and Evans.
Before Jonathan, Taylor, and Nicole were any part of whatever part they were of my firm, L.N. Wood, you worked initially with Wood, Hernacki, and Evans.
Correct.
And then you billed Wood, Hernacki, and Evans.
Yes, sir.
And then there came a time where that law firm disbanded and you continued from that point on to do your work for L. Linwood PC.
That is correct.
And that continued in terms of working for L. Linwood PC until, if I'm correct, the end of July of 2020.
That is correct.
Did you and I ever have any problems about your work?
Not over the caliber of the work. I know that we separated ways at your decision because you were frustrated that the mail migration had not been completed. Understood. So we did amicably and handed off all the credentials to the person working for you on physical security.
You recall after you were there in February that I asked you on more than one occasion to prepare a report about what you had done that day and what you had found or not found.
Yes, and I believe a summary email was sent basically covering the findings I've shared here today.
Well, would that be in your files? Because I can't find it.
No, sir. Unfortunately, again, when we separate with a client for confidentiality reasons, we delete all the data related to them.
But you do recall my asking repeatedly for a report from you.
Yes.
Do you know why I terminated your services?
You were frustrated at the time with the time that the mail migration was taking, and I could understand that.
I was also frustrated because I couldn't get a report from you.
Objection, Your Honor. He's testifying again.
Not yet. Overruled.
I don't recall that being part of the conversation, but again, it's been some time.
So you don't have a recollection to deny that?
I do not.
All right, sir. It's good to see you again. It's been a long time.
You as well, then.
God bless you. That's all my questions.
Any redirect?
Your Honor. Mr. Jones, did you see any emails that were sent from Defendant Wood's email domain that seemed suspicious to you the morning that you did your evaluation?
No, we typically don't read client detail unless we are specifically requested to.
And who suggested this change in password to the 14 Valentine 20 for Defendant Wood's email address at the time?
He would have called in and requested that. The technician that did that change worked the phones, so he would have called in and requested that change.
And what about the changes to the firm's Dropbox account access? Who would have suggested that?
That would have been at Lynn's request at that point.
Is it possible that anything, hold on, let me rephrase in a better way. Is it possible that this whole email situation was just user error?
I can't confirm or deny that. Again, from our perspective, it's all based on what we can see in log files, what we can see in user activity to be able to prove that out.
And you recall sending Defendant Wood an email of your findings from the day in February of what you did and what you found?
To the best of my recollection, yes.
Thank you. That's it, Your Honor.
Any recross on those points?
Very briefly. Do you remember that you were sitting in my dining room table,
Yes.
looking at my laptop? Sitting across was the individual,
The IT forensics expert.
Don Samuel. Remember that?
Yes, sir.
And then my neighbor was there. Do you remember pulling me over and saying, "Let me show you this"? And you showed me, he said, I'm going to delete an email that's not important. Remember that?
I don't.
And then you deleted it.
Objection, Your Honor. The witness has testified.
Yeah, if he says he doesn't, you
He's on
can.
cross.
I know, he said he didn't remember that, so maybe try to
Refresh.
ask it a different way.
Yeah. Do you remember sitting there with me saying, I just deleted this email and look what happened. It popped back up. Do you remember that now?
I don't.
You don't deny that happening, do you?
I don't.
Thank you very much again, Tyler.
All right, Mr. Jones, thank you for joining us. You can step down.
Thank you.
All right, if we could have Mr. Grunberg retake the stand.
Good to see you. God bless you.
I don't know what I needed. I think, oh, it's right here. Found him. All right, Jonathan, I believe, before the lunch break, we had just, spoke about the Nick Sandmann matter. When Mr. Sandmann turned 18, did you guys get paid pursuant to the March 17th settlement agreement?
We didn't get paid then, and we've never gotten paid pursuant to that settlement agreement.
And when Mr. Sandmann turned 18, well, actually, do you know when the date Mr. Sandmann turned 18?
I think it's July 24th
Of what year?
of 2020.
And did you receive any correspondence from the defendants? Sorry. Are you okay? You okay?
Yeah, I just was trying to get it to lean back. It worked. Oh, nothing to you, Mr. Wood.
Talking about his chair.
All right, next question.
Did you receive any sort of correspondence regarding the fact that you guys were not going to get paid under the March 17th settlement agreement?
Yeah, a letter was sent from Lynn's attorneys at Alston and Bird to our attorneys, saying that that Lynn wasn't going to pay the money he owed us under the settlement agreement.
And I'll point you to Plaintiff's Exhibit 106. What is Plaintiff's Exhibit 106?
Plaintiff's Exhibit 106 is just the email from Lynn's attorney, Chris Marquardt at Alston and Bird, attaching the letter on behalf of Lynn, saying that he wasn't going to pay the money he owed us under the settlement agreement.
And is Plaintiff's Exhibit 106 a true and accurate copy of the email and the attachment there too?
It is.
And did you receive a copy of it through your counsel at or around the time that it was sent or received, excuse me?
It's,
106. Jonathan, did you receive?
just pause for a second.
Okay.
I believe the defendants put this in evidence yesterday, but I don't know if they admitted it. So this is really a housekeeping matter.
I object. Mischaracterization of counsel, suggesting that there was an attached letter from me. This document shows 106, an email from Chris Marquardt to Andrew Bill, copying Joy Burby. It says, Drew, please see attached letter. And then the letter that's part of it is July the 24th of 2020. And that's the letter to Andrew Bill from Chris Marquardt, copied to Joy Burby. Those are not my letters. So I object to the form.
All right, well, she hasn't tendered them yet, so maybe
Sorry?
she hasn't tendered them yet, so I
I
might.
started asking him about them, saying that it was, I had a letter attached that I wasn't going to pay, and that's not true. It's false.
All right, I'll take up your objection if you have one once she tenders it. All right, Ms. Brown.
Your Honor, at this point, well, actually, Jonathan, I believe we got cut off. Did you receive a copy of this email and the attachment through counsel shortly after or around the time that it was received?
Yes, and I believe I testified that this was a letter from Lynn's attorney to us saying that Lynn wasn't going to pay the money. And we certainly received that letter through our counsel.
Your Honor, at this point, I'd like to have Plaintiff's Exhibit 106 admitted into evidence.
All right, objection to 106.
No objection, Your Honor.
106 is admitted.
If we'll go to page 2, Michael.
Bless you.
And so Jonathan, in just in basic terms, what did you understand this July 24th, 2020 letter to say?
I mean, on its face, I understood it to say that Lynn wasn't going to pay us under the settlement agreement for the Sandmann fees based on, you know, pretty much a false and fabricated theory about Rule 1.5.
Again, he's argumentative. The letter speaks for itself.
All right, understood. It'll be the
It's
jury's
a-
determination of that, the legal effect.
It's not.
Continue, Jonathan.
Well, yes,
He's
Mr.
allowed to
Wood.
testify
Wait,
as to his opinion.
All right, Ms. Brown, that's not how I've ruled. Ms. Wood, Mr. Wood, I don't think, is there anything else to add? I've asked him to,
Yes, he
Continue.
wasn't finished with his answer.
He's a fact witness. Stick to the facts. That's all I'm asking.
understood. All right, Ms. Brown, next question.
What factual statements in this letter do you believe led to your understanding that Defendant Wood was not going to pay you guys under the March 17th settlement agreement?
That he wasn't going to pay, the statement that the payment would require fee splits, or the fee splits would require client consent in order to comply with Georgia Rule Professional Conduct 1.5E. And that in order to comply with this, we would need to provide contemporaneous time records in order to get client consent under 1.5E. And, you know, saying as well that Nick hadn't, I think it says in here that Nick hadn't consented. While also saying that actually Carboni and Lindsay hadn't. So, yeah, I'm understanding that Nick saying he declined to consent, 1.5E applies, and that he needs contemporaneous time records, was Lynn saying that he was not going to pay the money, including because Lynn knew we didn't have contemporaneous time records for the Sandmann case, and he didn't have it, no one had it, because it was a contingency fee case, not one where we got paid by the hour. Those are hourly basis cases. Contingency fee cases are, you don't get paid at all unless you actually win the case. And so you might work a year, 2 years, 3 years and never get a dime. And we didn't keep track of our hours because we weren't getting paid by the hour. We would only get paid if we won the case in the end, on the back end. So I took this to mean he was never going to pay us.
And how did it make you feel when you received this letter?
Terrible. We had been through hell with that man, particularly in that time in January and February, with all the threats, all the abuse, him telling us he's going to fight us till he damn dies, wants to render us broke and essentially homeless. This was Lynn cashing that check. And it felt terrible.
All right, I understand the basis of the objection, Mr. Wood. It's overruled.
Continue if you were not done.
Yeah, I wasn't done. The last thing we wanted to do was to be in a fight with Lynn Wood. We settled the case once. We settled this dispute with him once in February 17, 2020, where he said he'd going to pay us all that money. Then he broke that promise. Then we settled it again on March 17th with him, 2020, because we didn't want to fight with him, and we gave up $285,000 that we didn't owe on the lease because we didn't want to fight with him. Because fighting with Mr. Lynn Wood is hard. This letter told me that I was back in the position of fighting with Mr. Lynn Wood and that my life was going to be very hard. It was emotion. It was like, it's kind of like being laid out by a truck. I remember the days after it where it was hard to get myself like up off a sofa. And I'm just sitting here thinking like, is this going to be the next years of my life? That was 2020. It's 2025. How many years of my life am I going to need to spend fighting with Mr. Linwood because of what he put in this letter? Because he's asking for things that don't exist, like time records.
Not written by me, it was written by Joey Burby.
All right, the jury will consider the evidence as presented. Overruled.
Again.
So there's that part. You know, I have my wife, our kids, our twins. We didn't make a lot of money for working a long time for the Sandmann case where we put all our efforts in. We didn't win the Musk case, so we didn't get paid for that too. Lynn knew that we spent a lot of time not making much money after we got that really nice settlement in Ramsey. And it was COVID. Business was tough. And I was like, what am I going to do for my family, for my little twins, for my wife, for this house that we bought? Thank you, Mr. Wood. The Ramsey money helped buy that house. But how are we going to keep it? So there's that of how I felt. I felt betrayed. We trusted him. You know, like I said, he had been good to me for a lot of years, right? He stood by me when I couldn't stand very well, when my legs were broken and my body was broken, and he stood by me. And this was like, that's all done. Any trust, any respect, any honor that I thought that man had, that's all done. Because he's sitting here asking me, through his attorneys, to give him time records that he knows doesn't exist, so he can try and take all the money that we all helped him earn. I thought he was any notion that he wanted to help us. I mean, if he wanted to help us, you know, he'd been referring cases to us, right? If he wanted to help us, why wouldn't he come to us personally and just say, hey, guys, I think there's this problem.
Objection, Your Honor.
All right, at this point, I think we're reaching more of a narrative.
And they were represented by counsel. I couldn't contact them.
All right, we're not going that route. I think we need to get back to question and answer. Ms. Brown.
Yes, Your Honor. And Jonathan, if we look here to Plaintiff's Exhibit 106, and I believe you talked about this, you mentioned this briefly, but the statement through Mr. Wood's attorney at the time talks about this client consent being required under the Georgia Rule of Professional Conduct 1.5E. Do you believe that position is part of the plan that you've testified about to not pay the three of you guys?
I think it is the center of his plan,
In what way?
because it plays into this notion that he, Mr. Wood, was somehow handcuffed, that he couldn't pay us these fees that he promised to pay us twice in settlement agreements, because 1.5 applied, which he based on this whole fabrication that we weren't lawyers in his firm, that we who were on his website as partners, who he sent emails to us as partners, who received email from us as partners, we signed every pleading we ever did with him as lawyers of his firm, that he came up with this, I'm sorry, it is a lie, that we weren't partners in his firm. So the notion that 1.5 had anything to do with him giving us fees is ridiculous.
And eventually, about a month or so after this letter, you guys initiated this lawsuit, is that right?
Yeah.
And why do you believe it was necessary to file a lawsuit against Mr. Wood and his law firm?
Because he was trying to defraud us. He broke two settlement agreements. He refused to honor two agreements.
Sure.
settlement agreement.
Yeah, keep it. That's probably that. Disagreement.
That's what happened to me. I can't be sued. Be sued for what? March the 17th. Then you ought not talk about $2 grand. On the record. It should be. And I should he just wanted that one does the March for 2 minutes. Follow me. Where you at? I took some allergies up there. I wake up in the morning. This is the verse of Thank you. Thank you.
I just said that you did something.
I'm not perfect. I'm doing the best. So are you. So is everybody. Thank you, Your Honor.
All right, plaintiff may proceed.
Thank you, Your Honor. Jonathan, I think right before the sidebar, we were talking about why you felt it was necessary that you guys had to file a lawsuit.
So after Lynn had breached, 2 agreements at this point, and it was very clear to me that Lynn was going to fight us till he damn died. I thought we thought our only choice was, well, either don't do anything or stand together and fight, file a lawsuit and try and do what's right. And so that's what we did.
And just to be clear, you're not suing the defendants for breaching the February 17th agreement that you just testified about, are you?
That's correct. We are only suing the defendant in terms of for a breach of contract,
Correct.
only for the March 17th breach of contract. And also we're suing him for defrauding us.
And did the complaint that you guys filed in this lawsuit, did it include facts about your WGW's relationship? When I say WGW, I mean Nicole, Jonathan, yourself, and Taylor, with Ellen Wood PC and defendant Wood himself.
Yeah, we included.
I might have a reference, the exhibit numbers, when she says you're a complainant. Which one?
I don't think that's an exhibit in evidence. She's just
Correct,
referring
Your
to the
Honor.
complaint generally that initiated,
Complaint.
that initiated the lawsuit.
Thank you.
Right.
Yeah, we included facts about our relationship with Lynn and how we were partners of L. Linwood PC, the stuff about the websites and the email addresses and the years of working, all that stuff we talked about.
And why did you include all of the factual allegations and pictures of the website and the business cards and stuff like that in the complaint?
As proof, as evidence, you know, to put in more legal terms, we needed allegations in order to satisfy our legal burdens, and those allegations help satisfy our legal burdens that both our breach of contract, that Rule 1.5 didn't apply because we were indeed part of his firm. So we didn't have to deal with this whole client consent issue that he's having his lawyers put in letters. So we put those details in there to show that 1.5E is kind of a whole red herring sideshow. And we put them in there also as part of the fraud case to show, I mean, how just wacky the notion was that we weren't a partner and part of his law firm, that we somehow were practicing under different law firms.
And did the complaint also include some of the voicemails and the threatening recordings the defendant Wood left you guys in it?
It did. And so those allegations are more for part of the fraud claim and also for our claim for attorney's fees. We've made a claim against Mr. Wood that he has to pay for the attorney's fees that we have to pay for in order to try and get him to honor his agreement or, you know, to hold him accountable for the fraud.
And why do you believe that the recordings, following his honor's instructions, so why do you believe that the recordings needed to be put in the complaint?
So that's what I was getting to. So
Objection, Your Honor, that's a question for the jury to determine whether those recordings have any relevance or not. For him to decide why it's relevant is an argument of a lawyer. He's a witness. He's a fact witness.
All right.
Here to speculate.
I understand the contents of the complaint, I believe, have been brought into issue on other grounds, so it's overruled.
Thank you.
So in filing a fraud claim, it's a very unique kind of claim under the law. When you bring a lawsuit, you often then
Not here to instruct on the law. You'll tell the jury what fraud is. It's not his place to do so. And that's the problem. That's why I object.
Okay.
It's irrelevant because it's his legal opinion and the law comes from you to the jury.
I understand.
Mr. Grunberg.
All right. I don't take that to be the point of this testimony. And yes, members of the jury, I will be instructing you on the appropriate law in this case. You may proceed.
So the defendant then tries to file a motion to dismiss to get you thrown out of court. When you bring a claim for fraud, when we filed our lawsuit for fraud, we had to meet a much higher burden to defeat his motion to dismiss to get us out of court than for almost any other claim. It's called that we had to plead with particularity. We can't just give a rough sketch of what happened. We had to plead the details in detail, the who, what, where, when, why, and how. And there's no bright line of like, okay, now you've certainly pled enough details. And so we put enough in the complaint to make sure that when he filed his motion to dismiss, he wasn't going to be able to say, you don't have the where, what, when, why, how. We put that in there to explain the fraud.
And
I mean, again, just for the record, because I have to make the record for appeal if necessary. I move to strike that testimony. It's argumentative. His dissertation on pleadings in Georgia is not relevant. He's not here as an expert witness. It goes well beyond his role as a fact witness. And I object to it and move that it be stricken.
All right. Noted. Overruled. You can continue.
thank you, Your Honor. Jonathan, what secrets have you guys discovered after the signing of the March 17th agreement and the filing of this lawsuit originally in August of 2020 that you believe goes to
Yeah, I'm going to stop
show?
right there, Ms. Brown. We've covered that through multiple other witnesses, I think, at this point. Tell me something new he brings to the table.
Jonathan, I'll point you to Plaintiff's Exhibit 45 and 48. And these are already admitted into evidence.
I've got it in front of me.
And is Plaintiff's Exhibit 45 and 48, what's been referred to as the smoking gun emails, if you will?
They are.
And are you the individual who received copies of these emails originally?
I was the person who first got these.
And how did you get copies of these emails that you're not copied on?
So, like, at least a year and a half after we signed the settlement agreement with Lynn, so that was back in 2020. So a year and a half later in 2021, a lawyer that is on these emails, Nikki Baker, that we had worked with Lynn, she guess felt bad and let me know that there were these emails out there that could be helpful for my case. And she sent me the smoking gun emails in like summer of 2021, months and months after Lynn then, finished his fraud by not paying us.
And did the defendants produce Plaintiff's Exhibit 45 or 48 during discovery in this case?
They did not. And, again, that's the kind of inside baseball stuff. The discovery is just this process where after you file a lawsuit, the parties get to exchange information with each other. You ask them to produce documents to you. We use the word produce.
He's now just trying to explain to the jury the discovery process. Are you going to let me get up there and give him my 45 years of knowledge of the discovery process? No, he shouldn't be allowed to give his interpretation of it. That's a matter of law for the courts. So I move to strike it.
All right. And I would respond, Mr. Woods, to this aspect of the case. If you do have something relevant that clarifies that or responds to it, I think I would give that leeway. We don't need a full overview of the discovery process, but we need something about it.
Well,
Thank you, Your Honor.
then I would be able to give my view of it.
That's right.
So I can explain the discovery process.
Not the entire discovery process and of it all, but what relates to this issue at hand.
Just what it relates to the discovery issues in this case.
This particular one.
When are we talking?
We're talking about emails.
Emails.
That's right.
I didn't hear him say that was part, well, strike that.
Okay.
My objection is noted.
All right. Overruled. You can continue.
So again, briefly, it's just the parties exchange information with each other. You ask them to provide documents. They ask you to provide documents and you send them on over to each other. So in that process, somehow the smoking gun emails that really describe a lot of what was going on here didn't get turned over by Mr. Wood repeatedly. And then they didn't get turned over by Todd McMurtry repeatedly. Both of them somehow, after turning over thousands and thousands of pages of other emails, other documents, somehow these smoking gun emails didn't find their way into what they were turning over to us.
And was Mr. McMurtry a party to this lawsuit at the time that he did not produce a copy of these emails?
He was not.
And did receiving these emails from a third party, is that what led to Mr. McMurtry being added to this lawsuit?
That's exactly right. Once we got the smoking gun emails, we learned more about how the fraud was accomplished. We knew there was fraud. Then we learned more about the how. And so we added Todd McMurtry as a defendant to the lawsuit.
And what about once Mr. McMurtry was added to a party to this lawsuit, did he produce copies of these emails during discovery?
He did, but we had actually put text from these emails in the amended complaint. So he knew that the cat was out of the bag. And so at that point, once the cat's out of the bag, the smoking gun email started appearing from Mr. McMurtry.
And briefly, what do you believe that these emails show?
So when I got these emails, I was, again, kind of floored because it explained the genesis of how this all came about to me. That's how I understood it, that Lynn had come up with this plan. He calls it in the first email, I think it's like 48, maybe. It really, the subject matter of the email is a good idea, exclamation point. And that's the first place that I ever saw him propose this notion that we were just partners in an office sharing agreement that weren't entitled to just split the fee with him. That we were entitled to $0 because we didn't have, say, contemporaneous time records. This was where the plan was hatched. That's what it meant to me. This is where the fraud begins.
And I'll direct you now to take a look at plaintiff's exhibit 196 and 198, and if you could tell us what those documents are.
I'm sorry.
196, 198.
196, 197,
196, 198.
198.
Try to cut out 197 for time.
Oh,
Get them all. Let's go home.
I wish we could.
I'm there.
Can you briefly tell us, just general terms, what 196 and 198 are?
So 196 is one of the violations of the contract by Mr. Wood for where he promised that he wouldn't disparage me. And then after he agreed to that and signed that contract, in 2021, I believe this is, he decided that he didn't care about his promise to not disparage me, and he went out and he said, what?
Jonathan,
Oh, go ahead.
it hasn't
Sorry.
been admitted into
Oh,
evidence
yeah,
yet,
yeah.
but are these,
You're right.
Is plaintiff's exhibit 196 telegram post from defendant Wood?
Yes,
Is it a true and accurate copy?
it is.
Okay, and is plaintiff's exhibit 198 true and accurate copies of replies to the post in 196 that were on defendant Wood's reply channel? 198.
It is.
And do you recall the exact date that this post and these replies were posted? I can refresh your recollection.
Was it in and around June of 2021 or?
I'll show you something that might refresh your recollection. It's that.
Right, so it was spring. Yeah, it was published March 24, 2021, so spring of 2021.
Replies were posted the same day.
Yeah.
Your Honor, at this time, I'd like to move to have plaintiff's exhibit 196 and 198 admitted into evidence.
So recognizing the similar previous objections you've made regarding these kind of posts, Mr. Wood, do you have any other objections?
Sorry, Your Honor, I got that. What numbers are we on?
196 and 198.
Now mine, oh, go
Well,
ahead.
no, he hasn't
Yeah.
been responded yet.
Same objection, Your Honor. No identification. Don't know who Elizabeth Hayworth is. Toenail wrap. Redone. OCO groaning. These I guess they're social media posts. There's no identification of who wrote them, why they wrote them. I'm not sure where they got them from. But it wouldn't have been on my reply channel unless they went and got.
All right, well, to that end, you're going to have to take that up with the authenticating
Lack of
witness.
authentication.
Okay.
Lack of identification of who it is, and blatant hearsay.
All right, and on similar grounds, I'll note the objection but overrule it. 196 and 198 is admitted.
Thank you, Your Honor. So in defendant Wood's post, I'm just going to read some excerpts of this. It says, "Some truth about Jonathan D. Grunberg. I learned after Jonathan stopped sharing space with me that he is a public supporter of Black Lives Matter." And it goes on to say, talks about your rock wall climbing incident and says, "Jonathan almost died and is lucky that he did not lose one or both of his legs. Jonathan could not work for 1 year." The notion that you couldn't work for one whole year is just not true, right?
That's right. I mean, this is part of the thing of trying to paint me as some sort of like ungrateful freeloader off of him or something who he just did everything for, and I've now bitten the hand that feeds him. And he's trying to shush me right now with his finger. He's been doing it this whole time.
It's so inappropriate.
Yeah.
Strike that.
All right. Jury will disregard that. Let's move on.
Moving over to the replies to this post, some of the replies that you saw on Defendant Wood's reply channel, which is 198, Michael. Somebody with the screen name A. Elizabeth Hayworth says, well, didn't need to hear anything past his willingness to take full pay for not working. Another user, Ton L Rat, says, apparently Jonathan is an ungrateful and inconsiderate POS. To bite the hand that feeds, so to speak, is a sign of an individual who is morally bankrupt and insolvent to those who look out for the best interests. Another individual, Rocio Ronin, I'm probably butchering that name, says, what a traitor this prick Jonathan is. Did you view other responses talking about you and your work ethic on Defendant Wood's reply channel that's not pictured here at 198?
Yes, very much so. It's been a theme.
And do you know how many followers Defendant Wood had on Telegram in the 2021 timeframe?
2021, I think he had about like 1 million people, somewhere in and around there. Maybe it was like 800,000 who followed him on Telegram.
And I'll take a look now at Plaintiff's Exhibit 206 and 207. Actually, 205 first, I apologize. So 205, 206, and 207. Pointing you to 205, is this a true and accurate copy of a Telegram post the Defendant Wood posted?
Yes, it is.
And it's 206, a true and accurate copy of another Telegram post that Defendant Wood posted?
It is.
And is 207 the same thing, a true and accurate copy of a post that Defendant Wood posted?
It is.
And were these screenshots taken at or around the time that they were posted?
They were.
And if you do not recall the dates of these posts, I can refresh your recollection. Because I believe the exhibit numbers cover it up.
I think these ones, again, were in and around the 2021 time period. I think a little bit after the other ones, maybe towards the summer now.
I think 207 dated May 17th, 2021.
So 207 was
May the 17th, so early summer, late spring.
And 205, does this refresh recollection about when it was posted?
Yes, so I think this was May 12th, 2021, so against late spring.
And 206, was that posted right before 207 on May 17th, 2021 to the rest of your?
To my recollection, yes.
Your Honor, at this point, I'd like to move to have 205, 206, and 207 admitted into evidence.
Any objection?
No objection, Your Honor.
205 to 207 are admitted. 207, so 205, 206, 207.
Thank you, Your Honor. So in Plaintiff's Exhibit 205, I'm just going to read a couple excerpts of this again. I gave Jonathan D. Grunberg a job when my small law firm Wood, Hernacki, and Evans dissolved, and the other two partners would not hire them. And again, it describes your rock climbing incident and that he paid you his full salary for a year while he recovered and could not work, and that he helped his wife find a job. It goes on to say, I was always good to these three young lawyers And then they turned on me when they wanted more money than they deserved in 2020. They threatened my efforts for Richard Jewell. They interfered with my relationship with my children. They falsely attacked my mental health. They filed a frivolous lawsuit against me. And it ends, I pray for their souls. Briefly, what about that do you believe violates the non-disparagement clause of the March 17th settlement agreement?
You know, the worst of it is the bottom part. Of course, where they said we threatened his efforts for Richard Jewell. They interfered with my relationship with my children. They falsely attacked my mental health. They filed frivolous fraud lawsuits against me. I mean, and then, goes on to kind of just say that we're getting money we don't earn. I consider that pretty offensive and disparaging.
In plaintiff's 206, again, just reading excerpts of this, after a defendant would post on Telegram, after the lawsuit was filed against me, I discovered on his Twitter page that Jonathan D. Grunberg of the Atlanta firm of Wade, Grunberg, and Wilson LLC was a public supporter of Black Lives Matter, also known as BLM. It goes on to say that I thought he was a communist. We would laugh. Heck, now, after seeing his support for BLM, I think I may have been right. Could Grunberg be trying to smear me due to a political agenda? Many others sure have. What do you think might be going on here? What about this one, briefly, do you think violates the non-disparagement provision?
This is tied into the lawsuit after the lawsuit filed against me, right? And he's trying to portray that we're somehow doing this lawsuit, not because it's a legitimate lawsuit, but because it's part of some political agenda, which I find deeply offensive, even also just as a lawyer. Like, I file real lawsuits. I do not file frivolous lawsuits. So that's disparaging to me. For their stuff, he could call me a communist all he wants, and Black Lives Matter. Sure, I support it.
And going over to plaintiff's 207, defendant would post on Telegram, again, just reading excerpts of this long Telegram post. Jonathan D. Grunberg is Jewish. That's true, right, Jonathan, before I move on?
Last time I checked.
And it goes on to say, now old Jonathan sues me and claims I am anti-Semite because I called him a Chilean Jew. Can you believe the nerve of this guy? There's not an anti-Semitic bone in my body. And then he goes on to say that the love of money is the root of all evil. Political agendas can play a role too. Someone falsely accusing me of being anti-Semitic or a racist is evil. Am I shining light on the darkness of the false fraud case filed against me by Grunberg and his cronies? There is more. Stay tuned if you're enjoying the truth, and truth is in all caps. Did you receive any responses directly to your law firm that reference your Jewish faith, or this notion that you're a Chilean Jew?
Yeah, they found it somehow like my religious and racial identity is somehow funny. And I got hate messages to me personally at the law firm and laughing about me being a Chilean Jew and things like that.
Approximately how many messages would you say that you received?
Was it tens, dozens? It was considerable. At some point, you kind of just try to shut it off. But they send you the emails, they send you the messages they making phone calls to me, leaving voicemails for me.
And I'll point you now to take a look at plaintiff's 212. Are these some of those examples that you received directly to your law firm at Plaintiff's Exhibit 212?
They are.
And some of these look different than the others. So just walking us through this to lay some foundation, Jonathan. The first 2 pages of 212, this is a direct message that you received a copy of via email by way of your super lawyers account. Is that right?
That's correct.
And your online super lawyers account has your email tied to it. Is that right?
That's right. It like pushes emails to me when people fill out a form on Super Lawyers.
And is this one a true and accurate copy that you received at or around the time that it was sent to your inbox?
It is.
And then the rest of these, pages 3 through 5, these look a little bit different. Can you briefly explain to us what this Squarespace email that's being sent to Chelsea Gray at wgwlawfirm.com is?
Yeah, so this comes from our website. We have like a page where you could fill out a form to inquire about, say, our services or something like that. And then it would send an email to our assistant, Chelsea, and then Chelsea would forward those things to us. So that's what this is.
And if somebody were to go on the website and fill out the form, can they type in whatever they want in the boxes, if you will?
Yeah, they could type in whatever name, whatever email address, whatever number, and obviously whatever abhorrent, terrible, offensive thing after, they see a post by Mr. Wood on Telegram.
And so are these true and accurate copies of what Squarespace sent to your law firm of what was filled out on these website forms by the various individuals?
It is.
And moving over to make this easy to 248. Are the Squarespace website replies that we see in plaintiff's 248 the same thing that you just testified about? Somebody entering information on the form of how can we help you on the WGW law firm website and it being sent to your assistant, Chelsea Gray?
Yes.
And are the website replies true and accurate copies that were received by Ms. Gray and your law firm at or around the time that they were sent?
Yes.
And I believe we also see, like on page 4, 7, and then 11 through 15, we see transcripts of a voicemail, it appears.
Yes.
Are these true and accurate copies of voicemail transcripts that you received directly to your office number
Yes.
at your law firm?
Yes.
And that's for take a look at 4, 7, 11 through 15. I'll give you a moment to do that to confirm. 4, 7, 11 through 15.
247.
248.
So 248.
Yes.
Hey, dude, is that what?
It's just exhibit 248.
Just the one exhibit. Okay.
They are. I remember getting many of them.
Your Honor, at this point, I'd like to move to have plaintiffs 212 and 248 admitted into evidence.
All right, so it's exhibit 212, 248, and recognizing the objections previously lodged to authentication, hearsay, and relevance. Are there any other grounds?
Well, I've never posted anything on, what is this, Squarespace? I don't know what that is.
Can we-
So I
Can we
object,
pause my
yes.
time, Your Honor? While
Just so the record's clear. Lack of authentication, lack of identification, resulting in a total inability to cross-examine these individuals, assuming these people even exist, and it's not fake. So I
All right.
object to it on those grounds.
Understood. For some of the reasons, I'll overrule the objection. They're admitted.
Okay, thank you, Your Honor. And Jonathan, for the purposes
I
of
left off hearsay.
And hearsay.
And for the purposes of time, I'm just going to read some of these into the record on 212. Somebody, Billy Madison, I'm assuming that's from the movie, says, "You sound like a real peach of shit, the Georgia kind. Remember to always respect your elders." Going on to page 3, this one says, you, sir, aren't a Chilean Jew. You are a fucking faggot Jew, soy boy, snowflake. Get a fucking life, you low life piece of shit. And a real shitty lawyer, I hear. You would be nowhere if it weren't for Linwood. Go out back and eat a bullet, you spineless fuckhead. Jonathan, this one in particular, how did it make you feel when you received it?
Like, this is part of the whole fraud thing. This is the render me broken, essentially homeless. This is him trying to destroy me and cashing that check. All that stuff comes up. Everything that he did in defrauding us and putting us through all of this.
This next one says, Jonathan is a coward and a stain on Georgia. He is an embarrassment to Judaism and the legal practice. With sign off, God wins. The next one says, you can help
What
by
exhibit are we
closing down
referring to?
your office. Return.
Excuse me, what?
It's right there.
But that doesn't help.
What's the number of the exhibit?
212.
212.
You can help by closing down your office, returning the money that was paid to you by nefarious actors, and begging Lynn Wood for his forgiveness, you treacherous bastards. This one says, I hope, in part, I hope you all dig down in your souls and do the right thing, because at the end of the day, because at the end of all of this, there will be Judgment Day, and I sure hope you are all ready. God bless Kim. Going over to 248.
Hold on, you're jumping all around. The last one you just read.
All right.
Going to 248. Your lawsuit against him feels to America like a suit over access to a farm pond by a neighbor of a Marine stuck in a frozen Korea fighting the Chinese. I would drop it. Very respectfully, James C. Henshaw, MD. The next one says, I will go around in part. I will go 248. I will go around bad mouthing you and
She can go at her own pace and present their evidence as she
Not
wants.
suggesting otherwise, I simply asked to know the exhibit.
248.
It's an omnibus exhibit. It's in 248.
And I will go.
All right.
I will go around bad mouthing you and doing anything I can to destroy your reputation. People are watching you everywhere. Did you receive other direct messages and responses to your law firm using the phrase "people are watching you" or "we the people"?
Yes.
The next one says, what is your problem? Lynn is telling everyone on Telegram about your bogus civil suit against him about, quote, unprofessional conduct, end quote. Really? This is total BS, you sorry bastards. It goes on to say, Lynn is a good guy and the rest of you are evil. Unprofessional POS. I hope that ridiculous suit of yours is thrown out, and I'm going to tell everyone on social media about your sorry butt kissing, quote, law firm, end quote. Now, how you doing? Now, Jonathan, going to the next one. This is a voicemail you received. Who was this individual identified here, Justin Collier, to the extent that you know?
I think I may have traced this guy to, he might have been the one who called himself like a citizen journalist from San Diego. And he had a thing particularly for me. And he would just call and, triggered by Lynn, leave me these offensive voicemails. Yeah.
And did he,
Oh yeah, San Diego. It says it here. Independent news reporting here in San Diego. Yeah.
And did he leave you multiple voicemails during this time period?
He did.
The next page, Wade, Grunberg, and Wilson focuses on safeguarding your reputation from false and defamatory attacks. Oddly, these three criminals defame Lynn Wood, wishing your firm a quick collapse under enormous pressure, suggesting that you are a slime mold, discredits slime mold. These go on, and this next one, are you guys aware that Linwood is frequently attempting to sick the QAnon mob on you, calling each partner out by name via Telegram to his 833,000 plus followers? The Q mob practically worship Lynn, and he is using their special jargon to incite them without being obvious. These go on and on. Jonathan, did you guys receive more of these than what is depicted in Plaintiff's Exhibit 212 and 248?
Well, yeah, and in particular, Lynn has been shown many of these previously, and then continued to disparage us on Telegram, inviting people to continue trying to hurt us, showing that he just wants to hurt us.
And going over now to Plaintiff's 232. Is this a true and accurate copy of a Telegram thread, if you will, subject to the redactions of your minor child's photo that defendant Wood posted?
Yeah, this is a subject to redaction, a true and correct copy of these photos and posts he made about me in July, I think July 16th of 2024, posting my children and saying horrible things about me.
And pointing you to the page that is numbered page 11. I don't believe it is page 11 in this, but, and going on to the next page, are these true and accurate replies that you viewed on the Linwood reply channel to the post that appear before it?
Yeah, those are.
And the very last page of this exhibit, is this a true and accurate copy from, actually strike that. Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 232. For housekeeping purposes, the last page will be removed before it and won't be published to the jury.
All right, so 232, with the exception of the last page, objections to 232.
It's gonna be easy if somebody trying to write these down, just flip through it. On exhibit 232. Object to that portion on the page. It starts with some statement by Tracy Hamish, ends statement by Sandy back grounds of those notes.
All the ones you previously outlined, authentication, hearsay, relevance. I think that covered them.
Authentication,
Yeah.
hearsay, relevance. One more, Judge.
We could throw in a 403.
Yeah, let's throw in 403.
All right.
Yeah, I think you've covered it. The key is we don't know who these people are.
We understand. We know the argument by now. Mr. Wood, it's preserved.
Proof of the matter contained therein, so it's hearsay.
All right. And on the grounds that I previously laid out on the record, so those are the posts Not by Mr. Wood, apparently. It's overruled. Everything else is admitted. Well, they're all admitted, but the objections are noted.
Thank
All
you,
right,
Your
moving
Honor.
on.
All right, so, Jonathan, here in July of what year did you say this was? I apologize.
This was July of 2024.
So in July of 2024, defendant Wood posts, "I know my enemies in lawfare and why they are my enemies. Do you have eyes to see and ears to hear?" He signs off Lynn with some emojis. Can you explain to us what defendant Wood's following post was that's cut off here for privacy reasons?
Yeah, it's a picture.
Excuse me, Bob. Judge, I've got to go to the restroom. Mr. Next, out, so y'all can continue, ma'am, be excused.
Understood.
It's a picture of my daughter, one of the twins. I think she was 5 at the time. It's turned what was a really cute and beautiful thing into something that's very much not now. She just covered in bubbles at bath time, and it was very cute. It was. Lynn, this is my bad. I didn't have my Instagram, my Instagram was public. I didn't realize that. He took it and put it up on his Telegram platform after he'd been informed many times about.
All right. Well,
He put it
on track here.
He put it up on the Telegram platform, a picture of my daughter at bath time with bubbles, and then continued saying vile things, continuing on to his next post, which he's right after that, where he says, "Why does the enemy hate me? I hate pedophilia and human trafficking, especially child sex trafficking," which I understood that he was making a connection to disparage me and say that I am engaging in pedophilia and child sex trafficking with my 5-year-old daughter.
And
Your Honor, may we approach?
I mean, if you have an objection, you can lodge it and just state the grounds.
Well,
Objections, lack of foundation or speculation.
this has already been subject to a prior ruling from Your Honor.
Okay. All right. I think we addressed that already as part of the record. So objections noted, overruled.
all right, and Jonathan, and going, Michael. To page 10 of this exhibit, Michael, I believe that's where the responses that were posted in response to these that we've seen come in. Somebody named Tracy writes, "Sick bastards. Why do they have to pick on innocent children, pick on those who can defend themselves, and then see how tough they are? Evil, evil, evil. They need to burn." Another follower writes, "Beyond sick." Another one writes, "The diaper had a pedo symbol on the very bottom. This makes my blood boil, praying for justice for the children to come now." It goes on to the next page. On the next page, Michael, can we zoom in on the very first reply, please? Jonathan, can you explain to us what's pictured on the screen here?
Yeah. So one of the hateful messages that I received, communicating to me that I would be put to death, and that my partners would be too.
And if we go on, actually strike that, is we go on to the next page. Are these more replies to the posts that we've just seen that were posted on Defendant Wood's reply channel? On the screen.
Yes,
And
there are more replies to that whole thread with my children and the accusations that he was making, it was my children. He also posted pictures of my son with my daughter.
Deborah writes, "I see, not a good look for Wade Grunberg and Wilson. I'm assuming it's the same Jay Grunberg. Am I right?" And does defendant Wood respond to that reply?
Yeah, so that's Lynn at the bottom. And after this person says, I think John just hung himself, what about his present law partners? Lynn's response is immediately below, but although it's apparently to Deborah up above, Deborah Warren, yes. Sign Lynn, this emoji that he does with these glasses and a smiley face. Yeah.
And moving back to the March 17th settlement agreement, did WGW ever pay defendant Wood the amounts that you guys owed him under the March 17th settlement agreement?
Every penny of it. So there's that bottom part of there's a second part of the agreement that sets out the fees where we're putting money over to his side. And we always did it. We always gave him the checks he was owed under the settlement agreement.
And how much is WGW owed under the March 17th settlement agreement?
Somewhere, given that Lynn broke his promise related to the lease, I think it's a number somewhere around like $930,000 or something.
And does that include the amounts that are specifically listed in the settlement agreement that was provided at?
No, for the amounts that are specifically listed in the settlement agreement, I think it's,
If you want to go to 102, it may help refresh recollection. And that's already in evidence, Michael.
so one of the amounts that owes us under the settlement agreement, there's several. One of them is $647,949.99 for a collection of some of the cases. Then there's another amount that he owes us of $100,000 for a WAPO case. And then there is the amount that he should not be entitled to under it of $285,000 under the lease provision as well.
And so your overall total that you gave, is that inclusive of all of those things you just testified about?
Yes. Oh, no, the overall total I gave is not inclusive of all those things. I think maybe the 100,000 isn't included in that.
And do you know how much defendant Wood got in the Sandmann versus Washington Post case?
Millions. I don't know to the penny.
Do you know how much the 10% that's provided for under the March 17th settlement agreement would be?
Yeah, for the WAPO case, it's 100,000.
And did the three of you guys have to get new office space after you left Ellen Wood PC?
We did.
And I'll point you to take a quick look at plaintiff's exhibit 282, excuse me.
I'm there.
Okay, is this a true and accurate copy of the lease that the law firm of WGW entered into on April 17th, 2020?
It is.
And is this did you sign this document at some point?
I recall doing so. I'm just looking to make sure this is the copy that has it. This one has Nicole's and Taylor's.
And you did eventually sign
I
this
did.
document?
I did.
And this is a true and accurate copy of y'all's lease at that time? Jonathan, is this a true?
It is.
Your Honor, at this point, I'd like to have plaintiff's 282 admitted into evidence.
Objection to 282.
Their office lease?
That's right.
Objecting the grounds is totally irrelevant.
Goes to damages, Your Honor.
All right, overruled.
Thank you.
Over objection.
Why did the three of you guys enter into a new lease?
So Lynn, threw us out of the office. We then needed a place to practice law. And so we got temporary office space and we were looking at something more permanent. Then Lynn broke that 217 agreement and we're like, okay, I think maybe we have to keep with the temporary. We're afraid to get into a long-term financial commitment. And then once Lynn was back on board and was going to settle again for the March 17 agreement, we were like, okay, we're going to have the resources to have a long-term commitment for a lease. So we got office space to practice in on a long-term basis.
And would the three of you have entered into this lease or any lease if you would have known that the defendants weren't going to pay what was owed under the March 17th settlement agreement?
No,
Why is that?
because we didn't have the financial stability to do it. We could have worked at home and saved our money given the financial risks that we were facing with not being paid for all this work that we did for Lynn as a partners of his firm for, over a year.
And can you take a look now at plaintiffs 262 and 263 and tell me if you're familiar with these documents?
I am.
And is 262 a true and accurate copy of a letter sent to defendant Wood's counsel at the time and a copy of the check written to Ellen Wood PC in December of 2020?
It is.
And is 263 a true and accurate copy of a letter sent to defendant Wood at his PC post office box in July of 2021?
It is.
And did you receive copies of these through your attorney at or around the time that they were sent?
We did.
Your Honor, at this time, I'd like to have 262 and 263 admitted into evidence.
I'm sorry, I'm not understanding here.
262 and 263. 262 and 263. 263.
No objection.
262, 263 admitted.
Michael, we don't have to put these up. I'm going to be brief. Jonathan, briefly, what is 262 and 263?
They're letters and one check reflecting the payments that we paid to Lynn under the settlement agreement of March 17, 2020, which he then accepted and he cashed. He took the benefits under that contract, taking money from us while refusing to give us the money he owed us under the contract. He affirmed the contract.
In 263, did you guys send him a cashier's check?
We did, and he cashed it.
They cashed both the checks that were referenced here, being sent to him in 262 and 263. Is that right?
Correct.
And did defendants or anyone on behalf of the defendants ever ask WGW if you guys obtained client consent to split these fees in 262 or 263?
No, he never asked about client consent or Rule 1.5 or anything like that when it came to him getting that money.
Your Honor, at this time, leave. Had to do some jumping around because of the witness earlier going in between, but I believe that's it.
All right, members of the jury, if you want to maybe stand in place, do a little stretch break, feel free as we transition to cross-examination.
Your Honor, may I use the restroom?
Sure, why don't you
I can be.
step out,
very
we'll just
quick.
hold in place.
Hold on. Are you okay?
I just said you could go to the restroom. Sure.
Here, I'm so sorry.
It's okay, I'll fix it.
And that's for me. Oh, I'm sorry. Need this?
I'm gonna let you have yours, in case he wants to see it.
Okay. He's waiting on us.
Yeah, just waiting on John.
Okay.
All right, ready to go back on the record? All right, we're back on the record. Defense may proceed.
Do we have to have a discussion about time?
We can. Why don't we get started and we'll go from there and see where we are.
Right now, we haven't imposed any, but I know there'll, at some point there will be. I just want to make sure I don't.
In terms of your time for cross?
Yeah.
Oh, well, I've got it up there. We got the matching time, just like we did with the other witnesses.
2 hours?
That's right.
So may I approach it?
Sure.
That means 2 hours because they took 2. You're letting them govern the length of it. Try to live with it, but I'm gonna ask the court to be flexible. I can't finish with it.
Right. So 2 hours is kind of a metric where if we get to that point, you can tell me how much more time we need. I'm gonna determination of how well you did, how focused we were. So not in terms of objectively, I mean in terms of staying on what questions and that sort of thing. How repetitive, if it was cumulative and that sort of thing.
Just, yeah, we did cut stuff out. It's just-
Yes, exactly. So I think there's a lot that can be achieved in 2 hours.
So two, is it 2:59?
The middle one's the time. Middle one.
If I finish with John, that's gonna be it.
Up to you.
Could I go home tomorrow
I
then?
think you'd certainly get on the road sooner that way.
That's me.
All right. Defense can proceed when ready.
Thank you, Your Honor. Great. I guess. Jonathan, good afternoon.
Good afternoon, Lynn.
John. Be ready. I don't have a hard copy. Do you have a hard copy of the lease that was applicable to the office space that we occupied before February the 14th of 2020?
Sure, you're talking about whether I have a hard copy of the lease at Regents Plaza for 2040?
No, the lease that existed on the office space as of February the 14th of 2020.
Right. So for Suite 2040, that's what I asked you. Are you talking about that space?
Was it 2040?
Correct.
Yeah, it was the space we're occupying in. I think it was 2040.
Sure. Yeah.
2140.
It's 2040.
Okay. Do you have a copy of that?
It might be in here. I don't know.
Let me show you what, so we don't have a hard copy, and I just want to get you to take a look at that and identify it as the lease.
Okay.
John, if you let him look through it.
I mean,
What, John, if you just.
Maybe you have
give
to
us
show it
one-
to them first and then you can approach.
Yeah, and if you can just give us 1 second, we'll tell you where it's at in the binder.
If you've got an identical copy, then
Okay,
go ahead and give it to them if you want.
It's what?
53.
All right, so it's marked as plain as 53.
Ah, thank you.
I'm there, Lynn.
You beat me to it. My copy was not this long. That's like 40 pages. I get the signature on it. Jonathan, can you turn to the signature page?
Sure.
I'm still looking for it. There you go. I got it. It's number page 40.
Okay.
And under tenant L. Lynn Wood PC, you see where it's signed by L. Lynn Wood?
I do see that.
You see the signature of Nicole Wade where she signs it, Nicole Wade, partner?
I also see Nicole Wade's signature.
See where the lease also has your signature saying Jonathan Grunberg, partner?
Yeah, I see where it says that under the name L. Linwood PC, a Georgia professional corporation, all those signatures appear so far.
Then do you see where it says Taylor Wilson, partner?
Yes, partner of, under L. Linwood PC. I see it.
And that would have been signed on July the 17th of 2018, which I think you correlate to the time where you say that you became non-equity partners.
That part is incorrect.
When did you become a non-equity partner?
May 1st, 2018. So that would be 2 months, like 2.5 months prior to this.
So you signed this at a time, thank you, this lease at a time when you felt that you were a non-equity partner
That's true. Of L. Linwood PC.
of L. Linwood PC.
That's right.
This was prior to the brief formation and early demise of Wood, Wilson, Grunberg, and Wade, right?
I don't know what you mean by formation and early demise.
Well, it didn't last long. We got everything set up. You remember we had the signage changed
We had the signage changed where?
on the office? We had a sign put up that said Wood, Wilson, Grunberg, and Wade.
Right, that was in 2020, in February 2020, I think, so 2 years after the date that I thought we were speaking about.
No, I'm just getting you to acknowledge that we had a short-lived partnership in 2020.
Go ahead.
Wood, Wilson, Grunberg, and Wade.
So in February of, or really January of 2020, you decided to change the name of the firm Ellen Wood PC, but not change anything else about the firm. We were going to, I guess, get new letterhead and probably change the name of some other things, but the financial arrangement was going to be identical. The company that we would be practicing under would actually still be Ellen Wood PC. As I understood it, it was going to be like a DBA. And you were still going to own, as I understood it, all of Ellen Wood PC, and we'd be doing the same thing where we get like 80% of the hourly fees when we worked them, and like 15%, or at your discretion, maybe higher, maybe lower, of the contingency fees when we would work them.
All of the fees were at my discretion. True?
I mean, no, not true.
Well, you could have said no and left.
Well, no, just in the sense that like at some, there are points in time where you made agreements with us, like you firmed them up. And so I would say, once you firmed them up, your discretion went away and you had an obligation to pay those fees under the agreement that you made.
I understand your point. We disagree. My question is, do you remember that you received business cards that said Wood, Wilson, Grunberg, and Wade?
I certainly remember, receiving those business cards. I don't think I ever passed one out.
You remember paying for your share of those business cards?
That went on. You usually took all the expenses of Ellen Wood PC of the firm and put them, can I finish my answer?
His question was about the expenses of the car, so just listen to the question that's asked and answer that question.
So I have a memory of you giving me a statement for overhead expenses for Ellen Wood PC. And maybe it would have been titled WGW or something, WWGW for February or January. And I would assume, given the practices from before, that you would have put the cost of those cards on the expenses that you would make us pay 75% of.
Each of you pay a fourth.
Yes, that's correct.
You remember that we had published in the Fulton Daily Report, you've had that announcement up many times of Ellen Wood PC. There was an announcement put in the Fulton Daily Report in either late January or the very first part of February, announcing the formation of a partnership of Wood, Wilson, Grunberg, and Wade. Right?
Yeah, I recall you getting that announcement put in the Daily Report.
And you all agreed to it and agreed to pay 25% of the cost. True?
I remember that it got done. I remember that we would have agreed, probably just generally, since we paid 75% of the expenses, that would be, I guess, an agreement to pay for it. I'm just saying, I don't remember specifically, like, we had a discussion about us specifically paying for the post for WWGW.
You don't deny.
No, certainly not.
Let's go home. I've got to find my pad that I had. Excuse me. I got it, I think. Yeah. You were discussing at the end of your direct examination exhibit 263. Would you turn to that for me?
I'm there.
And you redacted out certain information. But you will admit that this fee that was sent to me on July the 9th of 2021 was part of the payment of Dexter King for his outstanding bill to Nicole Wade. Do you remember that?
Yes, I do.
And the agreement between Nicole and I on how to divide that fee long predated March the 17th of 2020, didn't it?
I recall that there was an agreement between you and her about fees, but then the March 17, 2020 settlement agreement then contained a new agreement about the fees, and it had a clause that I think then said that it would kind of go over the old agreement.
The fee split in the Dexter King matter of March 17th, 2020 was simply the same agreement that Nicole and I had earlier reached many months, if not a couple of years earlier. True?
Oh yeah, I'm sure it reflected essentially that agreement. I'm just saying I'm sure it reflected those splits that you had with her before. I'm just saying you now put it into a new agreement. That's all I'm saying.
Yeah, it was the same split. You know that.
Yeah, sure.
She got 80%, I got 20.
Yeah, that sounds right.
I think it's clear that as of St. Valentine's Day massacre, February the 14th of 2020, right?
That's right, but I find nothing funny about it.
Well, it's been referred to as such, so I don't think it's that funny. I thought it was funny at the time, but let's just say February the 14th of 2020. We're all grown-ups. That day, you and Taylor and Nicole quit. You were done with me, weren't you?
Yeah, we quit being partners of Ellenwood PC, even doing business as WWGW. We quit that partnership arrangement that we had with you as of that day.
So as of February the 14th of 2020, there was no relationship between you, me, Nicole, Taylor, individually, or through your various LLCs. You were done with me, right?
That's incorrect. So we still had a relationship. We were still co-counsel in cases. We still, you still had financial obligations to us. So there was still a relationship. We just weren't your partners anymore in your PC.
You were out of, as of that, let's do it this way. As of the 14th of February 2020, whatever you want to call us before, as of that date, we were not in the same law firm. True?
So what I would call us before is partners. And at that point, we weren't partners in the same, at February 14, when we left, we were no longer your partners in the same law firm.
You were not partners, equity, other. You were not, as of the 14th, you left your relationship with my firm, and you were not, as of February the 14th, by your own choice, no longer a part or in my law firm. True?
Objection, Your Honor, asked and answered.
Overruled.
No, it's still not true. I think I explained to you before the relationship that we still had with you and your firm. And I've explained before a couple of times now that we were no longer your partners, but we still had a relationship with your firm. And so the problem, the reason I wasn't able to answer your question is true is because you asked me about the relationship. You were saying whether we had a relationship with your firm still.
Listen, let's just do it simple. Y'all quit on the 14th of February, 2020. True?
On the 14th of February, 2020, we quit being partners of L. Linwood PC and doing, at that point, doing business as WWGW.
Can you read that back? Let me just go back. So you had your own PCs,
No,
LLCs.
we had our own LLCs while we were partners at L. Linwood PC that you paid us through. That's correct.
And you maintained those after February the 14th of 2020.
Yes, we maintained those. Like, I still say had JD, I'll make it clearer. I still had JD Grunberg LLC, and I still, after February 14 of 2020, never practiced under JD Grunberg LLC. It still has not had a website, signed pleadings, any of that stuff.
And do you have, Taylor still have his, after that date, did he maintain his professional corporation?
No, he didn't have a professional corporation.
There was not a Taylor Wilson, G. Taylor Wilson LLC?
There was a limited liability company. There just wasn't a professional corporation. PC.
I'm sorry.
It's
I just
okay.
said, and he still has that?
Yeah, he still has I think it's G. Taylor Wilson LLC.
And then you and Taylor still have Grunberg and Wilson LLC?
That one might be inactive now. That I can't tell you.
So are those entities partners in Wade, Grunberg, and Wilson?
When you say those entities, we just talked about 3 of them. So you're saying all 3 of those? No.
Which ones are not?
So Grunberg and Wilson LLC is not a partner, not a partner, it's a member, if you want to use the term correctly. They're not members of Wade, Grunberg, and Wilson LLC.
So when you receive compensation from Wade, Grunberg, and Wilson, who is it paid to?
Who is the compensation? It's the compensation that I receive from Wade, Grunberg, and Wilson LLC is paid to JD Grunberg LLC.
And how about if Taylor receives compensation?
I think it's, again, G. Taylor Wilson LLC, something like that, but that's where Wade, Grunberg, and Wilson LLC pays compensation to Taylor.
And if Nicole Wade receives compensation from a fee, is her compensation paid to Wade Law LLC?
That's my understanding, correct.
So we understand all the background. You've gone into it at length. That's not what I'm asking you about now. The simple fact of the matter is, as of February the 14th of 2014, you were done with me in terms of being in a law firm, and I was done with you in terms of being in a law firm. True?
As of February 14, 2020,
yes,
I withdrew from being a partner in L. Linwood PC and WWGW.
So you and I, as of that date, once you withdrew, we were not in the same law firm. True?
Yeah, as at that point, we were not in the same law firm.
And on March the 17th of 2020, when we executed the settlement agreement, you and I were not in the same law firm, were we?
That's correct.
And from your knowledge, Taylor Wilson and I, after February the 14th to beyond 2020, Taylor and I were not in the same law firm, were we?
Taylor was not in the same law firm with you after February 14, 2020.
Ever again?
Never again, correct.
Same thing's true with Nicole J. Wade. From February the 14th, 2020, going forward, she was not in the same law firm with me at any time. True?
That's right. And can you still hear me if I'm not in the mic? Okay.
I can hear you. Is that
great.
true?
Yeah. Just if I make sure I heard the question correct, I'm saying that Nicole Wade
I'll
was not in a
restate it.
law firm with you any longer after February 14, 2020, and that is correct.
We were not in the same law firm.
Yes.
Thank you. I apologize for misstating your experience. For some reason, I thought you worked up in North Carolina for 10 years. Let me make sure I've got it right. You got out of law school. You worked for a year as a clerk for a federal judge in North Carolina.
That's right.
And a federal clerk judgeship is a prestigious position, I believe, don't you?
It's a job a lot of people want out of law school. It's an incredible experience, and
Good on your resume, too.
I was still talking, and it was, the best boss I ever had.
Well, don't tell the other judge that, because you were with Judge Jones for 2.5 years.
That's what I mean for both of them. They were the best bosses.
So I was wrong about 10 years in North Carolina. I apologize.
That's right.
All of the discussions you had when you came to work at Wood, Hernacki, and Evans, a lot of law firms. Your initial discussions were with Catherine Hernacki and Stacey Evans, true?
I can't testify to that one, true or not, because I don't recall.
So you're not in a position to deny it if I say that that's true?
Not at all.
So when you came with Wood, Hernacki, and Evans, which was a partnership, have you seen the partnership agreement that was in writing between Catherine and Stacey and me? And I should say me, my PC.
I have like a very vague recollection of seeing it, but I could not tell you what was on it.
And you were hired as an associate for Wood, Hernacki, and Evans.
Yeah, we had an interview
You and I
there as well.
Yeah.
And then you all offered me a job to come work with you three.
My recollection is and see if you remember this. My recollection is that Catherine and Stacey wanted an associate. They did the interviewing for the associates. They liked you, and they came and recommended you and set up a meeting between you and me to see if I would agree. Does that sound familiar?
I thought I just had one interview. I remember having an interview with you, Stacy, and Catherine.
Could have been one time, but
Yeah, I think it was like in and around the time you got an order. I think you got an order in green. I have like a memory of that coming in.
An order in what?
Maybe like you got an order in green in and around that
Talking
time.
about
Something
my
was going.
client, Jeff Green?
Yeah, something was going on in the green case that I seem to remember when we had that interview.
Did you ever work on Jeff's cases?
Oh yeah, I remember there was the time when so I wrote much of the appellate brief.
Excuse me.
Yes.
I don't have a lot of time.
Okay, no, go ahead.
Did you work on any Jeff Green cases, yes or no?
Oh, yes.
And were you paid a split of any hours that you billed?
I think you paid me a bonus in that case when it settled.
So you didn't work on it?
No, I said I worked on it, and I wrote much of the appellate brief. I did depositions myself in that case, much of the discovery. I did a lot of work. There was a time when I was going to argue before the Court of Appeals because you were sick, so you sent me down there to argue on your behalf.
And that was an hourly client?
There may have been a change. This is where you're at the end, in and around the time that the case was going to resolve. That part I'm getting a little fuzzy on.
I had more than one case for Jeff.
I'm talking about what was then St. Pete and then turned into Tampa Bay Times, that one.
You recognize that Jeff Green, at the time I represented him, was worth $3.3 billion.
I know he was a billionaire. I can't tell you what level of billionaire.
Who hired me because of a dispute he had with a newspaper in Florida when he had run for, I believe, the Senate. Or
right, he had a dispute with the St. Petersburg Times and the Miami Herald. And he hired you because you were a really good defamation attorney.
Did you know anybody at the time that was better?
You know,
Listen, I'm sure there's always somebody better.
yeah, no,
I'm not-
I thought you were,
Say I was,
He's withdrawing the question.
Okay.
He's asking the
yeah,
next
but when you say I was a really good, did you know anybody that you had ever seen that was better?
I think that your oral advocacy skills were better than the other First Amendment attorneys I've seen. I don't think your writing skills were as strong as some of the others. And I think maybe your deposition skills were better than any of the other First Amendment attorneys I saw.
Jonathan, I'd been practicing law 4 decades when you started working at Wood, Hernacki and Evans. Senior partners don't write initial drafts of briefs. They hire people like you to do it, right? And then I used to look at them and you remember this. I'd say, give me a draft and then I'll woodize it. Remember that?
Yeah.
So you never saw my initial writing skills because that's not what I was doing, given the number of years of experience I had. That was what I was hiring people like you and Taylor to do, right?
No, that's incorrect.
How is that incorrect?
Well, there was a lot of parts of that question. And so I'm talking about the part that I'm saying, I agree with you that oftentimes a lot of senior partners don't write their own briefs.
I didn't.
Certainly, I don't think you ever wrote a brief. We wrote a lot of them at the firm, but the entire time I was at the firm, you never wrote a brief. But the thing, if I can continue answering,
Please
the
do.
thing that I was saying that I didn't agree with is that I didn't have an opportunity to see your writing because you did make edits, like you said you would woodize.
Woodize.
And, that was one of the things about being a judicial law clerk. I got to see hundreds and hundreds and hundreds of briefs and read them in those years through the court. So I got to see a lot of legal writing. I thought your edits sometimes were good. Sometimes I didn't think they were the best legal writing. And so that's where that came from. I think you're a great oral advocate, like better than any of the other ones. I think you're better than any of the other ones at depositions.
That's enough.
Okay.
Don't compliment me too much.
I'm just here to answer your questions.
When you came to work with Wood, Hernacki and Evans, remind me real quick, what was the date? May of 2012?
No, it would have been like August or September. It would have been, I think it's actually maybe August 24th or something like that. It was like the last week of August of 2012, I think.
All right, well, August 2012.
That's what's kind of coming to mind.
And then you've talked about the tragic fall you had while rock climbing on an indoor rock climbing facility in North Atlanta in September of 2015.
That's right.
And after you suffered that fall, I visited you at the hospital, did I not?
You did. You visited me at the hospital.
More than one time.
You did, more than one time.
And I also took it upon myself to speak with attorney Tommy Malone and Adam Malone to ask them if they would look at your case about the rope and what happened to see if you had a potential lawsuit. I did that for you, didn't I?
You did.
I'd known Tommy Malone since 1977. Tommy
is that a
Tommy and his son
question?
are very successful lawyers.
Objection, Your Honor, he's testifying again.
Strike that. Let me move on.
All right.
I took it upon myself to see if I could get you any help with respect to a lawyer, to see if you had a claim.
You did.
Unfortunately, they didn't believe you did, so that's the best I could do. Did you ever hire a lawyer did you make any efforts yourself to get a lawyer, or once Malone spoke, that was over?
I had a lawyer look at the rope and it was determined that it was my fault. My rope had degraded, and so I didn't hire a lawyer.
You have, among other things that have upset you, sometimes the point of tears, is the idea that people online or in some posts may have said you filed a frivolous lawsuit. And I believe that you were a fraud. That upset you.
No, that's false because you said tears had to do with.
Strike the tears
With
part.
the,
Let me restate.
no, can I you said,
Well,
oh, I'm sorry.
I'll withdraw it.
Okay, sure.
Do you have anything that you've got in all this mass of materials where I ever publicly stated that you were a fraud?
I seem to remember you saying fraudulent lawsuit by WGW, Jonathan Grunberg. And so as I understand that statement to be, you're accusing me of being a fraud.
And it hurt you to the point of tears.
Oh, no, that's still not what hurt me to the, so I think you're maybe referencing my, if I could finish, you're referencing my testimony here today. What hurt me to the point of tears was that you posted a picture of my 5-year-old daughter with bubbles on her, and that I felt guilty myself because I put that on my Instagram account, and then you or one of your minions took it off that account and put it up on there to trigger the people who follow you to say terrible things. And I'm looking at my wife and I feel bad that I put my daughter in that position. That's what gave me tears, Mr. Wood.
I don't know. I stepped out. So you posted a picture of your daughter on Instagram, and you believe and I think I did. Somebody posted it some months later on television.
You posted it you posted it years, I think like years later, maybe like a year later, to your Telegram Linwood Speaks Truth channel, and then reposted it to your Telegram Reply to Linwood Speaks Truth channel.
But you posted it first of your own child, didn't you?
That's why I said I felt guilty that that something that was so beautiful and sweet and wonderful that I put to share with people that I knew. And I didn't think about Linwood is going to go to my Instagram page and take this thing of my child and put it on to Telegram. That I feel bad to this day about that.
You put your picture of your child on the internet. Don't you know that there are all kinds of people that can see it, including potential sexual perverts and deviants? You know enough about the internet to know that, don't you?
Oh, I've learned a lot about the internet, particularly in this case, and perverts and deviants. And I certainly know that there are people in this world, including you, who will take a picture from my Instagram that I was just trying to share with my circle. But as I said, I didn't think about making it private, and then you took advantage of it. So yes, I am aware that people will exploit images of my child now in that way because of what you did.
You didn't. How long have you been on Instagram?
I think it's 2012 or 13.
And how long have you been on Facebook?
Facebook longer. Facebook I did first.
So 10 years experience on both?
No, longer experience.
20 years on Facebook?
No, I probably got, or it might be, I probably got on Facebook around like 2007 or something. So maybe about 18 years there. And I guess like 13 years on Instagram. My Facebook is pretty well locked down. I didn't do that, unfortunately, to my Instagram. I didn't know it wasn't locked down. No one had ever gone and violated my children like that until you did it, Mr. Wood.
Jonathan, how in the world do you say I violated your child by reposting without comment a picture that you had yourself posted online publicly to the world?
Because
you abuse your child?
Oh, I certainly did not abuse my child.
Why
The
wasn't your
violation,
posting
can I
abusive?
finish my answer,
He
please?
can answer it. You've asked him if he's abused his child. and
So
he's
I
answering that.
certainly didn't abuse my child. And I didn't even say that you abused my child. I said you violated my child. And the way that I think that you violated not just my daughter, but my son, because he also posted pictures of my son.
That
Like
you
he
had put up-
posted a picture of my son and daughter arm in arm when we were on vacation together. And then his minions commented that this is part of some sort of sex trafficking ring. And
All
to
right,
put,
so let's get another question. So we stay within the bounds of the questions.
You made a reference to Sandmann. And you said us four. You're talking about me, you, Taylor, and Nicole.
Yeah,
Us four did the work, right?
that's, us four did the work, and I said that probably about 90% of the work in our firm came from Nicole, Taylor, and myself, and then you probably did 10%, and you did, I wasn't there, I was working on Musk, I guess, when you did the second hearing. I guess you did a great job on that hearing.
Thank you. I thought I did a good enough job to convince the judge to reverse himself. But be that as it may, so you had us four, right?
That's right.
Did you just give no credit for the work that Todd McMurtry and his associates did on the case? Or do you think you did it all, us four?
Oh, I don't know why you said that. I certainly don't think I did it all. I was talking about what was being done in our firm, but definitely Todd McMurtry's firm did some work too. They weren't doing the original. So Taylor and I drafted pretty much every single one of the retraction demands and the preservation demands that I can recall for that first like couple of months. We drafted the complaints and we wrote the response to a motion to dismiss, and then maybe a second response, like Kyle might have taken one of our briefs and like worked on it to turn it into a response. But the vast majority of the written work, to my recollection for Sandmann, was coming out of Linwood PC.
You were doing what you were hired to do. You weren't hired to, at least, you weren't bringing any business into this firm. Can you name the clients you ever brought into this firm that made Linwood PC a thin dime?
Sure. Shin-Ki Yu, Sam Hoffner. I don't know if there were other ones. Those two come to mind. There may have been more, but but if your point is that the vast majority of the money made in that firm were because of clients that Linwood brought in, 100%. You were the big name who brought in the big clients.
So if you could only eat what you killed, you would have starved to death, wouldn't you? Financially.
No, because I think what you're talking about maybe the happy camper. And so the happy camper.
The happy camper. I know the
Can
memo.
I answer?
Well, no, listen to the question asked.
Okay.
Answer only the question.
The question is simple.
Yeah.
In fact, let's just get it right. That memo was not about a happy camper lawyer. That memo was that I was unhappy because y'all were not pulling your share of the weight financially.
Your Honor, he's testifying again.
Isn't that what that
disagree.
unhappy camper memo said?
So the unhappy camper memo said that you were unhappy because you felt like we needed to make additional sacrifices for you. I guess you may have felt that we were not pulling our own weight, notwithstanding the fact that we basically did all the work in the firm. And in and around that time, you were virtually gone from the firm like most of the week. At that point in your life, you were spending a lot of time outside of the firm rather than in the office.
Absolutely 1,000% my right to do so. True?
100%, but you're asking me about why you were a happy camper or not, and I'm letting And you were asking about what we were doing at the time. And so we were doing the work. Mr. Wood was playing a lot of rounds of golf and hanging out with some people outside of Ellenwood PC.
A lot of rounds of golf I was playing and paying for G. Taylor Wilson to.
Well,
Oh.
maybe, maybe not. Depends on how the
Say
phrase ends.
I was out playing a lot of rounds of golf. You knew that many times, not only was I out of the office playing rounds of golf, but I was out with Taylor Wilson paying for him to play rounds of golf out of the office. You knew that, didn't you?
You certainly took, oh, I definitely knew. He definitely took Taylor to play golf with him.
You didn't play golf.
I did not play golf. I don't have I get too frustrated, I think.
Well, you can ask me if I play golf and I'll say, well, not for my score and not for my swing.
You know, I'm a perfectionist, Lynn. It would
You
drive
are.
me
You're
crazy.
You're a detail guy.
I'm a detail guy.
In fact, you wanted to be a plaintiff's lawyer, right?
Right.
And that's why you wanted to work with me.
Yeah, you were
And-
one of the top, well, you asked the question,
Yeah, that's why, one of the reasons you wanted to work with me.
right? Because you were one of the best plaintiffs lawyers in this town, in the state.
And I had a sterling reputation in Georgia and in many other states where I had practiced. You knew that, didn't you?
I knew that you had I don't know what you mean by sterling
An
reputation.
impeccable reputation.
I don't know. So the reason that I'm saying that is you had a reputation for being
All right,
a bold.
Mr. Wood, I just want to make sure you want to confine that question, or you want to continue answering that?
No, let's just let it.
All right.
It doesn't matter. My reputation is what my reputation is. Or was. How do you think I felt when you and Nicole and Taylor started publicly branding me a fraud?
Objection, Your Honor, calls for speculation.
Well, I also don't know if that's, you're going to have to tie that into the facts at hand, or
They've
the
talked
issues at
about
hand.
how harmed they were and how bad they felt because I said they had filed a fraudulent complaint, which he said, which meant I was calling him a fraud. I simply asked, did you ever stop and
Okay, all
consider?
right, I think this goes to specific intent to harm. All right, you can proceed.
Did you ever stop to consider how I would feel when the three of y'all went out and repeatedly and publicly called me a fraud?
I'm sure you didn't feel good to have the complaint filed against you. No one feels good to be sued. I've never in my experience seen someone experience joy from being sued. So I'm sure you were upset.
Are you aware? Don't know if your lawyer did this or y'all did this.
Objection, Your Honor.
I haven't heard the
Oh,
the
Your
question
Honor.
yet.
On this issue, Your Honor, please.
Well, I don't even know what he's about to say, but yeah, sure, that you can approach.
Let me withdraw it. Maybe she can stay there. I just want to find out if you ever
This
made
is-
any.
Yes.
I want to find out if you
If
ever.
you can just approach, Mr. Wood, I've paused your time. It's okay. I just need to hear what this issue is.
I am not. That's crazy. I'm not about to do that. I was gonna ask if they.
Oh.
All right, the objection's withdrawn. Defense may proceed.
Thank you, Your Honor. Mr. Grunberg, my question is simple. Did you or Taylor or Nicole, other than your firsthand knowledge, to the extent you had some, did you ever do any research before you filed this lawsuit against me to find out if I had ever been sued before in my professional career?
If we could pause, Mr. Wood, I think we've got a request for a short break from the jury. All right, so
Have the feeling.
whenever the light's on, we'll resume.
Could we take
This will be a type 5.
type trial?
All right, Mr. Grunberg, if you need to step down, you can, but let's be back in here 3:40 at the latest.
Oh, it's okay, so. Okay. I was worried that probably got away. I have no idea, but hopefully I need about 4. I've been looking. I've been like that? No, Monday's my, this was my day of Monday, usually on Wednesday.
That's I'm going here too. How long ago was it fast? Come on, to the
What day you got work on?
Well, I already did know that.
You did your mandatory?
I did, well, not days. I did one for Smuggler's like 2 weeks ago. And then that don't count, baby.
Yes,
You
it
gotta
do.
do your, oh, no, me and him just, me and him switched. So he's like, no, mine is June 21st.
Next day is August 30th. I'm volunteering to go on the 18th, but my day ain't until like this month. Yeah, my day ain't like till the 26th, but guess what? 26th is on Monday, so I got. Yeah, I realized it was on the Monday, so I got to place. Hey, how you doing, sir? How you doing? All right? Beat, right? Yeah, I didn't squeeze. Yeah, we mean, he was there. He was at the beach at the jail. Intake had 200 people. They couldn't even send them upstairs. They, look, one cell in intake, it had about 35 or 40 people. You gonna take them off?
And now we know what this.
Gotta work on it.
We gotta confirm. That took me a second. I'm a very Porsche race player. Anymore, but no, because I don't know if that was you and the people in the gallery. I mean,
What do you think? Wait, he came out. I walked back in.
I missed it. Sometimes I'm not watching this. Yes, 17. Yeah. 73.
Yeah, this is probably up there, because I see 4 pens up here, they can't be 4.
Sure. I'm a pill.
Right. You know, I do it very.
Pick up things and then
It's
I
5 of us.
set them down places.
I said, right there on the hill. I said, by the time we. I'm gonna turn this through. They gonna let me go yesterday to Nashville. Wait. I'm saying I didn't because. What is this? No, front.
Yeah.
So they asked me, what about when two includes your shoe? I said, very short. What you mean? That's true. You just go back on. This is kick. Took it to metal. DSP hand up to the metal. I can say 35 days. It was in the my days. I don't know what
So really, you probably only have 6 to 6.5 hours a day. And so, you know, there's really only 25 hours of trial time on this outside for arguers. Two for openings, 4 for closings.
Get Drew and then back. It's been like 5 minutes.
We don't. 35 cents in the home.
What's that? Did it?
Like a couple minutes, 30 seconds, couple seconds ahead.
Yeah, isn't that crazy for how much we spent on those? About every month or two, it gets slowly. I can mess with it here. It gives me something to do.
Yeah.
Actually, the atomic clock says it's 20-second mark right now. So it's only, it's 30 seconds. No, it's 30 seconds fast. Yeah. And our phones are on that metric.
Oh, listen, God says do your best. Let's say leave the consequences in. That's right. That the number on Burby's. No, the first mark was about 24. It's in theirs, I mean.
Say what? Yeah.
I think they did the
And there we go. All right, they're ready.
Does you still play the cello? You were
I
very
do.
good.
I do, but only if you can, only when there's a
What?
gig. If you got a gig for me, I'll give it, you know.
All right, tomorrow night at 8 o'clock.
What you paying?
Whatever you want.
That's not a question you asked.
Let me take that back. Up to a point.
All right, where's the JQC? Get him over here. Just get it over with.
Yeah.
The jury's ready. We can proceed without Mr. Beal.
Okay.
All right. When I come in here on Monday, totally clawed to death, my dogs go crazy when I leave them and come home. I've shed a lot of blood.
That's why I don't understand the expression.
Huh?
I don't understand the expression. I don't treat my dogs. Thank you, Deputy Scott. Everyone, please be seated. Defense may resume.
Thank you, Your Honor. Hello again, Jonathan.
I'm sorry?
Said hello again.
Hello.
I think before we took the break that I was asking you about one of the reasons you wanted to work with me was that you were interested in learning how to be a plaintiff's lawyer.
Not that I was interested in learning how to be a plaintiff's lawyer, but I was interested in being a plaintiff's lawyer.
We got to learn how to be one before you can be one, right?
There's definitely a learning process, but it's that I wanted to be a plaintiff's lawyer. Sure.
So if you walk out trying to become a plaintiff's lawyer and you don't know what you're doing, you're going to lose your, you know what, quick. Because it's a tough business.
I think that applies to the law.
So you were looking for experience.
I was looking to join a firm that had a plaintiff's practice, that I could be a part of the team and work on great cases and do the kind of like complex civil litigation work that I was seeing in the court, and I was getting to kind of like write about in the court and stuff like that. So that was, and I saw that you were doing complex plaintiffs work.
My question was, and I think you were looking for experience.
No, I was looking for a job
Well,
as a plaintiff's.
But
I,
you
I
were-
was looking for a job as a plaintiff's lawyer, and
And
your firm had really, you were doing great plaintiff's cases.
You could have gone out on your own and learned from the ground up, couldn't you?
That would have probably been foolish because I didn't have clients. But you did. You had a firm. Most people don't go out and go straight from clerkship to practice alone if you don't have to. Most people go in and practice with other people, particularly when you're a young attorney, which I was when I joined you. So you go and you work with more experienced attorneys.
And you also, I believe, would tell us you were looking for mentorship, somebody to help you develop your thinking, your skills in terms of how to analyze plaintiff's cases. True?
I definitely always appreciate having a mentor. And so if anyone in the firm was there to mentor me, I take that with open arms.
Who was the most experienced mentor in the firm?
The most experienced lawyer in the firm was you. All three of you brought different things to me in terms of mentorship. I think, interestingly enough, maybe Catherine sometimes was the more active mentor to me than other people in the firm.
Do you remember how many times you and I would sit around and talk and I kept saying to you, Jonathan, you're going about it backwards. You're trying to tear down this case before, as a plaintiff's lawyer, you've built it. In other words, I would tell you, as a plaintiff's lawyer, you've got to build the bridge first. Do you remember me telling you that?
That is one of the things you would say to me when we would talk about how we would approach a case. You had this build a bridge approach to it.
And then once you built the bridge, then you would look to see where the bridge could be attacked to fortify it, right?
I don't remember you ever having a discussion with me about that part. You just had this kind of mantra that you would say you got to build a bridge.
And I told you that I questioned your approach because it seemed like when I would give you a factual situation that you would go out and try to figure out where the case could be attacked. When I was trying to get you to first realize you got to build the bridge and then analyze how the bridge can be attacked. Do you remember that?
You definitely have said build the bridge to me a lot. And I definitely had a different approach in how I analyze cases than Lynn did. I actually generally thought it was a strength because if everyone on the team thinks the same way, you're probably going to have a team that doesn't figure it all out. And so the way that I approach a problem is a different way where I look for the weaknesses often enough, particularly when we're doing a lot of, you'd use me a lot to do like responses to motions to dismiss or motions for summary judgment. So I would pick apart the other side's arguments. Yeah.
I thought I always said, well, you're good at kind of telling us where the weak spots are because you were a detail guy, right?
Yeah. So when I came in, that's exactly right. That's a lot of the work that I did was more on that pick apart stuff. And as I developed into a lawyer, then I gained more skills.
You remember sometime, not, I guess, that long after you came to work at Wood, Hernacki and Evans, that I would say something that you were from Chile, and you would quickly correct me and say, I'm from it's Chile. Remember that?
Sort of. It's just that
and then
it's sort of.
And then you.
I think it's all right.
They brought this up.
That's fine.
And then you would look over and go, I'm a Chilean Jew. And we would laugh. Do you remember that?
I don't know if I have a recollection of laughing about being a Chilean Jew. It just doesn't ring a bell.
Well, if I recall it, You don't have the recollection to dispute what I'm saying, do you?
I have the recollection of not recalling it, so that is a way to dispute what you're saying. Like, I don't remember that happening. So
Look at Exhibit 207, your exhibit.
Exhibit 2 of,
207.
oh, 207, I'm sorry. Okay, I'm there.
Before I ask this question, there would be some occasions, very rare and usually very short, where we would talk about politics in the office, right?
There were occasions, not very rare and not very short, where we talk about politics. So I don't think that's right. I think it was
Oh,
often
okay.
and it was lengthy.
And we were 100 apart, weren't we?
No. Well, what time
Like
period?
Trump, you were a Trump
What,
fan?
I'm just trying to figure out the time period.
the
When I
last-
joined
since-
the firm in 2012, you had voted for Obama, and I think you voted for Obama again in
I voted for?
2012.
Yeah,
That's not relevant.
let's stay
He-
focused
Knew
on
that
the
in
question.
2016 that I was a supporter of Donald Trump.
Yeah, by 2016, we were on polar opposites of the political spectrum. It's just that we weren't when I started the firm.
And we
When I
remained
started with the firm.
at polar opposites for the rest of the time that we worked under the same roof,
Certainly.
because simply stated, it's okay. You hate Donald Trump, don't you, politically?
Objection, Your Honor, relevance.
I think it's going to the state of feeling between the witness and a party. So
Oh yeah,
overruled.
I really strongly dislike Donald Trump. I have no problem saying that.
Just as I have no problem saying that I strongly support him.
Of course.
It's your right to dislike him, even to the point of hating him.
It is my right to dislike Donald Trump. That's true.
Just like it is my right in this country to support him. People have political differences, right?
Yeah, people have I agree people have political differences and people have rights to support politicians.
And people have different faiths. We allow that in our country, don't we?
We do.
You are is it an Orthodox Jew?
No.
Give me do you remember the time I was on the phone with you and we talked at length and you gave me essentially a detailed biblical description, or at least from the Old Testament, about certain figures back in terms of the Jewish community. Remember that? I remember writing it
I
out loud.
remember a conversation. It's just your recollection of it is different because I think you're trying to talk about a time we discussed like Orthodox Jews, conservative Jews, Reform Jews.
That's it.
None of that's in the Old Testament. That's a different kind of structure that's been put around Judaism as it's developed through the millennia.
I misspoke about it being in the Bible. So what is your faith?
Objection, Your Honor, relevance 403.
I mean, how would you describe?
I mean, I think we have covered that. I don't know where this is headed. I mean, he's already,
Making allegations about me being an anti-Semite. I'm simply asking him, how would you describe your Jewish faith? Where do you fall in? You said you're not Orthodox. What are you?
all right, so objections overruled.
I am Jewish and I am a member of a Reform temple.
One last question on that point, because I remember you telling me this. Based on your faith, you do not believe that Jesus Christ was the.
Objection, Your
Okay.
Honor.
This is the last question.
Even if it is though, I don't see how this is playing into the issues at hand.
Significant difference.
Objection, Your Honor. This is gonna be
You know,
testifying here
I'm not gonna be able to finish today at this pace.
Well, if you want to lay your basis for it, I can't
Just
conceive
like
how
I
this
showed
relates.
a difference between Jonathan and I on politics.
Objection, Your Honor.
Okay.
He's testifying now.
I
I'm talking
understand.
to the court.
I know, and I can.
And I have
I'll
the
find that
right to
line.
show a difference in.
All right, I think
of
you've already
religion.
established that we don't go into nuances of religion. You've established you have
I'm
different
not going,
faiths.
if we're going to go into the nuances of my faith, we'd be here. I talked as long as you'd let me talk.
And we'll stop it right there. So I think we've established your point, and to the extent the jury finds that we have.
May I do it this way? And I think this is consistent with what I've testified to.
We'll see.
Or you allowed me.
All right.
I've made it clear I'm a follower of Jesus Christ. And the only question I want to ask him is, are you a follower of Jesus Christ? Which would establish either we're on the
He's
same
already
page
established he has
or
a
there's a
different religion.
difference.
I'm happy to
there's-
answer.
there's
the
too
question.
He's happy to answer the question.
I know, and first of all, let's stop. Everyone's going to stop, and we're going to stop interrupting each other. All right, and that includes largely you, Mr. Wood. Okay, so
It's always me.
only with the interruption, it mostly is. All right, at this point, you've established he has a different religion. You have a different religion. I think the point has been made to the extent there is one, and now we can move on to the next point or question. Okay.
He just offered to answer. That's all I'm saying.
I know, but even if he did, I'm not allowing it. So we're moving forward.
All right. Thank you, Judge. Now, you don't ever remember me when we'd have some pretty heated, I guess, maybe one way. We would have some contentious debates about politics and law.
100%.
Do you ever remember me getting to the point laughing at you and saying, Jonathan, you're just a damn Chilean Jew? And we would laugh. Do you remember that?
Definitely not. And I definitely don't remember how that would have stuck out in my mind if somehow we were having a conversation about politics and it ended up with a statement that I'm just a damn Chilean Jew and laughter. That would stick out in my mind. I would remember that. I don't remember that ever happening.
I do, but that's the
Okay,
difference.
Mr. Wood,
I'm sorry.
that's going to be, I'm not going to give you another warning because that was testimony. And we've warned you repeatedly about that. Or excuse me, I have. So you can
But-
continue.
Do you ever remember me saying sometimes in our discussions, Jonathan, I think you're a damn communist?
That one I wouldn't doubt that you would say
Okay.
something like that. Sure.
You wouldn't doubt that because you could see the difference in our political views where I might believe that you were a damn communist, right?
Yeah, like you believed in things politically that I found really abhorrent and offensive.
What?
Like you were pro putting like the
Yeah,
whole
let's just
pol-
stop it there.
can-
I'm just going to say that question is beyond.
Are you
You've established
from-
the differences.
Because you've been on Telegram and with Nicole and I don't know who else. Y'all keep up pretty strongly over the last 5 years on Telegram, don't you?
There's a period where I really did. I've tried for my own kind of sanity to pay less attention to it for the last year.
So you had 4 years where you're paying attention.
Yeah.
Nicole's still's paying attention.
Yeah, and I don't want to mislead you. I still see when things pop up, it gets shared with me, but I try to not view your Telegram regularly because it hurts me emotionally.
It hurts you emotionally?
That's right.
Do you follow me on Truth Social?
No, I definitely don't do that.
I'm not on any other social media platforms. So I just say, if somebody says they're Lynn Wood on Facebook, that's not true. And you may have seen fake accounts, have you?
I know you were on Facebook and we were friends. And actually I went to go check this 2 days ago. I was like, oh my God, am I still friends with Lynn on Facebook? In case you were going to do a thing again where you take a picture of my children. And you were,
Your Honor, I would ask to strike that.
And
Well,
we were
let's
still
just stop
friends.
there. Let's just stop there.
Yeah.
He asked if you on to Facebook. He says the jury will recall his answer. Let's go to the next question.
I haven't been on Facebook.
Well, now you're giving testimony, so Mr. Wood, let's just ask the next
I
question.
tell you that I have not been on Facebook since 2014. Do you have any factual basis to dispute the truth of that statement?
I think something you had said in this court yourself, you said something like you hadn't been in Facebook for 20 years, so the math doesn't line up.
Well, it's been a long time. I think the last time I was
Okay,
on-
Mr. Wood, hey, we've talked about this.
July 24?
Yeah.
D7.
No, I need it from the plaintiff's number.
106.
Thank you very much. You only told me that, Drew, because you had the wrong book. Where'd you have a book?
Got it right here.
Right here in front of me. Would you turn to Plaintiff's Exhibit 106?
Yes.
Plaintiff's Exhibit 106. You recognize that's the letter dated July 24th, 2020, delivered via email from Christopher Marquardt to your attorney, Andrew Bill.
I do.
Dear Drew, if you'll follow with me. I hope you and your family remain safe and well in these pandemic days. Have I read that correctly?
You have.
The settlement agreement between our respective clients provides that LLWPC shall pay to WGW a portion of its fees earned in 3 settled cases, Carboni versus CNN, Lindsay versus Clear Zone, and Sandmann versus CNN, and 2 other pending cases, Sandmann versus Washington Post and Sandmann versus NBC Universal. Have I read that correctly?
You have.
The fee splits for these cases require client consent in order to comply with Georgia Rule of Professional Conduct 1.5E. Have I read that correctly?
You have.
LLWPC has therefore requested that each of the clients in question provide their consent to the fee splits. Have I read that correctly?
Yes, indeed.
The clients in the Carboni and Lindsay cases have consented, but we have just learned that the client in the Sandmann cases, Nicholas Sandmann, who is now 18 years old, has declined to consent and indicated he will only approve payment of a quantum merit fee to WGW. Have I read that correctly?
You have.
Accordingly, please provide LLWPC with documentation of the services rendered by WGW in the 3 Sandmann cases, including contemporaneous time records, and a proposed fee based on the total hours worked so that it may be presented to Nicholas Sandmann for his review and approval. Or if you prefer, you may send the information to Todd McMurtry, who also represents Nicholas Sandmann and has been the primary point of contact on this issue. Have I read that correctly?
Yes.
Next paragraph. Without client consent, the fee splits pertaining to the Sandmann cases in the settlement agreement are void. Have I read that correctly?
You have.
Do you have any idea of when Joey Burby and/or Chris Marquardt first informed me about the existence and applicability of Rule 1.5?
I don't have an idea of that in the sense, I get to explain, that I don't think that happened, but instead you informed them of the existence of 1.5 because you reviewed that per the testimony of Todd McMurtry with Todd McMurtry in February of 2020, before you ever hired your lawyers at Alston and Bird. You came up with, to commit your fraud, you came up with the kind of nonsense theory that Rule 1.5 could apply to us, despite the fact that we were partners of your firm, and that 1.5 doesn't apply when the work is done by partners, by people who are associated with the firm.
So let me make sure that I'm clear on this, since Mr. Burby and Mr. Marquardt will be here Monday, we hope to get to them. It is your testimony that Lynn Wood sought to have Joey Burby and Chris Marquardt assert a 1.5 claim to avoid paying WGW.
Yes, it's my testimony that you retained Alston and Bird in order to assert this, false defense of 1.5E based on a series, or really, it's like a total lack of information that you gave them. You basically manipulated the information that you provide to your lawyers. You told them basically nothing about what our actual relationship was with you. So you could then try and get the lawyers to whom you ended up ultimately paying something like, or being charged like $1 million, to then give you a nonsense argument that Rule 1.5E applied. And by the way, once the lawyers found out additional facts, they still didn't have it all, but after this letter, when your lawyers found out additional facts via our complaint, they then told you that under the only.
It's sounding like closing arguments at this point. Everyone's going to be able to, but you're asking these questions. And
I'm not asking for an argument.
Well, but you're still asking him for inferences from evidence that he had nothing to do to create. So let's just move on.
So Jonathan. Listen carefully for me to this question.
Okay.
You've heard the testimony on prior occasions of Chris Marquardt and Joey Burger, right?
No, that's not right.
You're not aware of their testimony?
I'm aware of their testimony. I heard the testimony of Joey. I wasn't there to hear the testimony of Chris, and I haven't read all of Chris's testimony, but I'm aware that Chris testified.
Have you looked at the legal opinion letters they gave me?
I have.
You understand it was their opinion as expressed in the document.
If they're going to be here to testify to that opinion, then we'll hear about it. But otherwise.
He's testifying to something that they claims they said, and it goes against what he's read that they've said.
Yeah. And
right to impeach him on his own cross.
To that extent.
Let's move on. I don't want to belabor this point. You know where I want to go. To Motley. Do you think, from your knowledge of this case, do you think that Joey Burby is dishonest?
So I think that Joey Burby has asserted positions in this case, based on my knowledge of this case, that were dishonest in how they portrayed the facts and how they portrayed the law, including in the briefing that they submitted, or pleadings as we call it, but briefing that they submitted to this court.
Do you likewise believe that Christopher Marquardt of Alston and Bird, based on his involvement before their firm withdrew, do you think Christopher Marquardt was dishonest?
It's the same thing. There were positions that were asserted in this case by them that were not true statements of the law or the facts. So they are dishonest statements of the law and the facts in this case. So that's one example of it.
And you believed, and I assume still do, but strike that. Did you conclude at some point in time that Todd McMurtry of Kentucky was dishonest?
Yeah, I concluded at one point in time that Todd McMurtry was your co-conspirator in committing fraud, and fraud's a dishonest act.
So Todd was not only in your mind dishonest, you reached an opinion that you thought Todd McMurtry was a fraud.
I reached the conclusion that Todd McMurtry was your co-conspirator in fraud, and fraud is a dishonest act.
Now, there's Andrew Bill and Mylinda and Michael Glossop. Michael was a paralegal, not a lawyer, but other than Lynn Wood, because you think I'm dishonest in fraud, right?
I think you are dishonest, and I think you committed fraud.
So you've got Lynn Wood, Joey Burby, Chris Marquardt, Todd McMurtry. Dishonest lawyers, what you're saying, right?
I think that they have all asserted dishonest positions with regard to the facts and the law. And I think in terms of what Joey and Chris did, you certainly misled them intensely. And so whatever they did is in a different caliber than what you did. What you did and what you've done and what I see you do, you have a level of dishonesty that outshines them by far.
Well, your opinion is noted. Now, Andrew Bill and Linda Brown, right? They're the only other two lawyers that have been involved in this case besides you and Nicole and Taylor.
That's not true.
What I'm talking about for you.
Oh, okay. Yeah, for us, I think they're the only lawyers that have been involved on our side of the V.
And you're going to quickly tell this jury that they are honest, right?
Oh, yeah.
Ibrahim Reyes represented me for a period of time. Did you think Ibrahim Reyes was a dishonest?
He's no longer part of the case.
Sorry?
He's no longer part of the case, so.
No, just like Joey Burby and them were not part of my case.
But he's not going to be on the witness list. Really, this whole line of testimony is, he's not supposed to be commenting on the credibility.
Excuse me. Excuse me,
right?
approach the bench.
Sure. All right, members of the jury, again, disregarding the comment from the court, their defense may proceed.
Thank you, Your Honor. Did you ever receive and review the February? What day?
Well, 2021.
No date specific? You don't know it? Okay. Did you ever review the sworn affidavit in February of 2021, dated in February of 2021, of Nicholas Sandmann?
I have.
Do you know who prepared that affidavit?
I think your lawyers did, the ones at Alston and Bird that you paid $1 million to.
And I'm sorry?
The ones at Alston and Bird that you paid $1 million to.
What does that mean? I've had to pay a lot more than that to defend this case, young man. Now, let me go back and ask my question. The question was,
Mr. Wood.
Well, it was unfair for him to sit there and say that about paying him $1 million.
Yeah,
I
I understand. All right, let's take a second. Let's take a second. Witness will listen to the question asked and answer only the question asked. And Mr. Wood, again, I think we've reached that point where no more warnings from here on out, no personal commentary. All right, keep going.
So you got me again, Judge. I've lost my train of thought. So you were aware that it was drafted by Joey Burby and or Chris Marquardt?
That's right.
And you were aware that it was reviewed in its entirety by Todd McMurtry?
I believe that's true.
Before his client, Nicholas Sandmann, signed it under oath. You're aware of that, aren't you?
Yeah, I believe that chain of events is correct.
And you are aware that in that affidavit, Nicholas Sandmann stated that he had met with independent counsel.
Objection, Your Honor,
Yeah.
hearsay.
All right, it hasn't been tendered yet, hasn't been admitted. And he said he's aware of it, so whatever inferences you want to draw from that, once it is admitted, I think you can connect that in
I'll have to come
closing.
back to it Monday then, because I thought, Your Honor, it ruled it was admissible.
Well, but it hasn't been admitted yet, and so I don't see how this witness could comment on it.
Can I question about it subject to it being admitted? I mean, I don't know what you want me to do. I can't admit, I don't think I can admit evidence during their portion.
Well,
of the
I mean,
case.
you raise a fair point there. The point being, again, we're getting back to why do we need a witness just to summarize every exhibit or issue that may come in? The inferences and conclusions to draw from them are for the jury.
Well, I think I've gotten what I need on that for the moment. I can
Okay,
get more if I need.
all right, we'll move on.
Look at plaintiff's exhibit 101. And I apologize, Judge, for leaning like this.
That's
backwards.
fine.
I'm there.
Get there, Judge. Not that far from 73. You got it in front of you, Jonathan?
I do.
This is an email from Chris Marquardt to Andrew Bill, copied to Joey Burby, right?
That's what it appears to be.
Andrew Bill being your attorney,
Sure.
dated March the 13th of 2020.
Yes.
Drew, thanks for getting on the phone with me last evening and for following up with a revised settlement proposal from your clients. I'm pleased to see the productive movement from both sides, and I hope that we are now at the point to cut a final deal. Have I read that correctly?
You have.
To that end, attached is a final settlement term sheet. It has been approved by our client. Lynn has instructed us to make clear that this is a non-negotiable last and final settlement offer. Have I read that correctly?
You have.
You and I have been doing this. You and I have both been doing this for a long time. Have I read that correctly?
You have.
I note, for what it's worth, that I do not agree to characterize an offer in that way unless it is 100% certain that my client will not negotiate any additional terms. That is where we are in this dispute. Have I read that correctly?
Yes.
Lynn also instructed us to make clear that this offer will expire at 5:00 p.m. tomorrow, Saturday, March 14th, if not accepted by your clients by that time. To accept the offer, please have each of your clients sign on the spaces at the bottom of the term sheet. If we have a deal, Joey and I will prepare a formal settlement agreement for your review to be signed by the parties no later than close of business on Wednesday, March 18th. Have I read that correctly?
You have.
We believe that this is a very fair and reasonable resolution of the client's various issues. We hope your clients view it the same way. Lynn asked me to mention again that he truly wants each of your clients to be successful, and that once this agreement is signed and the parties move forward, he fully intends to keep them high on his list for referrals of future matters. Have I read that correctly?
You have.
And then after this agreement was signed on March the 17th of 2020, you will agree that I referred at or in excess of 40 different cases to you or a member of Wade, Grunberg, and Wilson.
I can't agree to that.
How many would you say I referred?
Actual cases,
I've
I
got
think,
the-
ended up being like two
No,
actual cases.
I'm not
maybe.
asking you about cases you
Okay.
took. You gotta look at a case, decide if you want to take it. I sent 40 cases to you for your firm to look at to see if you wanted to take them or not.
So you sent probably, I won't dispute that the number might be in and around 40 of prospective clients, people who we were kind of taking that work off your plate of having to respond to these people. And you sent them to us to look at these prospective clients to see if it's a matter we would get involved in.
To give you an opportunity to take a case that I wasn't going to take.
That I can't agree with. I don't think you did it to give us an opportunity to take a case you weren't going to take. I agree that I don't think you were going to take the cases because you didn't have lawyers in your firm, so you didn't have the wherewithal to take the cases. But I don't think you sent them to us as an opportunity to take the case. I think you sent them to us as part of your fraud, including because while he was sending that to us, he was paying a lot of money to his lawyers at Alston and Bird to try and undo the settlement agreement. And so if your interest was in trying to help us, I don't understand why you were going to these lawyers at Alston and Bird trying to find a way to tear up the settlement agreement. Instead, if you really thought that 1.5.
Yeah, we're a little bit
I've asked you
afield
to
from the
cut this off.
question. So let's get it back here. Mr. Wood, are you going to ask a question?
Thank you, Judge.
You direct?
I'm just trying to answer the opportunity. I didn't
Your
see
Honor,
it as an
please.
opportunity.
And Mr. Grunberg?
Yeah.
Let's keep it to the question.
I want him to get in the same situation I'm in.
All right.
Let me see the McMurtry depositions.
Okay.
Page 60.
It's 60.
Yeah, you got it. You recall Mr. McMurtry's testimony that your lawyer put into evidence earlier today?
I think I recall a good part of it.
Could y'all have the transcript where he could look? Is it, if it's a number that, I wanted to look at one page,
Which page? We only have the.
59 and 60. And if I can approach, I can just pull it up here and let him look at it. May I approach him?
Hand him if you got an excerpt.
Jonathan?
Yes.
You'll start at page 59 at line 25 and read down through page 60 at line 2.
Okay. So answer.
Well, are you supposed to read it to himself or you having him?
Read out loud.
Okay. Well,
Yeah.
Your Honor, is there a question before we just read something into the
There will
record?
be, I'm asking, this is totally
Do we know what the
proper
question is?
cross-examination. You read that statement out loud and then I want to answer the question.
That's,
I would read it, but he doesn't have a copy to look on to make sure I read it correct.
I don't think he could just be just the same way he couldn't be quoting another witness right now as testimony.
I'm quoting evidence now. This is an evidence, just like the letter from Burby.
I think it's considered the testimony just like any other witness. Maybe we start with the question and then we'll go back.
Right, you have another
Words.
copy where you could look and I can read it.
well, if you're
Let me
gonna
read
read
it.
it
I
for
do.
your question, then we have the same problem.
I've got another one somewhere.
You got another copy?
Yeah, I did. Smaller print, but I have it.
I'll take a smaller one. Right. You got it?
I do.
All right. Give that back, John. I don't mind. You can bring it back to you, John.
All right, page 60 right
Yeah,
there.
yeah.
Good to know.
Thank you.
So back to page 59, line 25. Answer. This is
Objection,
Yeah.
Your Honor.
Yeah, Mr. Wood, I think procedurally, I don't see how this would be. It's not his testimony or how it could be impeaching him.
no.
And it was testimony at the time it was received. They've now heard it. And I think that's how it has to, we wouldn't replay somebody else's testimony.
Not asking that.
If you want to explain the process, you can approach, but
In the break, I proffered for the record, so I'm protected. Let me ask a different way.
Okay.
You knew that Todd McMurtry wanted to insist all of the parties in going to mediation and resolving the dispute. You knew that, didn't
What time frame are you talking about?
you? Before we got into a lawsuit.
Yeah, I wouldn't be surprised if he wanted everyone to go to mediation and assist in resolving the dispute. That makes sense. It was in his interest to try and get things back good with you so you can continue working on the Sandmann cases.
It would have been in everybody's best interest, including mine and Mr. McMurtry's and others, to be able to resolve the dispute by mediation and not 5 years of litigation. Would you agree?
Objection, Your Honor.
It would
I
have,
think it goes to,
No
it goes,
evidence that-
sure.
well, it goes to the attorney's fees issue, I think.
Yeah, it would have been,
And state of mind.
Yeah.
yeah, it would have been in everyone's best interest if you honored the February 17th settlement agreement that you violated. And then I guess Todd McMurtry subsequently wanted to see if there's a way that he could resolve things and help the parties mediate. It would have been in your best interest to simply pay the money you owed us. Then it would have been in it would have been in everybody's best interest for you to do that and for you to honor the May 17th, 2020 agreement and simply honor it rather than make us litigate against you for 5 years to try and get what you've promised to us multiple times.
Well, it would not have been in my best interest if I disregarded my attorney's advice.
Objection, Your Honor.
I just
Calls for
can't.
facts,
I
not
can't answer.
evidence.
Let me
Calls
get
for
the question out,
speculation.
Judge, please.
Yeah, I mean, a second. I think I know where the question's going. I think as currently phrased, I don't think that's a proper question. Maybe you can rephrase it or a different subject.
Would you be concerned if you were to knowingly violate a state bar ethical rule?
I would be concerned if I were to knowingly violate a state bar ethical rule, certainly.
Because you could be subject to anything from being disbarred down to the low part of being publicly reprimanded and everything in between.
Right, there's different levels of discipline that you could receive for violating a state bar rule.
So it's important for a lawyer who is ethical to follow the state bar ethical rules. True?
Definitely.
You disregard them and make up your own mind, you're not going to follow them, you can get in a lot of trouble, can't you?
Definitely.
I didn't take that back. Take it off your plate.
Okay, thank you. You recognize that after Stacy Godfrey Evans was no longer part of the partnership of Wood, Hernacki, and Evans, when that disbanded,
Yes.
that Stacy Evans remained physically in my office under an office sharing arrangement. True?
That's true.
And that at least on 2 occasions, well, you may not know that, but that Stacy worked on the DeVita case with me
Yes.
under an agreement that we had reached before we disbanded Hernacki, Wood, Hernacki, and Evans.
Yes.
And did I live up to that agreement to your knowledge with her?
You did, to my knowledge.
You made reference to the fact that DeVita case resulted in a $450 million payment, right?
I testified that it resulted in more than that. There was the $450 million settlement and then additional money that was paid because of attorney's fees that were working the case.
Allowed under law.
Correct.
But you do know that literally 82% of that went to the taxpayer because it was a key tam case where the plaintiffs were in effect representing the United States government.
No, you got that math wrong. The relators,
78, I'm
the
sorry.
relators share, no, it's not the right math. The relator share was like, I think maybe 28 to 28.5.
You're right. The
And
related
so-
share was 28%.
Right. And so the math on that, it's getting later in the day, but I think I could give you the math on that, which would have been like 72% went to the United States government.
So clearly it was not a situation where anybody got a $450+ million fee.
Oh, definitely not.
The winner in the DeVita case was the taxpayer.
I don't agree with that. The winner in the DeVita case was the taxpayer, the clients, the firms involved, and I even, like, you gave me a $200,000 bonus on it. But the fee arrangement on it was for the lawyers was certainly as a percentage of the 28% relator share, and then getting that additional money for the individual attorney's fees submitted.
Your coming to work at Linwood PC had nothing to do with your being entitled to a dime from the DeVita case, did it?
Oh yeah, I had no entitlement until you made an agreement with me to give me a bonus on the DeVita case. But you're right. When I came to work with you, I had no entitlement to a fee on the DeVita case.
And what happened is you came to me and told me that you were going to leave Linwood PC and go to work for James Butler.
That's right.
And I expressed concerns because I know Jim Butler.
That's right.
I didn't know that you and Jim would be compatible. But I said, well, if you're going to go, you're going to go. But I came back and I offered you an increase in salary and I offered you a $200,000 bonus in DeVita if you would stay with me, right?
That's correct.
And you did.
I did. And I made the way that you compensated me at that time, it was certainly, and I knew what I was getting into. There was not as much compensation on the front end as I could have gotten and say I would have gotten had I gone and worked for Jim Butler's firm or taken the job at Kirkland and Ellis that was offered to me. But there would maybe be like more back-end compensation.
Well, those are questions you had. You made up your mind where you wanted to work.
Yeah.
Nobody put a gun to your head, did they?
Definitely not.
So did you know that Stacey Evans, SGE LLC?
I think it's different. It's SG Evans Law or SG. It's definitely SG Evans in there.
What did I say?
You said SG.
Evans.
Yeah. Go ahead.
Well, let's just say Stacey Evans LLC that was sharing space with me after she left Wood, Hernacki, and Evans, okay?
Okay.
Were you aware that she had her own operating account when she was sharing office space with me?
I would not be surprised if she had her own operating account and IOLTA account when she left Wood, Hernacki, Evans, and my understanding is that she did, because she was no longer practicing law with Linwood PC. She was off of the Linwood PC, or she actually never practiced law with Linwood PC other than as a partner in Wood, Hernacki, and Evans. But when she went out to do SG Evans Law, she wasn't on a website with you in the same firm. She wasn't on a full code Dropbox with you on the same firm. She didn't share firm letterhead. So she had a different account.
Pretty simple. This is taking up an inordinate amount of my time.
All right, again, just listen to the question and only the question answered.
Mr. Grunberg, when the time came that I told you and Taylor that you needed to form your own professional corporations or LLCs, when you described it as became a non-equity partner, May of
Yes.
2018.
Which you described as well.
Did you, at that time, you and Taylor open up your own law firm operating checking accounts?
No,
So
we didn't have a
how,
law, let me explain. We didn't have a law firm. So we opened up an account for our LLC, but it wasn't a law firm account because we didn't have a law firm. We practiced in Linwood PC. That was the law firm.
Jonathan, so you opened up an account for Jonathan D. Grunberg LLC?
Correct. It's just not a law firm.
Did your incorporation papers not indicate that you were going to be using that corporation for the practice of law?
I don't know.
You don't know what your incorporation papers said?
Well, it's not incorporation. I think it's a different term, but yeah, I'm not sure.
Did you use the operating account for any monies other than payments related to your own personal or legal expenses and deposits of monies paid under a 1099? In other words, did you intermingle personal monies, or was it always deposits from 1099s from L. Linwood and checks written to pay, in effect, legal expenses that you had incurred on your own behalf?
Objection, Your Honor, what this witness did personally is not relevant to any claim at issuance.
Whether how he's handling income and with the LLC.
He raised it about Stacey Evans. And it's just,
The question
I
was
think
specifically whether or not he commingled personal funds with his LLC. And this isn't a fraudulent transfer case.
I'm happy to answer it.
Okay.
He-
Mr. Wood.
yeah, I mean, all he was talking about, they weren't practicing law under those names. I was trying to make the point that all the monies that went in or out of your operating account, or Taylor's or Nicole's, were monies paid to your LLCs by L. Linwood PC, or your own expenses if you want to go out and buy a computer.
That's a different question than he
That's,
goes.
you're talking about intermingling. So as phrased,
I don't think they intermingled. I was trying to cut to the chase and make it simple.
okay,
Now I do it the hard way, but I think I've got it.
all right.
That's all he's getting at. If he's only asking if they only received payment from Ellen Wood PC, they paid their individual expenses through their LLCs, that's fine. That has nothing to do with co-mingling money.
Okay, all right.
Well, I was
You
gonna
can
say,
continue.
they didn't commingle.
Right.
Yeah, I wasn't
All
accusing them of commingling. I was trying
All
to find out.
Jonathan, you can answer that question.
I don't know. Is there a question pending?
Yeah, why don't we wait and get a new one?
Two fingers. There you go.
You stated on your direct examination that many lawyers in Atlanta were paid under 1099s. Remember testifying to that?
Yeah.
Name three.
So my understanding, well, I got three right here. And then my understanding is that there is a practice in Georgia and really in the law at large, that this is the way that people handle their payments with law firms, when they receive income and they're not simply a W-2 employee from a law firm, particularly when it's an of counsel type of relationship where the law firm doesn't want to have the person on the books as an employee. So if you look, oh, go ahead. I think
My question is pretty simple.
so I think if you go, like, say to the law firm, I'm pretty sure Stacy had that arrangement when she worked at.
No, wait.
Oh, go ahead.
Let's go back.
Okay.
You said many lawyers were paid in Atlanta under 1099s. Name 3 lawyers other than Wade, Grunberg, and Wilson that you know of by name that receive their compensation pursuant to a 1099 independent contractor form. Their names, please.
I don't go asking people their arrangements. I just know that this is a common practice in the law that you can do, that you do a 1099 arrangement for people, particularly when they're of counsel, say, or even a non-equity partner like we were of a firm. We looked
I think you've answered the question. It can't be an indefinite response.
So I can't give you 3 names off the top of my head.
One name,
Right.
right?
I don't go talking to people
The
about
answer is
that.
you cannot give me
That's right.
a one name.
That's right.
From the time that you started as an associate with L. Lynn Wood, PC, up until the time when the relationship ended and you were not in my firm in any shape, form, or fashion, and that was, I believe, February the 14th, right? 2020.
February 14 is where we stopped
when it
being
ended.
partners in your firm.
Right. So from the beginning of your work to February the 14th of 2020, did you ever review or receive an L. Lynn Wood PC partnership return?
Oh, no.
Did you ever even receive or review an L. Lynn Wood PC profit and loss statement?
No, and I don't think I would, I don't think I would have well,
Did you
I
ever
just,
review it?
Ellenwood PC was a corporation. I don't think they would issue a partnership return because that would be for a partnership.
Let me restate it.
Okay.
You're right.
I mean.
I'm wrong. I can make a mistake. So did you ever review an L. Lynn Wood PC corporate tax return?
No.
Did you ever review an L. Lynn Wood PC profit and loss statement?
That one, I don't think so.
You didn't review any of the financial information of L. Lynn Wood PC because you didn't have a right to access that information. Would you agree?
That I don't necessarily agree with in terms of, I think you probably had it on the Dropbox, but I think what you're trying to say is, was I an owner of Ellen Wood PC? Absolutely not. Ellen Wood PC was a professional corporation. I did not own Ellen Wood PC, a professional corporation. I was a non-equity partner, as you said in the Happy Camper email.
All right, thank you. So your first hire as an associate received a W-2.
Yes.
Then you received, after I believe May of 2018, you received a 1099 independent contractor form, right?
I don't think it's called a 1099 independent contractor form, and it's for, and 1099s are for much more than independent contractors.
I don't want to fight over that. I know what a 1099 is.
Okay.
Do you?
Yeah, I understand it to be an income tax document that's given to people that you've given money to.
That are not employees, but are independent contractors, or not salaried employees or hourly employees, but are independent contractors hired on a case-by-case basis. You know that.
No, that I don't know.
Then let's move on.
Okay.
I'm not here to educate you on independent contractors.
All right, Mr. Wood, that's the last one. Okay, you can come back on recross, sir.
Sir, please. I'm doing the best I can. You have had to stop him from talking. It's just a casual comment. Let me finish up today.
No more commentary, Mr. Wood. Keep going.
Did you or Jonathan or Taylor? Did you or Jonathan? Did you, Jonathan, or Taylor ever enter into a written partnership agreement with L. Linwood PC?
Definitely not, because L. Linwood PC was a professional corporation. But we entered, if you're talking about like partnership, like ownership, we entered into an agreement with you to be non-equity partners of L. Linwood PC. Are you talking about ownership of L. Linwood PC, or I just want to make sure I understand what you're
My
saying?
question is, did you or Taylor ever enter into a written partnership agreement with L. Linwood PC? That's all I want to know, yes or no?
Yeah, I think the agreement was oral, like you communicated to us how we would be your partners. Like you said, we would be non-equity partners of L. Linwood PC. You put it in an email, the Happy Camper email, and we entered into an agreement with you to become non-equity partners of L. Linwood PC.
Jonathan,
Yes.
you know what an agreement is in writing. My question is simple. Did you or Taylor ever enter into a written agreement with L. Linwood PC that was a partnership agreement in writing? Yes or no?
We entered into, we did in part because, as you may remember from practicing, that there are agreements that are part oral and part written. People, when they have informal relationships of trust with one
He
another,
asked if it was a written agreement, so that's what you have to answer.
it's a partially written agreement.
Okay, and you
So
can go
you
from
entered
there.
into a partially written partnership agreement with L. Linwood PC?
So I agreed with Ellen Wood PC that I would, yes, I agree with Ellen Wood PC that I would be a non-equity partner. And part of my understanding is of how I would be your non-equity partner was put down in writing in the Happy Camper email. And then subsequently, I think you did it via email, which became a written part of the agreement that we had with you to be non-equity,
Let me see if I can
where
make it
you
quicker.
shifted the compensation to us to be 80% instead of 70%, even when we didn't bring in the
Is there
cases.
an agreement that you actually signed?
Oh, yeah, no, we didn't sign something.
All right. You didn't sign anything. Taylor didn't sign anything.
That's right.
Could we take a little moment or two? Let me talk to the court about where we are.
Sure. All right, counsel.
No,
Want to do that in?
May I, while we're doing that, may I use,
You need to use it right now?
or if he's ready to go, then I'm good to go.
Well, let me, Mr. Wood, let me just see what you have to share. Are you asking?
Oh, no, I was asking if you want to take a minute. I was going to try to look over and give you some idea of how much time I might need, if any, to get finished up so we could hopefully get it done today.
I can wait, Your Honor, it's fine.
Okay,
I just
we're
will
just
take-
holding in
maybe
place,
take
is what you're
5.
telling me.
I'm fine, we'll
Take
wait.
5 and let me look at it.
Okay, all right. I think we're just waiting in place. Yes.
The plaintiffs, all right.
So, yeah.
It's 102.
Now I want y'all to be sure. And silent say thank you to all the model three. Because I'm getting ready to finish this, so I can get on the road to see him.
Okay, Mr. Wood.
Thank you, Your Honor.
Okay, any further cross-examination?
Here
it is.
John, yes, Your Honor.
Okay,
Very briefly.
all right. You can proceed.
Jonathan, would you look at plaintiff's exhibit 102?
I got it.
This is a copy of the settlement agreement executed by you and Taylor and Nicole and me for the L. Linwood PC and L. Linwood, right?
That's right.
If you will look at page 5, under paragraph 6. You with me?
Yep.
Under the paragraph C, if you'll read with me.
Yes.
Entire agreement. This agreement contains the entire agreement between the parties relating to the subject matter hereof, integrates all the terms and conditions mentioned or incidental to this agreement, and supersedes all prior negotiations or writings. No modification or waiver of any provisions of this agreement shall be valid unless in writing and signed by all parties hereto. Have I read that correctly?
Yes.
And that was part of the agreement that you signed off on after consulting with your attorney, true?
That's correct.
Your Honor, that concludes my cross-examination of Mr. Grunberg. But I still have to, I'm not just walking away from it. I have obviously the right to call him as an opposite party for purposes of the defense case. Don't think I'll do it, but I have the right to, and I haven't made a decision. But subject to calling him as an opposite party for purposes of cross-examination during the defense, the defendant's case, that would conclude my cross-examination of him today after his direct examination. Thank you.
Okay, well, we'll circle back. There's one box I want to check about that, but first, Ms. Brown, you have a few minutes left?
Your Honor. Thinking I might need 5 minutes additional at most.
All right.
I'm gonna try to keep it as quick as possible.
You can proceed.
Jonathan, do you believe that WGW, that you guys owe anything on the L. Linwood PC lease payment?
On the what?
I don't,
And why not?
I'm sorry.
because
I just didn't hear.
Lynn violated, so that's the lease provision. He had a duty to go to the landlord and get the landlord to sign off on us being liable, having any responsibility for the lease. He specifically violated that agreement.
I think the moment has passed. We can get through this testimony. Let's continue.
He specifically violated that agreement. And actually, when the landlord was ready to agree to take us off and give us what's called a release, he had that struck out of his agreement with the landlord, like specifically violating what his obligation was under the settlement agreement. So I don't think we owe him that $285 anymore.
And you have Plaintiff's Exhibit 102, the March 17th settlement agreement. I believe in front of you, it was the last exhibit you guys were talking about.
That's right.
Okay, just going through these quickly. There's one case that $54,999.99 is owed to WGW on. Another case that there's $34,200 owed to WGW on. Another case that there's $843,750 owed to WGW on. And then in regards to the Sandmann versus the Washington Post case, I believe you testified that WGW is owed $101,000 on that based on the 10% that's listed in the March 17th agreement. Is that right?
Yeah, those are the funds that are owed under the settlement agreement to WGW.
And so when you add that up, it's $1,033,950. Is that right, to the best of your knowledge?
That sounds right.
And did you ever discover what happened with the money in the Lindsay and the Carboni case, which are two of the cases that WGW is owed money on?
Yeah, Lynn took that money for himself before he even signed the settlement agreement with us, promising to take the money.
And
Promising to give us the money.
And what about the money owed to you guys on the Sandmann cases? Did you ever discover what happened to that money?
Same thing, like pretty close in time to when it hit his account. He just took all that money out of the account and took it for himself instead of leaving it there to pay us.
And in this March 17th settlement agreement, the defendants agreed specifically that the three of you guys worked as lawyers of Ellenwood PC on cases since 2018, right?
That's right.
And the firm of WWGW, was that a different firm or was that just a rebranding?
WWGW, that thing that happened at the end of January 2020 was just a rebranding. There was no new entity created. We were just rebranding.
And do you recall whether the daily report announcement that you guys were talking about on cross-examination, if it stated that this was a rebranding of Ellenwood PC?
I believe so.
And have you ever posted any disparaging statements about Defendant Wood on social media?
Never.
And do you monitor Defendant Wood's Telegram? This is my last question, Your Honor. Do you monitor Defendant Wood's Telegram for the purposes of this lawsuit and the non-disparagement provision?
Yes, for the purposes of this lawsuit, the non-disparagement provision and, just basically
I apologize.
learning other facts as well about this relevant to this lawsuit, not just non-disparagement.
And Drew reminded me that I had one more question. I apologize. Do you know of a state bar rule that requires a lawyer to hold in escrow funds when there is a dispute as to fees?
Yes, there is a state bar rule that if you're having a dispute as to fees like Mr. Wood had with us, you're supposed to hold those funds in your trust account, not just push those funds over to your personal account.
Yeah, I don't think we need to go down and open up this road, so.
I object to it, it's irrelevant.
All right.
Nothing further than that.
Did right then the pre-vote is going to be subject to cross-examination.
We'll take it up. We don't need this witness to talk about it then. We can take it up.
Thank you, Your Honor.
Later in the
Nothing
trial.
further.
Any recross on those points, Mr. Wood?
No, sir, Your Honor. Thank you, Mr. Grunberg.
All right. Members of the jury, thank you for your attention this week. I know it's been a long week and we've covered a lot of ground, but from what I understand, I believe we still are on track to stick with that original time frame for the case to be in your hands at some point Wednesday. And so, although it may not feel like it at times, we are on track as best as I can tell. A lot will depend on what happens Monday and Tuesday. To that end, this weekend, don't discuss the case, including among anyone, including amongst yourselves. Don't do any research, and have a wonderful Mother's Day as well. See you back at 9 a.m.
Judge, 9 a.m.?
Yes, sir, but don't run for the door just yet. I just need a minute to wrap things up.
Oh, I'm sorry.
May I?
You can step down, Mr.
Thank you,
Grunberg.
Your Honor.
All right, for Monday morning, as I understand it, the plaintiffs are proceeding then to have the Sandmann deposition played, and that's it.
Deposition designations of the defendant,
Very short, Your Honor.
and that's real short. And then
Very
that's it.
Okay,
So he should have it by 9:30.
okay. To that extent, there was only one defendant's objection to the Sandmann designations. This was highlighted on page 3 of their objections, starting on page 16, essentially talking about whether Mr. Sandmann was aware of any testimony between his attorney, Mr. McMurtry, and Mr. Wood. And the answer, I think, was just that he was not aware of any. And I think the objection here was raised to speculation, but as he was the client, I think that that's not a improper question. There was no objection to privilege there, or if there was, he answered it. So basically the bottom line, the sole objection raised to the Sandmann designations by the defense, they're noted, they're preserved, but I don't see that as being improper testimony. As to the turning it around, I would ask the plaintiffs over the weekend, since we would turn over to the defense case here. Most of your objections are to the McMurtry designations. I don't know how many of these perhaps have been impacted by what has happened this week. So why don't you can come back and tell me what still needs.
Prove it down.
Yeah, well, to the extent they need to be. All right. And the only thing I was going to comment on, Mr. Wood, in terms of reserving to recall Mr. Grunberg, I think that would be your right, but you're going to have to. You say it's unlikely. Fair enough. But if that is something you decide to do, I'm going to need to hear that some new ground, something new has come up that you need to cover that you couldn't have covered today.
I think Your Honor has analyzed it correctly. I have the right to do it.
Yeah.
Chances of this something new, very, very, very remote.
Okay.
But
Well, we'll
I
just.
have to preserve the right.
All right. Well, I guess we can leave that there.
And I just to inform the court, we have obviously a motion for directed verdict at the close of their evidence. I don't think that'll be lengthy. Shouldn't be. And then right now I'm planning to get Joey Burby and Chris Marquardt up first because they've been waiting on call for 2 or 3 days, and I want to get them in and get them out.
How long is the Sandmann designation that you have?
30 minutes or less.
Okay. So I would give them a 9:30 kind of call time.
I think we did, but we'll make sure.
Yeah.
We've been working closely with them on time with their lawyer. And so we'll tell them 9:30 to 10 o'clock.
It may be closer to 10 with everything else if there's delayed and motions. And I'll just go ahead and put this out there when it comes to directed verdicts and motions by either party at the halfway point or at the end of it. Just because I understand that I can do this in civil cases, which is kind of nice, is that I can just defer judgment until after there's any verdict received. And so I've done that in every civil case so far. That's probably what I'll do here. And to the extent you can incorporate your arguments, say, all the issues that I raised in the motion for summary judgment filed on this date, if that's going to encapsulate all your possible arguments, perhaps you could do a 1-sentence motion.
That's not going to be the way the motion for directed verdict that we'll make is going to be based on very simple, undisputed evidence on one issue, and I don't think it's going to take long. And I think it would be one of those instances where the court would be proper and required to grant it at the conclusion of the plaintiff's case because they put up their case.
I certainly will consider it.
I don't think they proved their case on one essential element. We'll be shortened to the point.
All right.
If Your Honor wants to reserve it to the end,
All right. My point was just,
I'm not going to be long.
yeah, my point is just the practice I've seen of people essentially restating their entire motion for summary judgment motions may not be necessary.
Never seen me do that.
All right. Well, I haven't. Sorry.
Never do that.
Okay. With
Very
that,
much, Judge.
anything else on behalf of the plaintiffs?
Nothing.
All right.
The notice to produce that we served on the.
That's right.
defendants, we still haven't gotten any documents. And
Okay.
If we are successful, we're going to go right into phase 2 and they need to be.
Yeah, I've got them here. I haven't had a chance to get them. Part of my tax returns 1 year and it's lengthy. If the dogs will let me this weekend, I'm gonna look through it and I'll have it ready to produce them on
You believe you'd have that ready Monday morning?
I do.
Okay.
I'm assuming the dogs will cooperate and let me take that time to work. They may not.
Well, you can give us an update accordingly. All right. Anything else from the plaintiffs? Anything else on the defense? Seeing none, we're in recess 9 a.m. Monday morning.
Thank you, guys.
Take care.
Have a great weekend, you both.
You as well.
Have a good weekend. Sue, have a good weekend.
Good weekend.
New court reporter? New court reporter? Thank you.
I have a couple questions regarding spelling.